Hey Heather,
Hold on one second, Judge. Yeah,
do we have an interpreter for Mr. Baza?
I was not informed, and it does
Okay.
not say on the ROA. I don't think that he was supposed to have one.
Okay.
Yeah, when he
Yeah.
said hello, I kind of.
Yeah, I was trying to talk to him and it limited. But let's see if Josh Hadley can talk to him.
Um, okay, yeah. Um, yeah, she didn't say anything about it on
Okay.
the last hearing date.
Oh, he was here before?
Um,
For goodness sakes.
Marianne, I think she must have been told that he was in St. Clair County, but she didn't do anything. Remember, she did the,
Yeah.
yeah, so it's,
Yeah.
all right.
Hey, ladies,
Yes.
I just received a phone call about those two gentlemen that were sent in court.
Yeah.
I would advise to do those, and the reason being, if they don't accept them in the van,
Uh-huh.
the CTU drivers are not going to come back here right away.
Okay.
They got a list of who district courts, and they may not be back till this afternoon.
Okay, I understand. So it
Yeah,
wasn't
just
like
keep
they
that in
could turn
mind
around and
because
come back.
sometimes the CTU units, they say no, we're not taking them. They're not going to come right back here. They're going
Okay.
to finish their route and then they come back here.
Okay.
Okay,
Alrighty.
thank
Thanks.
you.
Good morning, Jacob.
Good morning.
Michelle,
Yeah.
you checked in Charlene Jones?
Yeah.
Okay, I'll put her in the.
She doesn't want to, no, she does not want to move, Heather. Leave her there.
Yeah, we don't need to talk. She just wants to observe.
Okay. And the Samsung is driving me nuts.
They refused to unmute. Oh, they're muted now.
Now maybe they'll talk to you. Good morning, Josh. Are you there, Josh? Good morning.
Yeah, I'm here. What's
Ju-
going on?
Not much. Just so you know, the person that's in St. Clair County Jail, he is on a ICE detainer. Just so you know. So if we're able to do as much as we can today, that would be best.
I don't.
He's in
Am
your
I
MIDC.
missing?
He's in your waiting
Oh,
room. Just so you know, you're the MIDC
I
attorney
see.
today, and we
I
have
see.
people coming in live and in person.
All right, so I'll just leave my computer pulled up today. So
Yes, please.
the MIDC waiting room is the only one I've got right now. Got it.
Yep.
Um, I don't have a prosecutor or any info on this at all.
The prosecutor is Mr. Lecky. So if you
Yep.
want to talk to Mr. Lecky,
Is he logged in?
yep,
Yeah,
he
I'm right
is.
here, but I can come. I'll walk over.
Oh, Jacob's here. I got it. Uh,
Michelle, what happened to Martell?
I never saw Martel. I was in that breakout room.
No, he jumped in earlier, even while you were here, and then he's gone. I thought you grabbed him.
Uh-uh. I never talked to him. No, I was thinking in my head I needed to talk to him. I have something else going on that.
Oh yeah, that other one.
Hmm. Good morning, Mr. Martin.
Hi, Michelle. Good morning.
How are you?
I am good. On the road. I
What-
do have starting a trial this morning. So just I got permission from Heather to appear by Zoom. My clients are Lazaire, Brandon Lazaire.
Do you they have him. Do you want to talk to him?
That would be great. Yes.
Can we put Lazier on?
Ask and ye shall receive.
Thank you.
Lazara.
Well, they call him Lazera. Which one is it, Carrie?
Oh,
Lazara.
besides Lazaire.
Yeah, they're bringing him right now.
Okay, my other client is Joshua Patton.
Yeah, I know about that one. We don't know if we're gonna get him. They didn't list him.
Got it. Yep, that's it. Just those
Okay.
two.
All right, I'll put you in a room.
Thank you.
You're welcome. Heather, drive me crazy.
What, Michelle?
Nothing. I was moving him. I'm like, where'd he go?
Heather, do we have the assistance of a Spanish interpreter?
No, we don't. We were not informed that he needed an interpreter.
Yeah, I don't think we're gonna be able to get to the arraignment without one. I asked the first
Okay.
thing off is, do we need an interpreter? And his answer is yeah.
Okay.
Sorry.
Oh, I'm sorry. Can someone make me a co-host? I think is what's called.
Yep, I thought I did earlier. I guess I did not.
No problem. Thank you.
You're welcome.
Heather,
Yep.
Crystal Medina reached out to me and asked me to cover Scott Cordell and a Danielle Jones. I see both of those on the docket, but I'm seeing in the breakout rooms another Michael McDaniel.
McDaniel, she's jumping on for. That's just an adjournment.
Got it. Okay.
Which other ones are you supposed to be covering for? I heard you say, I know Danielle, but
Got-
what's the other one?
Danielle Jones and Scott Cordell with a K.
And what time is he at?
I don't have a docket actually.
Oh,
Did
I'll
you
bring one
send me
too because I don't
one?
think yep, I don't think he's on. He's not on today's.
Who's not on today's?
Wait a minute, hold on.
Oh,
Sorry. How do you spell Cordell?
K-O-R-D-E-L.
Mm-hmm. We don't even have a Cordell in our system with that spelling.
Uh, I've got one on the docket that we've
You
got
just
out
said you
here.
don't have the docket, so you can't
They
say
have one.
that.
I don't have a copy of the docket in front of me. I wrote all these down on my yellow pad. What I'm saying is I don't have a copy of today's docket
Okay,
email.
I'll bring it to you, but we don't have anybody with that spelling unless it's something else. Hold on.
That's right here. I didn't see the first either.
You see her name, I saw her name next to. Okay, Cordell's the first name, I can't find
Scott
any.
Cordell.
Scott
Scott
Cordell.
Cordell. Yeah.
Okay, so.
Oh, she got it.
Not Cordell.
I think she's.
But she had-
Cordell's the first name, not last name. My bad.
Anastasia, are you one of the prosecutors or you're just helping Mohammed?
I'm just helping Muhammad.
Okay, thank you. I just want to make sure you weren't a special prosecutor. I mean, I'm sure you are, but
She's a very special prosecutor.
that's all right. Mr. Barlaskar, who are you
Yes,
here
good
on?
morning.
What time is the hearing for Ahmed?
8:30.
I don't see it. Let's check. What's Ahmed is the last name?
Yeah, I've got a case number.
Yep, that would be better.
Okay, it's 5, and I'm reading it off the
Yep.
notice of hearing. 5 S as in Sam 4494299.
Ahmed Tanver. Tanver is the last name. Okay. So you're here for Mr. Moomin?
Yes, he's my
Okay. All right. I will put you in the breakout room with the prosecutor.
Perfect. Thank you.
You're welcome.
Mr. Lucky,
Yes, hi.
do you see that you have two victims waiting?
Yeah, I put him in
Okay.
there.
No, I did. Oh, you moved them into a different one. I gotcha. Because they
Yeah, I
both
just
wanted to
moved them.
speak with you. Okay.
Yeah,
Because
thank you.
Miss Hernandez wants to speak with her husband to help
Wait a
him.
minute. Oh, hold on. Hold on. I have the YouTube in my ear talking at the same time. I'm calling multi-language right now for the Spanish interpreter.
Perfect.
Okay.
Thank you.
Josh, I'm giving the information to the Spanish interpreter place to get one on. And Mohammed, just so you know, you have somebody in your breakout room.
We're looking for him out here too. Oh, there he is. Heather, I just walked back in. I missed what I heard my name. I was trying to find Mohammed. What's going on?
I'm trying to get a hold of the interpreter in place now for them to send somebody.
Okay.
Thanks. Good morning, Miss Medina.
Good morning. How are you?
I am fine. Hold on real quick.
Yep.
All right. Crystal, this is Mr. McDaniel, correct?
Yes, it is. I think my assistant already filed an appearance. I don't know if it.
Yep, I got everything for you.
Thank you.
You just need an adjourned PCC?
Yes, I just need an adjourned PCC. He actually has another case set for preliminary exam in June. I don't know if that makes sense to, I don't know if that's possible. I don't know how the
I
docket.
cannot put it on, I can put it on that day. I cannot put it at that time,
Okay.
only because I can't add something to their exam docket.
No, of course. That makes sense. That makes sense. But if we put it for the same day, whatever
Yep.
docket it is, I guess I'll kind of know. Yeah, right.
Yep,
'Cause it
and then
might
that
be
gives you
one or the
time
other.
for you to work on what you needed to.
Gary, yep. I need to reach out to Gary. Thank you.
Yeah, okay. It's going to be June 4th.
Mm-hmm.
I can June 4th. Do you want me to put as late as 10:45 and because you need to be wait a minute, you're on that doc. Okay, do you want me to do it at 10:45 and you guys can be here at 10:45?
Yeah, because it would be in person, the adjourned PCC. It would be Judge Oakley again, correct?
Nope, it's going to be Judge Martin.
On
But
Zoom. Okay.
his exam is at 12:30. So
Yes,
he's going to have to be
perfect.
here anyway. So do you want that late or do you want
Yep.
earlier?
No, do 10:45. That's perfect, Heather. You are awesome. Thank you so
Okay,
much.
10:45. So Mr. McDaniel, did you hear that?
Yes, ma'am, I did.
Okay, Crystal, then I'm gonna throw you in the breakout room with more. And it didn't have anything to do with discovery, right? You just needed the adjourn to speak to
No.
Gary.
Yeah, either way I would need it, but either way, let me talk to Mohammed if I can. I meant to
Yep.
talk to him anyway. Thank
Yep,
you.
I'll throw you in.
Thanks a
Crystal,
lot.
are you gonna talk? Crystal, are you gonna talk to Muhammad about the other two that you got, or do you want me to just deal with those?
If you could handle those for me, this was quick. I have to get here to Lincoln Park to my cases here.
Okay.
Thank you. Hey, Heather, do I need to go
Yep.
on the record when we're done, or I'm all set when
No,
I
you're
speak
all
with
set. We're
Mohammed?
on record. It's adjourned PCC for June 4th at 10:45. Judge Martin, I'll send out notice.
All right, thanks a lot. And
Oh, sorry, I cut her off. Mr. McDaniel, you're all set.
Okay, thank you. And it's 10:45 in person, correct?
10:45 on Zoom, unless she wants you to be here in person, because you have to be in person anyways at noon.
Okay, so all right. So then
right.
you said you will send out paperwork and everything?
Yep.
All righty, I appreciate it. Have a great day.
Shalana, I'm going to put you in the breakout room with the defendant. And Josh, are you on? And let's see, where is Josh Hadley? Let me get a hold of Mr. Hadley, but I'll put you in the breakout room with the defendant.
Okay, thank you.
You're welcome. Let's see. MIDC. Pravanchi, I see you back there. Who's this on screen? Please.
Was it Lazarus?
Lazier.
Lazier?
Mr. Lazier.
Here's
Okay.
the council.
Thank you.
Yeah,
Waiting
I
for
got
counsel.
Griggs and Jones on deck.
All right, thanks. Hi, Mr. Barlaskar.
Hi again.
Hi, did you guys come to a resolution?
We did.
All right, and do you know what that is?
Impeding traffic, and I was going to ask the court if my client can have 30 days to pay.
I'll do it. Impede 180.
Okay.
And just let them know 30 days.
Perfect. Thank you.
Thank
And
you.
I have another question.
Sure.
Completely unrelated. I've got on a traffic ticket a motion for relief for judgment, which I haven't filed. Client's still kind of mulling it over. Are those held by in person or via Zoom?
Depends on the judge. Judge Oakley would handle it in person. The other judges would handle by Zoom. So it just depends on whose day it falls on, or whose docket it falls on.
Perfect. Thanks so much. Appreciate it.
You are welcome.
Have a great day.
Thanks, you too. Joe, if you have any adjournments, just bring them in here, please.
Okay. It's a ticket though.
Yeah, so if it's a ticket, Mohammed would have it.
Yeah, I got the ticket.
Okay, so you just bring it into me. There's no file.
Okay.
All right. Sorry if I missed anything. Mr. Martin?
Hi, yep, I'm here. Sorry.
Did you need to speak to Mr. Lazier or do you need to speak to Mohammed?
I already spoke with both of them, really.
Okay.
Yeah.
So what did you want to do?
Set exam dates and address bond.
Oh, okay. For that, I'll have to get the judge out there. But just so you know, the exams we're looking at either next week or June 11th.
I think next week, yeah, I plan to be in the building on, next week, the 7th.
Okay.
So yeah, let's do that.
All right. So we'll do exams on both of them May 7th at noon.
That's great.
All right. So let me let the judge know that we need to speak regarding bond.
Thank you.
Mr. King,
Yes.
excuse me. Just so you, do you need to speak to Mohammed on your
Yes.
cases?
Yes, I do.
Okay. And just so you know, one of them is being brought live for some reason. So it's going to be Mr. Ross Borough Wallace. When he gets here, we can put him on Zoom for you to speak to him. Okay.
Thank you.
I don't know if you're talking, but I'll throw
Yeah, I
you.
said thank you. I'm sorry.
Oh, it's okay. Okay. I'll put you in with Mr. Mohammed. Alex. I always get your name wrong, so I'm not going to say it. Mr. Ignatiev.
Okay. Hey, how's it going? Sorry.
Alrighty. What are you here for this early in the morning?
We got Mr. Lawrence Wells, but we're gonna waive his. He's set for a PCC at 10:30.
Oh, okay.
We just want to go ahead and waive.
Yep. Alrighty. So, I think he just jumped on. He's waiting for the clerk to speak to him.
Great.
And when he jumps back on, then I will let the judge know that you're ready to waive on that.
Okay. Thank you so much.
You are welcome.
Hi, Heather. I got a question when you have a second.
Sure. Yep. Start talking.
I think I talked to counsel about Christian Swovlin. We're just looking for a new date. Can we pick a new date or would you like us to talk with you?
Nope. Nope. We can pick a new date. Let's see. What time is she at? There she is. 9 o'clock. So Mr. Stammel is here?
Miss Stammel, but she's right
Miss
next to me. She's here.
Oh, because it says Jacob Stammel, but okay. I'm
Is the
sorry.
Is the 28th available?
Let me find my date. Yes, May 28th.
Okay. And then do you need a write-up from us?
Nope.
Okay.
I just have to remember to do it. But so May 28th, I have as early as 8:45 all the way to 10:15, and it will be by Zoom.
Okay, could we do 9 o'clock, please?
I have either 8:45 or 9:15.
Okay, 9:15 is fine.
9:15. That's going to be with Judge Martin, so it will be by Zoom, okay?
Okay, great.
And all right.
And do we need to put this on the record?
Nope, we're good. I can just come in and grab it.
Okay, thank you.
Thank you.
Thank you so much.
Mr. Martell, did you need a prosecutor or do you need to speak to your client?
May I speak to the prosecutor, the DV prosecutor, please?
Sure.
Thank you much.
Yeah.
Yep, I'll be in there.
Is Heather doing an adjournment? Did you give me that paperwork? If you give me that paperwork, I'll go with that adjournment. The attorney gave some.
The one that talking to you.
Other than that, we got none pre-approved.
I don't know, I mean, some like, well,
Thanks.
Did an attorney give you paperwork for an attorney?
they did not, no attorney has given me paperwork that I have done to adjournments.
Who's ready on Zoom?
Lazier,
L.A.
LA.
They did it Zoom.
We are gonna do the exam on the 7th, but he wants to talk to you about bond. The exam is not.
Are we ready on Staples? Your appearance, counsel.
Good morning, Your Honor. Paul Stavlin, appearing on behalf of Staples approach. Go get me.
Good morning. Go ahead, counsel.
Your Honor, I am to the prosecutor, judge, we resolve this matter. You should have a form in your file.
I do.
Ms. Staples is going to plead guilty to the offense of operating rules that impaired in exchange for prosecution to dismiss the original count. I've advised Staples what rights would be in regard to a trial. She's winning all those things.
That's all true? Okay. And you understand what the possible penalty is for the added charge? All right. Understanding all of that, you're pleading guilty freely and voluntarily?
Yes.
Counsel, would you voir dire?
Ms. Staples, on March 30th, 2024, were you operating one vehicle?
Yes.
And was it on I-94? Okay, that was in City of Climax, correct?
Correct.
And prior to driving, did you consume alcohol?
Yes.
And you had your ability because of alcohol, ability to operate a motor vehicle been impaired to the point where it was physical to another person.
Yes.
You satisfied, counsel? So am I. I'll accept the plea and dismiss both original count 1 and 2. She got priors?
No. I indicate to the court that Ms. Staples also has, I've had her evaluated by Raj Mehta, who's a social worker.
Good.
Who put her through a number of tests. And his conclusion, with respect to the case, judge, was that she appears to have no significant, no apparent problem in regard to drinking. And he concludes that her likelihood of reoffending is very low because of her family support, because of her, she also did complete with Mr. Mehta the level 1, what he calls level 1 high BAC.
Well, tell me about that.
So I just had this meeting and we talked about the
The level 1 thing?
yes,
Yeah. Yeah.
basically just talks about the importance of like.
Like an interview. Yeah. Yeah. So it was a online
It was via Zoom.
interview, probably long. Okay. Yeah. Okay. All right. So the reason I ask, counsel, is because the recommendation is for sobriety court, and if she doesn't have a prior, she's not eligible.
That's, I
Okay.
did talk to Mr. Muhammad about that, and you know, he was making that recommendation. I said, well, I don't know that she's.
Yeah. I think that's a parameter that he's been given from downtown, that if it's a high BAC and it's pled down,
Right.
that's a recommendation they make. What was our BAC?
Yeah.
That's all right. Take your time.
It was a 0.18.
Okay. All right. So here's what we're going to do. We're going to send you down to our probation department, set up a sentencing. Counsel, you can follow the file down and then you can have some input on when the sentencing date will be. They're also going to have you come back for an interview with one of our probation officers. Based on that interview, they're going to put together a report and recommendation to me for what they think sentence should be. Then the three of us will meet again. We'll talk about anything you want to talk about, and then I'll determine what the terms are. Understood? In the meantime, I'll continue your personal bond. Any questions? Counsel, we miss anything?
No, we didn't.
All right.
Thank you very much.
You're welcome. You too. Have a great day. All right, what do we got online?
Lazier,
Are we ready on Lazier? Why do I have so many names up there?
because there's just a lot of them. There's a lot of them, the APAs, a lot of them sick with advocates.
Yeah. Who's representing Lazier?
Terry Martin.
Mr. Martin, are you on that screen somewhere? Nope.
And Mr. Martel, are you ready?
We are. My apologies for the delay. We are ready.
Who's this?
We have Robert Gardner.
Martel, what's your client's name?
Robert Garner, Mr. Garner.
Robert Garner. Thank you. Put your official appearance on for Mr. Garner, please.
Thank you, Judge. Good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court, Edward Martel, P 85051, behalf of Robert Garner on all three matters. Mr. Garner, please state your full name for the record.
Robert Lee Rasan Gardner.
Good morning, sir. Go ahead, counsel. What do we got?
Judge, we have reached a resolution in this matter. I will turn it over to brother counsel to put the details on the record. My client has been fully advised of the offer and wishes to waive his trial rights at this time. Mr. Leckie, I will turn it over to you, please, and thank you.
Thank you.
Yes, good morning, Your Honor. Jacob Leckie appearing on behalf of the people. We
Okay, hold on. I'm getting really bad stat coming through somewhere.
Oh, sorry.
Mr. Leckie, mute for just a minute. Yeah, it's you. Okay,
You want me to
go
just
ahead.
come in, Judge?
Go ahead. See if it's still there.
How's it sound now?
Better. I don't know what you did, but it worked. Go ahead.
I don't either, Judge. Well, good morning, Your Honor. Yes, we have come to a resolution in this matter. If the defendant pleads guilty to file, all right, let me just make sure I have the right one. 250228, domestic violence in count 1. The people will dismiss the other two, so 0229 and 0151. If the defendant pleads guilty to 0228, the terms and conditions are as follows. The plea will be taken in pursuant to 7694A, 12 months probation, an alcohol and substance abuse assessment and any treatment necessary, batterers counseling. They are to have no firearms, no contact with the complaining witness, and that is all for a 12-month period, Judge.
Okay. And how do you feel about immediate sentencing versus a pre-sentence investigation?
I have no issue with immediate sentencing today, Judge.
Mr. Martel?
No objection to immediate sentencing, Judge Albert. It's my understanding that the prosecutor has no objection to no contest. That would be our humble request for considering potential civil liability.
Sure.
And in furtherance of this plea, Judge, as you are aware, my client did do 30 days inpatient in Oakdale, was successful and continues to maintain full and complete sobriety. So
That's awesome. Good for you, Mr. Garner. Give me just a minute, gentlemen. Hey, Joe, go see the prosecutor and get his plea form that's got all those terms on it, on this one. Mr. Leckie, I'm going to send the court officer in to grab that plea form that's got all those terms on it.
Sounds good, Judge. Thank you.
So I don't have to rely on my old memory.
I got you.
All right, Mr. Garner, have you discussed your rights with Mr. Martel?
Yes, Your Honor.
Do you understand the rights you have and the options those rights present to you?
Yes, Your Honor.
You understand the possible penalty for the charge of domestic violence?
Yes, Your Honor.
And understanding all of these things, are you pleading no contest to that charge today?
Yes, Your Honor.
Sir, you understand that when you say no contest, you're literally saying to me, Judge, I'm not fighting that charge. You understand that? You're not contesting, you're not fighting the charge against you.
Right.
Okay? If I can get a factual basis to accept the plea from somewhere other than your mouth, then I'll go forward and we'll do a sentencing. You understand that?
Yes, Your Honor.
All right. Gentlemen, where am I going to get my facts?
Your Honor, if it's all right with counsel, we can stipulate to the investigator's report attached to file 0228. Do you have?
I don't have an investigator's report. That's why I asked.
All right, I will provide one, and in the incidents, I'll provide one.
Okay. All right. And Mr. Martell, safe to assume that you have no objections to me looking at the incident report to get the facts I need.
No objection, Judge. So stipulated. Thank you.
Thank you. All right. And it looks like we've got another file coming up May 14th. Mr. Garner's got a date on for a 2025 drinking and driving offense. You know about that one, Mr. Garner?
Yes, Your Honor.
Okay. All right. Then I'm just waiting for paperwork so we can continue on this file.
Thank you, Judge.
Yes, Your Honor.
This, you didn't know, wanted to discuss it. You didn't want to sign it till today. The order for.
Discovery?
No. What?
We don't like Nolos. Nolos under 769.
Is it scheduled for today?
Yes. And they both agree on it.
Oh, they do?
Yeah. Because I just asked Ms. Stammel again, the attorney, and she said, yeah, we already discussed it. Everything's good. We're just waiting for the judge to sign.
Oh, is that supposed to tell me that they've stipulated?
Yes, they stipulated there.
I thought it was a signature on it.
Perfect. Thank you.
I don't think I said this for the record, but I am dismissing case ending in 0151 and 0229.
Thank you, Judge.
Thank you, Your Honor.
Mr. Martin, are you online yet? Where did Joe go?
Where'd Joe go?
Yeah, I sent you out there to get paperwork. Do you see a swirl?
Sorry, Judge, I'm working on the paperwork right now. Sorry.
Oh, okay. All right. You got anybody else ready for anything?
I'm not sure.
Your Honor, I represent Mr. Lawrence Wells, and we just want to waive his exam.
Yes. Thank you, Mr. Gottlieb.
And we got Wells online.
Yes, sir. Mr. Wells is here.
He's at 10:45.
Mr. Wells, can you hear me?
Mr. Wells, you have to take yourself off mute.
Hello?
Are you Mr. Wells?
Yes, sir.
Can you hear me?
Yes, I can hear you.
Do you have a camera?
Yes, I do, but it just got me on a black screen with a little.
All right. Counsel, do you recognize your client's voice?
I do, Your Honor. And
Are you okay going forward without a camera?
I am, Your Honor.
All right. Mr. Wells, have you discussed your rights and options with your attorney?
Yes, sir.
You understand those rights and the options they present?
Yes.
You understand the purpose for a preliminary exam?
Yes.
You understand if you waive that exam, this file will be sent downtown to the circuit court for your next court appearance?
Yes.
Understanding all of that, do you want to waive?
Yes.
Are you doing so freely and voluntarily?
Yes, sir.
All right. Counsel, are you satisfied with that this waiver has been knowingly and voluntarily waived?
Yes,
Or
Your Honor, I
made?
am.
All right.
Yes, sir.
So I'll waive and set the AOI date for 2 weeks down the road at 9 a.m.
Yes, sir. Thank you
Bond
very
will be
much.
continued, and I will wish you luck downtown, Mr. Wells.
All right. Thank you, Your Honor.
You're welcome, sir.
Mr. Wells, I will be in touch when I know who the judge is.
Okay.
And you can leave the meeting now.
Okay. Thank you. Have a good day.
Thank you.
Mr.
Thank you.
Henry, are you ready?
I can't hear.
Are you ready on Elder?
We can't hear you, Heather.
Oh, that's weird.
No, yes,
Mr. Hadley, are you ready on?
Mr. Buzzier, but
Is here.
Baiva.
Are you ready on Beza?
We are, Your Honor.
Start talking while I look for the file, please.
Thank you, Your Honor. Attorney Josh Hadley and the interpreter. I'm
here. I'm present.
There we go. Attorney Josh Hadley appearing on behalf of Mr. Elder Viza Lara with the assistance of an interpreter, Spanish language today.
Ma'am, what is your name?
Shalonda Heisley, Heisley.
Ms. Heisley, would you raise your right hand for me?
Yes.
Do you swear or affirm that you will accurately translate between Spanish and English and Spanish so that Mr. Viza Lara and the rest of us can discuss his matter today?
Yes, Your Honor.
Would you let him know what we just talked about?
Señor Elder Baiza Lara, este es el caso suyo. Estamos aquí presente con el juez y tiene aquí representándole abogado Josh Hadley y soy la intérprete Shalonda Heisley.
Okay, thank you.
Thank you, Ms. Heisley. Mr. Hadley, what do we got?
Your Honor, we're going to be asking for a brief adjournment to obtain discovery.
Entonces, señor Hadley, ¿qué vamos a hacer? Dice, su señoría, vamos a pedir un aplazamiento breve para hacer el descubrimiento.
That's fine. Yeah, 10 a.m.
How about next week, Mr. Hadley, 10 a.m.?
¿Qué es de la semana que viene, 10 a.m. de la mañana?
When next week, Your Honor?
¿Cuándo, su señoría?
Wednesday.
Wednesday?
Not if it's going to stay with me. And I don't know that that would be quite long enough to get.
So let's try it another way. When do you want to have this adjourned to? You said quick, and next week is quick. So you tell me pick a Wednesday, because we don't care what Wednesday.
Entonces aquí estamos pidiendo que usted escoja cualquier miércoles que necesita. Decía que quería algo breve. La semana que viene breve.
I don't think this matter can stay with me, Your Honor. I'm not going to be back. I'm not available for the next 4 Wednesdays after today.
All right. So how much time do you think we need for discovery so somebody from MIDC can handle it?
¿Cuánto tiempo necesita usted para el descubrimiento?
I'm sorry, Your Honor. I've got.
And he knows some.
Your Honor, let's keep it with me and set it for the 21st. No, let's set it for the 14th, Your Honor.
May 14th.
I'm sorry, Your Honor. He's actually got an immigration hearing on the 14th. Let's do the 21st.
Vamos a fijarlo para el 21 de mayo.
10 a.m. on the 21st of May.
10 de la mañana, 21 de mayo.
That will be on Zoom with Judge Patton, courtroom 3.
Entonces, por Zoom con juez Patton, cuarto número 3.
And Your Honor, that matter will stay with me if it's going to be on Zoom.
Okay. And I'm sorry, Miss Hain.
Si vamos a hacerlo por Zoom, su señoría, entonces el caso se puede quedar conmigo.
I will continue the personal bond that is on this file.
Y voy a continuar la fianza personal que está aquí en el archivo.
Sir, do you have any questions?
Señor, ¿tiene una pregunta? Señor Lara?
No, por el momento no. Gracias.
No, at this moment, no, thank you.
All right. Ms. Heisley, thank you for your help.
My pleasure. Have a good day. Adios.
Okay.
Mr. Leckie, what are we going to do for facts on Garner?
I emailed an incident report, but I could also voir or read them in.
Okay. Yeah. Let's see. We still got Mr. Martell.
Correct.
All right. Thank you. Go ahead, Mr. Leckie. I'm not taking emails at the bench.
Yeah, no problem, Judge.
Go
ahead. Well, counsel stipulate to the following, that the event happened on or about January 1st, 2024 at 422 at 5973 Esther Street in Romulus, Michigan. That on that date and time, Mr. Gardner put his hands on Latoya Hurst without her consent.
So stipulated, Judge.
And that they have a prior dating and living relationship.
All right,
Further
and
stipulated, Judge.
gentlemen, you're satisfied that those facts support the plea, correct?
I'm satisfied, Judge.
All right.
Defense is satisfied, Judge. Thank you.
Thank you, Mr. Martell. What should I know about Mr. Garner other than the plea, or excuse me, the sentence agreement? What should I know about him personally?
Judge, I've known Mr. Garner personally for the better part of my adult life and half of my teenage years. He's a lifelong Romulus resident. Certainly has had some struggles with alcoholism, which brings us before Your Honor next week. But he's been very proactive from the onset of that DUI, taking full and complete steps to work towards lifelong sobriety. He did the Oakdale 30 days and ultimately has been doing follow-up. Judge, I am confident the underlying issue here is alcoholism, to which he is addressing, Judge. So I'm hopeful that Your Honor will follow the terms and conditions which have been agreed upon by the parties and allow him to walk this opportunity down. And he has been fully advised that this is an opportunity, Judge. And certainly I look forward to seeing him complete his steps and ultimately working towards the dismissal. Thank you, Judge.
Good, thank you. Mr. Garner, are you working?
No, Your Honor, I'm on disability.
Okay, how long? Long-term?
Yes.
Okay, all right. Is there anything else you want me to know before I assess sentence terms?
No,
No magic answer. I just want to give you a chance to talk if there's anything you want to share.
No, I'm just staying sober and getting my life together.
Yeah. I'm glad you went to Oakdale. That's a great program.
Yes, thank you, Your Honor.
Yeah. Good. All right, so I think I've got everything that was discussed as far as a recommendation. 12-month delayed sentence under 769.4A, substance abuse evaluation. Obviously, Mr. Garner, if the evaluation leads to a recommendation for further treatment, that's probably going to be ordered by the court. Understood?
Yes, Your Honor.
All right. Batterers counseling, not to purchase, possess, or possess any firearms, and no contact with the complainant. The same terms of no contact that went with your bond. No social media contact. You see her at Burger King, you're eating Taco Bell. She tracks you down and wants to meet for coffee to talk about whatever. She can't change the order. Only myself or somebody else in a black robe in this court. Understood?
Yes, Your Honor.
All right. Court costs are assessed the amount of $1,000. I'll leave it to you to work out some kind of payment arrangements with the court. I want something on paper or payment in full within 5 days. Understood?
You said pay in 5 days?
I either want it paid in full or I want a payment plan on paper within 5 days.
Okay, do I gotta come in?
It's easier to come in. You can do it through our website, but you're a local guy, so it's probably going to be easier on you and the clerks both if you just come on in and take care of it.
Okay, thank you, Your Honor.
You're welcome, sir. Good luck with your sobriety.
All right, thank you.
Mr. Martell, always a pleasure.
Always a pleasure, Judge. You have a great day. Thank you.
Thank you, Judge.
Mr. Martin, are you on? You lied to me again, Heather? What time we're gonna do this exam on the floor?
Good morning, Judge Oakley. I'm here.
Good morning, Mr. Martin. What time? You pick a time?
Yes, that'll be 12 noon. So
All right, your appearance for Mr. Lazier.
And good morning, Judge Oakley, and to your staff, Neighborhood Defender Service, Carrie Martin, PE 4592. I appear on behalf of Mr. Brandon Lazier on both matters. Mr. Lazier, go ahead and state your full name.
He's muted. Do we have 2 files on him? Yeah.
There should be 2 files, yes.
I got 2. All right, Mr. Lazier, if you can hear us, all right, just give me a thumbs up. Perfect, thank you. Mr. Martin, I understand we're gonna set both these for an exam on May 4th at noon?
On May 7th at noon. I think so. I actually just stepped out of a courtroom where I was being set for trial on Monday. So I really hope that will be resolved by Wednesday, the 7th. But I will keep that date and I'll follow up with the court if there's a problem.
Yeah, that's no problem. Just let us know as soon as you know.
Thank you.
All right, so 12 noon, May 7th. Obviously, that's live. I understand you want to have some conversation about bond.
Yes, Your Honor.
Hold on just a minute. Mr.
Lazier's
Leckie, just
bond.
confirming, this is your file?
What file is it, Judge? I'm sorry.
Lazier. I've got two files with Mr. Lazier, Brandon Lazier.
It is not mine. No.
Okay.
I believe these would be Mr. Muhammad's cases, both of them.
Yeah, we got to find Mr. Muhammad. He's not online. Joe, can you tell him to come in or get online? Oh, okay.
Are we good?
Well, Anastasia's there with him as well, so she can tell him.
Anastasia? Oh, never mind. Mr. Muhammad, unmute, please.
Besides this one. Good morning, Judge.
Good morning. I've got two files for Mr. Brandon Lazier. Mr. Martin's getting ready to talk about bond, just so we're all on the same page. I'm looking at the file. It looks like he's on a 5,000, 10% no alcohol on case ending in 145 and case ending 369. 75,000, 10%. Mark file for mental health can only be released on GPS tether, cannot return to the Rose Boulevard address, no contact with a number of folks. We agree those are the bond conditions currently on those two files?
Agreed, Your Honor.
All right. So which file do you want to talk about first, Mr. Martin?
Your Honor, I think I can just collectively talk about both. I guess we'll talk first about that 75,000, 10% bond.
Go ahead.
On the assaultive case. And in general, Your Honor, I'm asking for a reduction of bond to either a personal with all the same conditions that you just listed, including a GPS tether, or a more achievable cash bond, as that 75,000, 10% is totally unachievable, equivalent to a remand for Mr. Lazier. Mr. Lazier is very open to going to treatment, specifically mental health treatment. I think he would be a good candidate for the Team Jefferson site, Team Wellness Center, or any sort of comparable program, such as, and I know Wayne County sheriffs can arrange for people to be either at Team Jefferson or other similar sites. You mentioned it yourself that one of the files was marked, for mental health, mental illness. That I think is the crux of the issue here, and I think that a GPS tether confinement to one of these centers would do Mr. Lazier a lot of good. And he does have a treatment history. A history of mental health treatment and hospitalization. I think the jail is not what he needs right now, and it's not necessary to ensure public safety in this case, whereas the conditions that you just named would accomplish that. Thank you, Judge.
Right. Mr. Mohammed, I just recently learned this was an option. I think maybe it was last week, at most 2 weeks ago. I actually, as bond, ordered the defendant to be tethered to teen wellness by the jail. And obviously it's fresh, so I'm not sure how well it's going to work, but it was recommended me by the judge in Wayne, who has a mental health treatment court. So she's had good luck with that. So I'm inclined on Mr. Lazier's file to change his bond to a personal, order that all those conditions that I just read into the record continue, and order the GPS tether to treatment. And my understanding from Judge O'Leary is the way that works is if they don't have a bed, they don't take him out of the jail.
And I can confirm that from prior experiences, Judge.
Thank you.
Judge, the only reason I would be hesitant is because I know there was another case, and I think it's actually up today, where the individual was tethered to Team Jefferson, but was out somehow as well. So that's why I'm hesitant to agree to that.
Well, let's see if Team Wellness is any tighter lockdown than Team Jefferson.
And the thing is, it's my understanding also that Team Jefferson can kick him out, and therefore then he would just be out. So that's what and especially due to his nature. I mean, in this case, in both cases, the facts suggest he poses a serious danger to the public. I think it was 3 or 4 FAs with firearms, and then the other case, which is an OWI third, I mean, he poses a serious danger to the public. So I'm more inclined, Your Honor, to object and request that bond remain the same at this time.
Understood. Mr. Martin?
Sorry, Judge.
That's all right.
Just by means of response, Your Honor, I just remind as you know that at this point these are simply charges, these are simply allegations. My conversations with Mr. Lazaire lead me to believe that this was a self-defense incident that led to these charges of felonious assault. Members of a single family kind of lining up their stories against him. So he's innocent until proven guilty, and he's already been in custody for about 2 weeks. So I think what Your Honor is leaning towards in terms of personal bond with GPS tether confinement to Team Jefferson is a good option. And Mr. Muhammad also alluded to the fact that, it's not impossible to walk away from there. It's not a locked down facility. Nonetheless, with that tether on, Wayne County sheriffs will know the minute he steps off the premises, and they're fast. They would take him back into custody, and Your Honor has the ability to warn and admonish Mr. Lazaire about any tether violation resulting in his resumed incarceration.
All right. Thank you, gentlemen. Give me just a minute. Is Team Jefferson and Team Wellness the same place? Or are they two different locations?
So the Team Wellness Center is located in the Eastern Market area down here.
That's what I thought.
They run another jail diversion facility called Team Jefferson, which is on Jefferson Avenue.
Okay. So if there's a problem at Team Jefferson, it's a problem for me to order him to Team Wellness. Right. Same facility.
Team Jefferson is the place he'd be going. I believe the Team Wellness Center in Eastern Market is simply outpatient.
All right, on the case ending in 369, I am going to put him on a $10,000 personal bond with GPS tethered to Team Jefferson. All other conditions remain. On the case ending in 145, I'm just going to change it to a $5,000 PR bond. And no alcohol, which was already a condition on that file. Thank you, gentlemen.
Thank you very much, Judge Oakley. We'll see you next week.
Judge, is he being placed on just a GPS tether, or is it an alcohol tether as well?
GPS tether to Team Jefferson. I've
Can I
ordered no
request that
alcohol,
they-
but I'm not going to order 2 tethers.
Okay. All right. Thanks.
You're welcome.
Thank you.
Here. Mr. Lazaire, can you get a deputy, please?
You got something ready?
We've taken care of it, but I came in and I like putting in person. I want to say good morning.
Good morning.
Please grab
Please.
Mr. Griggs.
Are we all set with Mr. Lazaire?
Yep, we're all set with Mr. Lazaire. If we can have Mr. Griggs.
Mr. Griggs.
Ms. Quick, your defendant is here. Mr. Lewis is here.
I was gonna ask if he was in person.
Yep, what were you guys doing?
Does he have a phone? I wasn't able to reach him yesterday.
Okay, we'll go double check and see if he's got a phone.
Thank you.
Thank you. Joe, can you go check, please?
Motions to
Mr. Lewis, Jason Lewis.
Jason Lewis. Why don't you give me a number so I'm not running back and forth? She wants me to call both things.
They gonna be a few minutes. They just changed on us.
See the number, Miss Boyce? I was gonna go down and see.
They can't hear you.
Give me something with the case numbers, and I'll go down and see the commissioner. What do you want?
I don't think so. Jason Lewis.
Judge, what is the state?
Mr. Woodyard, do you need to go in and speak with Mr. Lewis?
Yeah,
Oh,
put him
did
in
you
with
already
him.
Oh, I was trying to find him.
Mr. Johnson, are you ready? And Mr. Harrison?
I'm sorry. Yes, I just have to speak to Mr. Muhammad. Lewis's phone got stolen 2 days ago. No phone. He's in the courtroom.
No phone is quick, so we'll throw him on Zoom.
You're not ready for me yet?
Throw him down. No, I don't think so. What are we doing, Mr. Rashad? Or Mr. Johnson?
I already moved him. He has talked to Muhammad.
You look good, Leon.
Why does he keep, who is moving him?
There, you go Zoom down with your mom. Your mom got a phone at work. They probably had it. Yeah. I didn't mean to take it away from you. I said, keep it on.
Oh, no, that's fine. I don't have any.
My guy was waiting 14 days.
Yeah, I put that in.
It's way better. I'm glad you did. I don't know how you can do this by Zoom.
Miss Quick, did they say they were going to put him on a Zoom?
I think so, yeah.
Okay. All right, I'm watching for him.
Or if there's an NDS attorney in the courtroom that can call me with him, that would work too.
I don't know. Sorry.
Yeah, Mr. Woodyard's here, I think, but he's in a room, a Zoom room.
Done. Really, I had a great time. I just sat here to watch. They drove out here for a visit. It's closer to your office.
Okay, Miss Quick, I got him now. I'm going to put you guys both in a room.
Thank you so much.
You're welcome.
You said retire. You can retire. No, right. Now, babies. Plus, if you're still having fun, why not? Just see. Yes. Yeah, I appreciated your handing me that one matter. Oh, no, it was just, I told my daughter, yeah, you make it pretend like they wanted it out. No, yeah, sure. Did my daughter get so upset they want motion? Was she upset? Well, every time. I asked for a trial, because two guys were right in a bunch of them. Yeah, I see that food that it was their possession. Yeah. So it's just, they're gonna be anyway. Yeah. Right. You see her background is, so everything's fair and logical, right? And she's singing it. I mean, she prepares it as a call. Yeah. And that's good. What's that? Sure. It's obviously going to be miles. Yeah. So if you're interested in really want to be able to watch this video down. If you believe in what I started with videos. So. But I do it small. No, it's going to do it. Some people really there. Right, absolutely, you're correct. You're thinking of shame you. Positions better than my sheets.
Yes.
Right.
Hate it. I never wanted to go on.
That's right.
It's my house.
Yes. Yeah. And also, because I was here today, came up.
That's it.
Right. Well, I'm glad that. Got to solve it. No, she.
Yes, that's what I mean.
No, she wasn't. Everybody that she pressed over. We have one of the. Station cases of one. This is the lady's defense. She's caring for her money, so she's on. Suspicion in justice. Her law. She James. Okay. He's not before she.
And Walker's there. Mr. King, most of your people are showing up in person. Do you have your people's phone numbers to call them?
I do not. I have, let me see. The ones I had like 3 that weren't working.
Yes, Friday is here and Walker is here. Mr. Woodyard, are you done with your client or do you need to speak? You already spoke to Mohammed. What are you gonna do on
We're ready to go on the record. We're going to ask for an adjourned probable cause conference. The prosecutor is going to refigure the charges.
so you're just asking for an adjournment?
Yes,
Bond is staying the same?
yes.
Okay, what Wednesday do you want?
Wednesday?
It's always gonna be a Wednesday. What Wednesday do you want?
Sure. Is today Wednesday? I thought today was Thursday all day, all morning so far. Why don't we say, can we do it the 14th?
We could do it the 14th at 8:30. That's with Judge Patton. I'll do notice.
Okay, that's wonderful.
All right, then you're all set.
Okay, Mr. Griggs, you heard all that, right?
Thumbs up if you heard us.
Just give a wave.
All right.
Okay. Thank you, Madam Clerk. I appreciate it.
Yeah, have a good day.
Okay, bye.
Mr. Griggs, can you go back and tell the deputy that we need Mr. Jones? Mr. King, you already spoke to the prosecutor about the next one, correct?
I have, I'm
You need to
speaking
speak
with,
to Mr. Jones?
yes, I'm speaking with Ms. Walker right now. I do need to speak with, Mr. Jones as well.
All right, I'll put you in a breakout room.
Thank you.
Judge, I hope you had your fit on the extra steps of these. I mean, on the file. That's enough. I see it. Right. First of all, that one. Okay. That number was right. They've actually got maybe only files. So yeah, that one's great. Why don't they go with random?
Cheryl, it looks like we tried putting you in a breakout room with Mr. Lewis.
We're good. We're ready.
Okay,
It's gonna be a waiver.
It's gonna be a waiver. Okay, I'll let the judge know. You want to just take a seat, Mr. No, just take a seat. Yeah. Yes.
We were wrong. Originals are not for the 65. So yeah.
She's here in person, his attorney. And Smith and Roseburg came out and. Can you go let Moore know that Smith is here in person?
Yeah, exactly. Right, so D3, 128713. We'll waive the 20%, so they can down 7 they just start. And I know, that's how they get 30. I'm not changing anything. No list, no, he'll be done 13 when they pay. I just wish they had paid to. Well, yeah, total.
Yeah, I emailed it in and you guys emailed me back about the course. They had these gypsy. Probably have it handy.
Don't update her.
I feel bad for God. They've been good.
I'm thinking he's in one.
Just think. Good to see you. Okay.
So I'm just gonna ask.
Okay, ready for me yet?
Yes, I think I have 2 ready.
Let me get my robe.
Yeah. This one's. And Mr. Murray, we can get the date ready. Do you want like May 28th?
Let's go.
It'll be on Zoom with Judge Marks.
Is that 30 days?
I think it's
This
also.
prosecutor needs
It's 28 days. 4.
let's do June 4th. Good.
Martin, well, Abraham, it's gonna be June 4th.
Oh, okay.
Joanna Vargo? Come on up. Counsel, your appearance?
Your Honor, good morning, man. Please score James W. Murray, P4 legal. Standing with Barlow. Please state your full name.
Hello, Your Honor. My name is Joanna Noel Vargo.
Good morning, ma'am. We're going to adjourn this till June 4.
Your Honor.
Pick a time.
Oh, I'm sorry. What time did you want?
It's Zoom.
It's all.
Let's go. 10 a.m.
All right, so pretrial 10 a.m. Judge Martin, June 4. All right, let's talk bond. I'm assuming Ms. Vargo's a good candidate for personal bond.
Certainly is.
Would you waive formal reading?
You and will. And assume the statutory maximum penalties as far as on the allegation that.
All right, so I've entered a not guilty plea on counts 1 and 2. Ma'am, I'm going to put you on a personal bond with a number of conditions. The first condition is the obvious one, stay out of trouble. Second one's pretty obvious. You have to take care of your court date on June 4th, either in person or by Zoom. So if you don't have the ability to Zoom, you can show up here and we'll put you on a computer. Third condition is do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. Do you understand these terms, ma'am? Can you live with these? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up on bond?
Yes, sir.
Any questions for myself or Mr. Murray? Mr. Murray, we miss anything? Always a pleasure. Always. Have a great day.
Right now. The next one, Judge, is Jason Lewis.
What time?
It is 9 a.m.
All right, what time was Vargo scheduled?
I can't even find it. I don't know.
Not on the docket, is it?
I got the files.
Hey, Jim, what time were you scheduled today on this file? Oh, there she is. Okay, just trying to cross her off the list.
Thank you.
Have a great day. And Lewis? Was Lewis online?
Yeah, no, Lewis is in person.
Good morning, sir.
Miss Quick.
All right. Good morning, Ms. Quick. Your appearance for Mr. Lewis, please.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Jason Lewis, who is in the courtroom.
You didn't want to come see us today?
I had a little bit of an issue this morning. And
All
your court
right.
was very accommodating, and I appreciate that.
What are we doing today?
Your Honor, after speaking with Mr. Lewis, and also the prosecutor's office, and Mr. Lewis being advised that he has the right to a preliminary examination, he is electing to waive that right and have the case bound over to circuit court where we believe he will be placed into diversion.
Thank you. All right, you've discussed your rights with counsel. You understand those rights and the options they give you? She's explained to you the purpose for preliminary exam. You understand that. You understand if you waive today, that means your next court date's not going to be here at the district court. It'll be downtown at the circuit court level. Understanding all of that, are you waiving the exam right? Are you doing so freely and voluntarily? Ms. Quick, you satisfied?
I am, Your Honor.
So am I. Arraignment on information date will be the 14th of May. That'll be at 9 a.m., sir. Counsel, we'll have him stick around until we give him a paper notice. I'll continue bond and wish you luck downtown. Anything else, counsel?
Nothing else. Thank you so much to you and your staff.
You're welcome. Enjoy your day.
You as well.
Good morning,
Lewis,
Mr.
I'll call you
Duncan.
Mom.
How are you?
Wonderful. Sure, come on up. All right, Mr. Lewis. You gonna give him a notice or not? Oh, we're not gonna give him no. I'm sorry, you can go. We don't give you a paper notice. Yep, you're good to go.
With your mother. I'm sorry. You know, it's Muhammad. I mean, you put him, and I like him, but he says, call me anytime. I got 4 cases, right? I'd be an extra limiter. I'm not, but I got time, but he handles this. Then he talks to this person.
This one you guys have to.
And then he walks out, goes over here, then goes over here. I go, Muhammad, you got to focus on one of these. We got all these lawyers out there. We're just sitting there saying, so now he's in here and now he's having a conference over here with somebody. So,
Oh, okay.
Go to the other side.
Well, here.
I don't know what.
That was one of the ones that were brought here live.
But he's already. Oh.
These are the people that were brought to your life.
Oh, it just looks different because yours is in different.
Yes, yes, and I got it.
Yours is-
This attorney's here.
File's gonna-
It's also the defendant, so they can talk in a room,
Oh,
because
okay.
we don't have enough. And then
That's not.
he's on Zoom. He's live, so you gotta get a told him.
And that's what I'll tell
You
him.
guys probably did exactly what me and Hunter discussed.
That's what I'll tell him.
Yes, Smith and there so more can talk.
Smith, I think his attorney now.
Okay.
Oh, I'm crossing when I'm school.
So the other one just needs to be provided as a witness.
I like him, but he tells me. Maybe, have to hear that?
Yes.
Bring you up a laptop.
I think she.
No, why, is there anybody downstairs? Downstairs where? In the Zoom room. So.
He is a prisoner, but they brought.
Oh, boy. I thought Smith was a prisoner. They're both prisoners. I know. Oh, okay.
They brought two of them this morning.
That's a Simpson. Well, we'll get there.
So yeah, I think Mackenzie's on, but
Okay.
you can double check.
You're going back down. This way. Yes.
Hey, Heather, no one's in the Zoom room.
I know, but they don't want to put a prisoner in there.
Oh, okay.
So they have these other, Lewis's, I mean, King's other people need to go in there.
Yeah, because Lewis is gone now.
Yeah, Lewis is gone.
Well, we might be focused on something else. But, you know, by telling him to call and help that, I think that's great. You know, most prosecutors don't. No, I like it. Tell him, the only benefit is if I'm getting them out early, when I'm here. Okay? So, ask you if I can work right next, this one is Scotch island fish. Right. I mean, what? You do anything out. Another, we've always prior. So the reason you don't. Judges. Yeah. It's not saying anyway. Right. Well, like I said, I think he's coachable. That's why I like him. And I think if he was side versus you and talk. Okay. All right. Okay. Thanks. Say hi to Jay. Okay. Say hi to Suzanne. I will.
Yep, just take a seat and I'll grab you a notice. Judge, can you grab me Brown, Edward Brown?
I will. How are you?
Mr. King, are you ready on anyone?
On Jones,
Jones, Judge.
I believe I may need a break
But
out
you-
with the prosecutor.
I would like
Okay.
to meet with them.
Okay.
We've got at least 3 different defendants named Jones.
Thomas Jones, he has 3 cases.
What's the file I just handed you?
I'm sorry.
File I just handed you.
Edward Brown, I'm sorry, Brown at 9:15.
Yeah, we got two Browns too.
Yeah, this one's at 9:15.
I got him.
We're gonna start putting King's defendants in the Zoom room. So that he can talk to the Zoom room. Yep. And judge for Carpenter,
Carpenter, yeah.
I am gonna, neither her nor the co-defendant up here. If they don't appear, we're just gonna FTA them, but Carpenter right now doesn't have an attorney. Was that day still good for your?
Yes, yeah, that was the attorney.
Okay, that's what I thought, so I didn't want to hit enter just in case it wasn't a good day. You told him the day?
Yep.
Okay.
8:45, 2 weeks from today, May 14th.
Let me give you the notice, and actually the time changed to 9:30, but I'm sure if you show up a little earlier, fine, but let me just get this notice for you. I'm gonna go double check and see if either one of them appeared, if they did use FTA, and it doesn't matter that she wasn't assigned an attorney.
Carpenter, and who else?
Billy Brown,
Yep. You want me to just call the guys?
I'll go up there.
I'll call. Save your steps.
Security.
Hey, I'm checking to see if two defendants showed up.
All right. What time?
9 a.m. Billy Brown and Shaquila Carpenter.
Just here.
Brown is here.
So.
And Carpenter is here. We're just waiting for a turn.
Okay, thanks. He said they're both here and waiting for attorneys.
So Miss Carpenter, the attorney never, because the co-defendants, NDS took one, she was hanging, they probably tried 10 different attorneys, everybody declining it. So Henderson. We can handle, oh, there's Miss Henderson. No. We handle Mr. King and Jones. And then we'll go to the next issue.
Mr. King, are you ready on Mr. Jones's files?
I am.
Hello. Right now, I just literally called the files. Thanks. Counsel, what do we have on Mr. Jones' files?
We're going to be setting the exam and addressing bond.
All right. Is Mr. Mohammed the prosecutor?
No, Your Honor.
Mr. Lecky is the prosecutor.
That is correct.
Here's our TV.
Counsel, May 7, June 11, or June 18. What's your pleasure?
I can do the 7th, Your Honor, but I have a hearing in at Circuit Court, 3rd Circuit Court, at 9 a.m. I can come after that.
Yeah, my exams are all in the afternoon, so 12, 12:30, 1, 1:30.
1:30 is fine.
All right.
That's very good. That's June 7th.
May 7th, next week. And 1:30 was the choice, council, correct?
That is correct.
All right. Alright. So on the case ending in 0391, I don't even see that there is a bond on that one.
One of them it might need to be arraigned.
So on that one, would you waive formal reading, council?
Yes, we would.
Thank you. On case number ending in 0378, looks like it's $100,000 cash or surety. GPS tether, no contact with Charlene, I think it's Jones. Cannot return to a Hurano Drive address. And on the case ending in 0380, $10,000, 10%, no contact with Jones and GPS tether. Counsel, you agree those are the bond conditions on those two files?
Yes.
All right. Go ahead and make your argument.
Yes, Your Honor. With regards to the bond that's currently set, I think we have a couple of issues here. As the court knows, Mr. Jones has had the right to see a magistrate or a judge within 72 hours of being arrested, and that did not happen here. In fact, based on our investigation, it appears to me, at least at the forefront, that Mr. Jones was held for at least 4 days, maybe 5 days, before he was taken down to the main jail and prepared for presentment on this matter. Moreover, Your Honor, at this current juncture, defense counsel, even in preparation for next week, which I think is kind of pushing it as far as cases that involves these types of allegations, defense counsel still doesn't have discovery. I
Okay, let
have
me
just,
stop you, counsel. You picked the date.
yes.
So don't complain about how quick it is. You picked the date.
Well, I'm just talking about Mr. Jones's rights to see a magistrate within 3 days and then to have his hearing within 21. And so
Okay.
I'm just trying to, I guess, highlight for the court that I do anticipate being ready for next week's date, but that I see that there's some issues here. Moreover, Your Honor, although these are serious allegations, I would like the court to consider at least that Mr. Jones has a very minimal contact with the criminal justice system. The last one I see is well over 10 years old as far as an arrest goes. I'm unable to locate if there was even a conviction. This matter arises out of the complainant in this case is actually Mr. Jones's wife of 23 years, and there's been some family disputes and some disputes with regards to uh, to a potential divorce and property that I think may play in part with this as well. I said all this to say that I think that there are some circumstances that the court can set forth to guarantee both the safety of the community and his return to court. He has an address that he can go to. He doesn't oppose GPS monitoring or home confinement at this juncture in time. And as the bond is currently set, Your Honor, setting the bond this high is equivalent to setting him at remand because he's just completely unable to pay a bond of $100,000, even if it was put at 10%. He's not in a position to do so, and I believe that since the judge did see that he was someone fit for a bond, that it should be a constitutional bond that he can afford. So I'm asking for a modification in the bond, and that he be placed with regards to the conditions as far as going to his sister's address. I believe her name is Brianna Jones. She'll allow him to stay there with her and doesn't oppose GPS monitoring.
Counsel, do you know where Brianna Jones lives?
I did. The address is.
Hold on. Are you Brianna Jones? Yeah, what's your address? River Rouge? Okay. I'll get that again. Counsel, anything else?
Nothing at this time, yeah.
Are you making a proposal as to case number
Yes.
0378 that's currently set at 100,000 cash or surety?
ask the court to place him on a $10,000 personal bond with the opportunity, at least at this point in time, to be released to Miss Brianna Jones's home with no opposition to GPS monitoring.
All right,
Your Honor,
counsel.
you may respond, Your Honor. Your Honor, actually, we oppose any and all sorry, I'm so sorry, Your Honor. We oppose any and all changes or fixations to the bond at this time. These allegations are quite serious. So serious that myself and Mr. Art, our supervisor, actually appeared in front of the magistrate to argue bond in that case, in which case we laid out the reasons why it should be this high. Those reasons being he has no connection to the community, does not work. Not only that, he is a threat to the safety of his family. The allegations are threats to harm his children, his wife. There's a recording in which he threatens multiple times over the periods of 10 minutes to kill the wife. And, you know, I've had the opportunity to talk with the complaining witness, Ms. Jones, on this case, and it's at least documented 6 months of abuse, not to mention years and years prior. The people in this, I mean, the allegations are, they should speak for themselves. He threatened his own child, he threatened his wife, and he's threatened to, you know, if I call them, if anyone calls the police and kills everyone in the house. All these things point to, I'm sorry, that he should not be out in the community. We are very concerned, both our office and the Van Buren Police Department, for the safety of the family, not just the complaining witness, also their children. It is our position that the bond should remain where it is at. And I'd actually like to amend the bond on the new case that I think is going to be arraigned. That is that with the two FAs and.
Case ended in 0391.
To include the daughter as well, as in the part of the no contact order, who's another victim in that case. And
What's her name?
Kayla, it would be Kayla Jones. In that case, the defendant is alleged to have pointed a gun at her and to have hit his daughter in the face, etc. Those are all the reasons why we do not think the bond.
Thank you. Mr. King, any response?
Yeah, I mean, at this point in time, again, Your Honor, these are allegations, and I think the safety concerns can be addressed by placing Mr. Jones, even if the court has reason to think that there could be an issue here, that he could be placed in home confinement at his sister's home, and given a GPS monitor that will allow the court to know where he is and the police department to know where he is if he were to step foot outside of their residence. And at this point, these are allegations. And although the allegations are months of abuse, my understanding is that 12 months ago was when the disputes began and the divorce was spoken about, which I believe is going to come out at exam. It's just a matter of right now, these being allegations and him having the presumption of innocence and his criminal record showing that he's someone who the court can give some conditions of release to outside of his residence where he's been with his wife of 23 years that could protect the family as well.
All right, thank you, Mr. King. Mr. King, I understand these are allegations only, but I'm going to leave the bond the way they are. Well, we can take this up again next Wednesday and look at it if the bond or if the exam results in a bind over. On the file that was arraigned today, I'm going to set a $10,000 personal bond with a no contact order. Any questions?
No, yeah.
No contact with both Charlene and the daughter.
It's no contact with the complainants on that file. Thank you all. What do you got?
Two sit next to you.
Felicia Moran? Good morning, Mr. Robinson.
Morning, Your Honor, for the records.
Yep. Would you waive formal reading?
Wait formal reading.
All right, we'll set this for May 14th. Pre-trial, 10:30, Judge Patton.
Sure.
Ma'am, that works for you?
Yes.
Police department has no reason to object to a personal bond, so I'm assuming that works. Would a no contact order cause any problems?
The only thing, Judge, is that, that I haven't even discovered it yet, but I've been handling Ms. Warren's custody matter for. So I'm, intimately familiar with what's going on. Parties do communicate parenting time through Close, which is I don't think what's.
Yeah.
However, the complainant in this case does contact Ms. Warren outside of the app.
So how about if I just order no face-to-face contact? Does that cause any problems?
They do pick up and drop off.
Or I'm just gonna order no harm, not to harm, harass, or confront them. All right. Ma'am, I'm gonna put you on a personal bond. The first condition is pretty obvious. Stay out of trouble, no new criminal offenses. Second one's pretty obvious too. You have to participate in your court date, May 14th. And third, not to harm, harass, or confront the complainant in this matter. Understood? Raise your right hand. Do you swear, that one, do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on bond? Any questions? All right, we'll get you a notice and get you out of here. You're welcome. Richardson, Stephanie Richardson.
Or no, that's Josh.
Josh.
They're on Zoom. I'm sorry.
That would be Carpenter and Brown. That's the other files I got.
Oh,
I got one up here. Conley. Counsel, your appearance. Counsel, have you filed an appearance? Just not on my ROA. All right, we got you in the computer. Go ahead, counsel.
And having people here take each other on this starting section of addressing a well-involved tax game. And 12,100 this lies with all conditions. So
I don't think so. All right, so we're going to dismiss count 2, take a plea to impaired driving, plea on count 1, and sentence agreement on both. Agreed?
no.
All right, Mr. Conley, did you discuss your rights with counsel? You understand those rights and the options they give you today? You understand the possible penalty for these charges? Understanding all of that, are you pleading guilty freely and voluntarily today? Counsel, would you like to voir dire? March 17th is the incident date I'm showing.
This. Yeah.
You're in the double shots.
Yes. At the time you arrested, family is one of your section.
Yes.
Legal gun.
Yes.
All right.
Are you satisfied that the facts justify the pleas? I'll accept the pleas. I'll dismiss the original count 2. I'm going to refer Mr. Conley to our probation department to set up a pre-sentence interview. You'll come back, be interviewed by our probation officer, then you'll come back for a sentencing date. That's when the 3 of us will have a chance to discuss the report that the probation department puts together and anything else you fellows want to talk about before I determine the sentence term. Do you understand all that? Counsel, I'm going to let you follow the file down so you can pick a sentencing date. In the meantime, let's set bond. I'm assuming he's a good candidate for our personal. Good. Beautiful. Where at?
Southgate, Oakwood, I think it wasn't Shine.
Beautiful. Beautiful. You're working? Where do you work? Perfect. All right, I'm gonna put you on a personal bond. First condition is the obvious one, stay out of trouble. Second one's equally obvious. Cooperate with probation so we can get you back here for sentencing. Third one, do not purchase, possess, or consume any mood altering substance. Can you handle all those? Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess that up? Any questions? Counsel, anything else? Go on down to probation. We'll get you guys out of here as soon as we can. You're welcome. But
Added impaired. They added impaired and he's leading to the gun. I think they're looking at outrageousness.
Yep. I don't have any files ready.
Mr. Dolan's on screen still. I didn't look at him.
Yes.
Okay, so we can get rid of him and county's done.
Do you hear that, Deputy? We are done with the county. Mr. Jones is all taken care of.
You get here what happened? When's his next court date and did bond keep continued?
Bond continued and it's next Wednesday.
Okay, a week from today. Thank you, Your Honor and staff.
We lose Josh. Still don't have Josh.
Ask Mr. Harrison, or Mr. Johnson if he's ready on Harrison.
Mr. Johnson, are you ready on Harrison?
Hi there. Could I please have a breakout room with Mr. Harrison? I have to update him after our long conversation with Mr. Prosecutor.
You can.
Thank you.
Father, this is that same situation.
Any of you folks got anything ready? Smith?
He's locked up? Yeah.
What are we doing?
So they work with your exam?
Joe, can you bring him out? I'm sorry. Mr. Roberts, do you have your client's phone number? Because your client is here in person.
Yes, Madam Clerk, thank you. I'm actually on the phone with him right now.
Okay, so do you need to talk to the prosecutor?
I believe we did receive a discovery, so we'll just be setting a date.
Okay, then whenever you're ready, have your client come in the courtroom.
Thank you.
Counsel, when was your, you don't have to jump up for me. When was your guy scheduled?
8:30.
30?
They brought him on incident last name Smith.
Yep, there he is. Just trying to find him on the list, Counsel. And who's this guy gonna bring in? No, not Smith. The attorney you just said.
Yes. His one is Harris, Cameron Harris at 10 o'clock.
Cameron Harris, 10 o'clock.
Harrison's in the hallway, and it's my understanding his attorney's on Zoom.
Yeah, we're ready for him.
Right now, well,
And his attorney should be saying, come on in. Thanks, appreciate that. Good morning.
That's Stickler and Parnell that are president board.
I'm sorry, say that again.
Stickler and Parnell are very here.
Well, I'll pull those files too. I asked to Mr. Smith. This is Mr. Smith. You're Mr. Smith. All right, what are we doing? All right, counsel, I've got May 7th, June 11th, or June 18th. Mr. Smith, you can have a seat.
And then. That's fine.
Next week, how about 12 noon?
Yes, that's.
All right, anything else for Mr. Smith?
That'll be all. Thank you
All
so
right.
much. It does appear though, however, we do have digital discovery outstanding.
Okay,
One minute.
okay, well, I gotta say it. I'm old enough to have done probable cause hearings without digital discovery, so I'm not a real big fan of holding things up for that. All right, so give me those other names.
Parham.
Parham. And
Stickler.
Stickler. Who do you have first? Who do you want
Dates for preliminary.
to call first?
Parham, please.
Parham? Come on up. How about the same date, counsel?
That would not be the corporate exam. I am really busy. Do you have something that morning?
No, our exams are always in, but the earliest we do it is 11:30. I can go to another date. June 11th. 11:30.
Yes.
Mr. Parham, that work for you? Good morning. All right, so on Parham, we're going to do exam June 11.
And then I'd also like to do stick with that same day that.
Awesome. Stickler, you out there?
Yes, sir.
That work for you? All right, come on up. Counsel, I'm going to continue bond on both these files unless you talk me out of it quick.
Thank you for continuing on.
All right, fellas. Actually, you guys can just have a seat. We're going to get you notices. Counsel will get you a copy as well. Excuse me, and then we'll get you all out of here. You're welcome. You're welcome.
Can you put down Tracy's district?
No, no. Absolutely will not consider that.
I need to speak to you.
But I accept the compliment. Thank you. Always. Yeah, come on up.
My pleasure to meet you.
Same here. Hope I see you again. You're all business. I like that.
So, Joe, do you have a carpenter's information? We have a plan, or tell me what they do. No. Tim, has anybody picked up carpenter? Has anybody showed for carpenter?
Attorney.
Can you look at carpenter? And see if anybody showed for that, I think it was at 9 o'clock. You're in, yes. Forget it.
Yeah, she can't do it. That's the problem, right?
I'm sorry.
Okay, no problem. Thanks.
Have a great day, Counsel. You got anybody online that you think is ready?
Josh with this, Stephanie Richardson.
Mr. Hadley, are you there?
Nope, I haven't got.
I'll take that as a no. Is Hadley in the building?
Yes, he is.
Want me to be in, Judge?
Just let him know I'm ready when he's ready on Richardson. Next time you're out there. Any of you folks got anything ready for me? Who are you and what do you got? Cameron Harris.
His attorney's online, Mr. Roberts.
Yeah. Mr. Roberts, are you ready?
Yes, Judge, thank you.
All right, I got Mr. Harris coming on up. Why don't you put your appearance on record?
Yes, good morning to your honor court staff, Jonathan Roberts, P86428, on behalf of Mr. Harris, who is present in person. Mr. Harris, could you please state your full name for the court?
What are we doing today?
We'd like to set this for an exam. It's my understanding that the complaining witness does not want to move forward on this. This is a 6-month-old GBH. So the earliest date that your honor can give us, we would appreciate.
How about next Wednesday?
That would work, Judge. Thank you.
12:30?
Yes, that works.
All right, your client says that works for him.
All right, thank you.
All right, so May 7th, my courtroom, live, 12:30, bond continued. Anything else, counsel?
That's all. Thank you, Judge.
All right, counsel, you should probably be doing radio, not law. You got a great voice.
I appreciate it. Thank you.
We'll see you next week.
I'll see you. Have a good day.
You have a seat. We're going to get you a piece of paper. You got a question?
Yes.
Hold on, counsel.
Back to the pier here.
Oh, yeah. Yeah, it's live, just like you are today. Yeah. Yeah. All right. You're all right. Just have a seat. We'll get you a paper notice.
Thank you, Judge.
You're welcome, counsel. It's
And Justin Smith? Western Wing Narcotics. Oh, you guys. Finally. No, we haven't talked about. Harrison. No. We're waiting, is Billy Brown?
I'm ready on Harrison.
I don't know what happened. Double check.
Okay, I need to know if they both here, if they want attorneys, they're with.
I'm sorry, you're ready on Harrison, counsel?
Yes, sir.
All right, go ahead.
Yes, may it please court, Vassal Johnson II, 72130 on behalf of Rashad Harrison. He's present on Zoom and consistently present on Zoom. Today's date time set for PCC. I'm asking for an adjournment. The prosecutor and I, we're working out a discovery issue, and I also submitted a stipulated order for Your Honor's signature with your staff this morning.
Is that the one you were talking about?
I don't know. It's probably downstairs somewhere in our online email.
Yeah, I don't have anything up yet, counsel. When was it submitted?
At 10:22 to Miss Mortsfield.
Oh, yeah, that's,
And it's
yeah, it's probably in my clerk's email. She's gonna go check it. Mr. Harrison, can you hear me all right?
Yes, Your Honor.
Counsel, did you discuss another PCC date with prosecutor?
Yes, sir.
And that is?
2 weeks should be good. We didn't discuss an actual date. We just discussed adjourning it to a date.
Okay, all right,
So
2 weeks out works for you?
It does.
All right, so that is going to be the 14th. That's going to be in front of Judge Patton, courtroom 3. So that'll be a Zoom PCC.
Thank you.
Let's do that, counsel. 10:30, 9:30, or anywhere in between. You pick it.
Let's do 10:30.
Bond is continued on that one.
Thank
If you want to stick around for a minute, I'll let you know what's going on with that order. See if my
Sure.
secretary can find it.
I'll wait. Thank you.
Mr. Hadley, are you ready?
Stay on. Do I stay on?
Yes, Your Honor.
Your appearance for Miss Richardson?
Yes, Your Honor. Attorney Josh Hadley appearing on behalf and with Ms. Richardson.
Miss Richardson, where are you?
I'm sorry, Judge. Do I stay on?
Yeah, just stick around. Hold on a minute. Hold on a minute.
Okay, I'm sorry.
All right. Mr. Johnson, no, you don't have to stick around. I'm signing the order that your attorney submitted for discovery, so you can take off.
Okay, thank you so much.
Thank you, Judge.
You're welcome, counsel. Enjoy your day. Miss Richardson, you are muted. I need you on camera and unmuted, please. Cross them off on here if you can find them. Okay.
Jonathan. She's here in the morning.
There you are. Miss Richardson, unmute. Find Murray's.
Yes, I'm here. I'm sorry.
Thank you,
Can you hear me?
Mr.
I'm
Hadley.
sorry. Okay.
Thank you, Your Honor. Attorney Josh Hadley appearing on behalf of Stephanie Richardson, who stated her name for the record. Your Honor, we have resolved this matter as detailed in the plea form before the court. The driving with license suspended shall be dismissed.
Thank you.
Yep, thank you, Your Honor. I believe it was allowing an unlicensed driver to drive.
Yes. Miss Richardson, you understand your rights and options after discussing same with counsel.
Yes, I do.
You understand the possible penalty for the added charge.
Yes.
Understanding all of that, are you pleading guilty freely and voluntarily to the added charge today?
Yes.
Did you drive a vehicle on March 13, 2015 while your license was suspended, revoked, or denied?
Yes, I did.
Was that in the city of Romulus?
Yes.
I'll accept your plea to the added charge, dismiss the original charge. Mr. Hadley, what should I know about the nice lady before I sentence?
The Ms. Richardson is the proud owner of a temporary driving permit. Her physical license is in the mail or should be in the mail shortly. She looks forward to never having this be an issue again.
Awesome.
And not looking in that rear view mirror.
Awesome. Ma'am, are you working?
Yes, I am.
And where do you work?
I work at Ford Motor Company.
How long?
Going on a year.
Good. And it looks like you're currently on a payment plan with the court. Looks like a payment due. I think that's tomorrow.
Tomorrow. Yep, I paid
Okay.
every week.
You're on track? Okay. Anything you want me to consider before I sentence you on this file?
No, I'm just ready to get it over with.
All right. Well, I'm going to help you with that. Got a lot of late fees on this one, so it's racked up some extra fees. The total is $745. You can add that into your current payment plan. You just have to take steps to do that. So either do it in person or go online. Go to our website and send us an email that says that's what you want to do. Understood?
Okay. Understood.
Any
Thank
questions?
you. No. Oh, sorry.
You're
Thank
all
you.
set. Enjoy your day.
You too.
Christina Sidoraninos. Say it again. Sidoranios. Good morning.
Your Honor, that's me. I'm sprinting into the court right now.
You're doing what?
That's me. I'm on my way.
You can stay there. I'm just going to adjourn it, right?
It's an arraignment on an alleged operating while intoxicated offense.
I'm assuming you'd waive formal reading and stay on mute.
100%, sir.
I'm assuming you won't object if I put your client on a personal bond.
That's exactly what we were asking for, Your Honor.
And
Mind
I'm
reader.
assuming you can pick a Wednesday.
Yes, Your Honor. Let's
See
go
how
with,
easy?
yeah,
Go ahead.
absolutely.
Fine.
What Wednesday? Not you, him.
Oh, sorry.
Your Honor, on this one, there is some blood test involved and a little bit of video. Let's go out, if we may, until, can we go as far as June 11th?
That work for you?
Yes, perfect.
June 11th, how about 9:30?
That'll work.
June 11th, 9:30, confirmed with your client.
Phenomenal, Your Honor. Thank you.
Yeah, that's
You.
gonna be, that'll be on Zoom, Judge Martin,
Judge.
9 AM. Sorry.
9:30. All right. Judge Martin on Zoom. All right. Now, ma'am, I'm gonna put you on a personal bond with a number of conditions. First one is the obvious one, you stay out of trouble, no new crimes. Second one, equally obvious, you have to be here to participate with your court date, either virtually or live on June 11th. Thirdly, do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. Can you abide by those rules?
Yes.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess that up?
Yeah.
Any questions? Have a lovely day. We'll get you notice and get you out of here. Mr. Duncan, Erica Mazdi,
Passing that along, if that's something come up on you.
what's the next one?
I've got buddies, we don't have a fine, that's what we're waiting, I think we're waiting for a file on that.
Okay,
Paula Ashton,
got that one in my hand.
I'm just, Paula.
Good morning. How are you? Good.
Judge, I'm asking for a jury trial.
Okay. We got any of those? That'll be fun. We haven't had a jury trial together in a long time. Yeah, but not fun for you. It's state. Mohammed.
Gotcha.
June 2nd?
Second judge is gonna be for them.
Okay. Where's she got you on vacation now?
No, it's gonna be. Could we go either late June or maybe early July?
July, the only thing we would have is either July 10th.
That's a good day for
Yep, July 10th. The Thursday.
All right. July 10th, 8:30.
Thank you, Judge.
Bond is continued. You're welcome.
And mine was Samuel Coleman. Samuel, come up, please.
Go ahead. What are we doing on Miss Coleman's file?
On the juror, I think it's a ring. If it's a ring,
You way formal?
I waived the reading and and we're asking for an adjourned PC. Watching video, I wondered if May 21.
Any Wednesday.
May 21 would work.
That will be Judge Patton by Zoom. Good morning. And 9:30?
9:30. It's gonna be on Zoom. Okay. Good, so I have the other two files, but I'll come up when the overweight files is here and then I'll see what's going on in the file.
Okay. All right, let's take care of a bond for Miss Coleman. Good candidate for personal? All right. Ms. Coleman, I'm going to put you on a personal bond with a couple conditions. The first one is the obvious one, you stay out of trouble, no new criminal charges. Second one is also obvious, May 21 at 9:30, you got to participate on your court date. And then lastly, do not purchase, possess, or consume any mood-altering substances unless you've got a doctor's prescription. Can you live with all those? Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on bond? Any questions? You're all set. Stick around, we'll get you a paper notice and then we'll get you out of here. Yep.
It's not with the judge. No, we haven't done that. I said they're gonna change. You want to?
Judge, Mr. King's ready on Roseboro Wallace.
We're not waiting for Thomas Jones's address, Howard. You got that already.
Yeah, we're good.
Yeah, okay, that's what I thought.
Counsel, are you ready on Roseburg Wallace? You just thought he was ready, Michelle.
He was. Well, now I lost. Where does Clint go? Uh-oh. He's in the jail.
No, he wasn't in jail. He's here in person, I think. Looks like he's in jail.
Oh, really?
Oh, Russ, he is in jail. He's just here and they
I'm
brought him
like,
here.
I'm pretty sure he's
Yeah.
Yeah,
he's
he's
gone now. We lost
transport him
him.
and out. They transported him here when we didn't want him.
We
Council, you got
lost
anything
him.
ready? With a V?
Thank you.
You as well.
Heather, someone needs to go find him because we lost him
Hey, Joe.
wherever he's at.
The guy, Rossboro guy.
He was on screen. He's gone.
Ask the guys out there about what happened to him.
What's his name?
It's the guy that's live in custody here on Zoom somewhere in the building.
Rosborough Wallace is his name.
What is your guys' name? Emily.
Yeah, that's Murray's client. Mr. Duncan's client.
And what is your name? Cameron Harris? Did we handled you earlier?
I thought we did.
You're waiting for an attendance notice.
Mr. King, we lost your client. You want to go talk to your other one while we're waiting?
That's fine.
Thanks.
I can physically tell you where that guy is. I cannot.
He's not on Zoom. They got
Virtually tell
Have a good day, sir. What do you got?
Mr. Thierno, last name So, S-O-W.
What time was he scheduled so I can find him on my list? Thank you. Go ahead and talk while I look for the phone.
Your attorney, Josh. On behalf of Mr. Kim. Thierno, So.
Good morning, sir. Go ahead.
Thank you, Your Honor. We have waiver coming on this matter standing for range purposes as they're not guilty, they are prepared to resolve.
Go ahead. Tell me what we're doing.
Your Honor, the current misdemeanor charge of proper registration will be dismissed. We'll be pleading guilty, or I'm sorry, responsible. See, I have a little talk. Responsible to the civil infraction and non-distractible offense of no registration on person.
Is that the way you want to resolve this today? I'll accept the plea to civil infraction. I'll dismiss the 90-day misdemeanor. Fines a cost $200. Can you pay that today?
Yes, I do have a bond of 150. I believe already.
You only need $50 then. Do that downstairs and we'll get you out of here.
Okay.
You're welcome.
Checking them when you're done here. Nothing else on Zoom right now, right? I didn't see my breakout rooms.
Nope, you're good.
Okay. Crazy. Well. Yeah.
You know what? Morrison is. And name on the document, looks close to that, close names.
I had that interpreter case that was taking forever. And I was back and forth with Muhammad, and a couple of the retained counselors were like, "Hey, you're court appointed. You're here all day, man. What are you jumping in here for? We go first." And I just looked at him and said, "Do you guys have interpreters?" Okay. So no, you don't. The court's paying for the interpreter.
No, Spear.
Does interpreter cases, unless I'm way off on that.
No. That's
She's here
money.
for a
Time is money.
pre-hearing.
And you know how I am. I like to
I'm
take
waiting for the
care of
attorney.
the pain people, but that's my dollar.
That's what I was trying to tell those guys. I'm like, no offense, but that's the court's money. Make sure I'm not lying.
How did we lose the guy if he's in custody in our building?
Because that's our security for you. You probably took that and smashed it. Looks like Mr. King's ready on Riley, maybe.
Taja? Mr. King, are you ready on Riley?
I am, John. I think we're ready on Riley and Walker.
All right. Let's talk about Riley while I look for Walker.
Very well.
Go ahead.
Oh, yes, Your Honor. We're just asking the court for an adjournment here. The assigned prosecutor and I are discussing a potential plea offer that Ms. Riley would be willing to take.
Pick a Wednesday, counsel. Any Wednesday. You ready?
And we do the 14th.
Yes. That would be by Zoom with Judge Martin, or excuse me, Judge Patton. How about 10 o'clock in the morning?
That works for me. Is that okay with you, Miss
Riley, that work?
Yes, sir.
All right, you're all set then. Bond is continued.
Thank you so much.
And counsel, the other one that was ready was Kayla Walker.
Yes.
Miss Walker, where are you at? I don't see Miss Walker.
She was physically present.
At the court?
Yes.
Joe,
I just
go out there,
spoke to her.
holler for Miss
me.
Walker.
Yeah.
Kayla Walker. What are we doing on that one, Mr. King?
Same. We can adjourn it to the same date. So that we can consider a plea offer.
Yeah, what was it, the 14th?
Yes.
And I think it was 10 o'clock?
Yes.
Okay. All right. Done. We'll just give her a notice when we get her in the courtroom.
Well,
We're looking for her right now, Mr. King.
okay. I think
Did we lose her?
She's on her way, Judge.
Okay, that's fine. That's fine. That's fine. Mr. Duncan on Mazdi.
Judge Marie Duncan, on behalf of Ms. Mosby, please get your name.
Good morning.
Judge, it's been agreed with the prosecutor that the felony would be dismissed. Ms. Mosby would be 1 to 1,000, 1.1. The victim, which is the mother's, there's a sentence or there's recommendation to Your Honor that my client do anger management. I don't really believe he need nothing more. The parties have talked, he's reconciled with what the problem was. My client went in and fixed the door that was damaged, so that's been done. I do have an anger management class I've been sending my clients to. It's an 8-hour online class. Most of the courts accept it.
Yeah, where's it at?
I don't have it in front of me.
Give me that information because I like to put that in our arsenal.
Okay, then I will.
Yeah.
But I've had quite a few clients do it just because it's doable in 1 week. Otherwise, I'm ready.
Good. Good. All right. You understand your rights and options after discussing those with Mr. Duncan? You understand the possible penalty for the charge? Understanding all of that, are you pleading guilty? Freely and voluntarily pleading guilty? Would you void error?
Ms. Mosby, on August 14, 2024, were you in the township of Van Buren County, Wayne State, Michigan?
Yes.
And were you at your mother's residence at 9855 Andover Drive in Van Buren Township? And at that time, did you destroy or damage any property in your mother's residence? What did you damage? And was that intentional? And has that door been repaired? And was it repaired by you at your cost?
By us, yes.
And what was the cost on that?
$500.
Judge satisfied?
I'm satisfied if you are. I'll accept the plea. I'll dismiss the felony matter. Mom, would you state your name for me?
Name is Mary Goss.
Picking her up.
Yeah.
Okay, you can stay there. You can stay there. You're nice and loud. Is there anything you want me to know before I set the terms of sentence?
Well, sir.
Okay, that's all I wanted. All right. What else should I know?
Well, Judge, she works full time. I'm sure it's a Ford ad, correct? She works full time. She's had an issue with her mother. They're trying to work through them. There was not a no contact. That's what allowed her to go and take care of the dog.
Right.
I don't think we need reporting probation. I think if we put her on 771.1 and she.
No priors? No priors?
No.
Yeah, go ahead.
So I'm asking the court to just have it do the anger management and obviously tell her that you can't get into any more trouble during this time. And fine costs.
Right. Okay. Anything else you want me to consider? All right, I'll delay sentence for 12 months, stay out of trouble, no new criminal offenses, anger management, stay out of trouble, $500 court costs, that's done. As long as all that happens, at the end of 12 months, we dismiss. Understood? Can you pay the 500 today? You sure? Or I'll give you a due date. What do you want? How much? All right. Okay, now officially I'm done, but I'm not done.
Give me the file for you.
You only get one of those. Right? I'm going to really strongly advise you ladies to go to counseling.
Yeah.
Great. You just made my tail wag. Yeah.
I don't want to think of her record. I would like to follow the pages.
Yeah. No, unfortunately, sometimes the system takes a life of its own. Yeah, but this gives her the option to get it off her record. Now, and I'm sure you've explained, the arrest will always be there. The plea will always be in the system, but the conviction will be dismissed. So anybody in the system knows what happened. But if you go to get a job somewhere and they look at your criminal history, there's no conviction at that point. Okay?
After 12 months, it's wrapped up, right? If you don't-
The conviction goes away. Right. But if she applies to the FBI, they're going to know about all this because they have access to records that your employers don't. Understood?
Thank you, Judge.
Good luck.
Judge, is Buddy's transportation file here?
Nobody's brought it in. Is that a civil infraction?
Yeah, that's just the payment. Can I put it on the record or no? Yeah, it's an overweight.
It's probably downstairs already.
If they bring those into me, I just phone when they're done.
So did you get it?
I only have that as class.
Nobody brought it in yet.
He didn't do a form. He told me I didn't need a form. Do I need a form?
Who's got the file? Does anybody got a file in it?
It's a ticket. So yes, most
So
of the
he's got the ticket.
Yeah, he's doing 70% on the ticket, so.
Okay.
You let Miss Alper know that it's. Yeah.
So just on straight, I have to go back to Muhammad. He did the file form.
Because the paperwork lets her know what to put in the computer.
Thank you.
Yeah, good luck. Miss Al Turkey?
This is. It's just a pre-hearing. What? I can't.
You're muted.
I think both these two people are here, correct? No attorneys.
I understand you've talked to the prosecutor. You're going to plead responsible to a 1 to 5 over limited access speed.
Good morning, yes, Your Honor.
Fine cost 150. When can you pay that?
Within a few days. I'm just really sick right now, so I can't make it physically to the courthouse.
Yeah, that's all right. Just tell me how long you need.
By next Wednesday, I think would be sufficient.
I'll give you a week.
Thank you.
I'll give you a week till next Wednesday. You can do this
Bless your heart,
online, but it
thank you.
might cost you a little extra money if you do it online.
Okay, thank you.
Just go to our website if you want to explore that option.
And is that found on this document, I presume?
I'm sorry, say that again, ma'am?
Is that found on this document, the website?
I don't know that it is, but if you just do an internet search for 34th District Court in Romulus on Wayne Road, and it'll come
Okay.
up, and you can do that online.
Okay, thank you.
Good luck.
Thank you.
Walker. You have Miss Walker, Kay?
I do, Kayla.
Yes. Being left, but you were.
Yeah, we're just gonna give her a date. Is she there?
Did we lose Mr. King?
Yeah, we don't need him. Just bring Walker out so I can talk to her, please.
Okay, she's out.
Miss Walker, are you there?
Yes.
All right, so we adjourned your court date to May 14th at 10 a.m.
Okay.
And that's on Zoom.
Okay.
That's on Zoom, Judge Pat.
Okay.
You guys know. You're all set.
That's okay. How do I get my Zoom information?
Say it again.
How would I get my Zoom information?
Talk to your attorney.
No, go to the front counter, Miss Walker, and they'll give it to you. You're here.
Okay, thank you.
And then, Judge, what are we doing on his other case?
Which other case?
Rosboro. I can't, my thing just messed up. I can't read it. Rosboro Wallace. He's in
We're
custody.
waiting to find him.
We found him. He's here now.
Okay.
But we lost Mr. King, so.
Okay. Let me plug this in for you.
So 9 o'clock, we have Julie Brown and Carpenter.
Yeah.
They're the co-defendants. Sydney Henderson failed to appear.
Okay.
Miss Carpenter, right, Miss Carpenter never had.
No attorneys.
And same thing with Mr. Folks at 9:45. Oh, Washington says I'm in court, I can't show.
All right, so.
3 people, do we just want to give them a new date?
Yes, and then make sure we let Mariah know so she can call NDS and say this.
Well, I mean, I can get a hold of NTS and tell them,
That's fine.
okay, can you send in Henderson, Folks and Brown?
Interesting folks around.
Hey, Michelle, can you see if Mr. King's in a breakout room somewhere?
No, he's gone.
Can you call him, Michelle?
Yeah.
And once again, Attorney Pusey.
Right.
Brian, how are you? Better than I deserve.
And I'm surprised by Sydney Henderson. She usually is very good.
Yeah, it's obviously a mix up on calendars.
What do we want to give them those new dates here?
What's that?
So all the returns will.
Try that? Yeah.
Which date we gonna give so I can start to know what says?
Oh, sooner's better than later. Next Wednesday.
That's
Too soon, too tight.
your next Wednesday.
Oh, then do 14th. More time for the notices to go out. 10:15.
Yes.
Judge, they're looking for him.
And
Yes. They're all in here.
they're all in here, Judge. Brown, Carpenter, and Folks.
No speak here.
All right, Billy Brown, Michael Folks, and Shaquila Carpenter. You're all here and we have no attorneys for any of you.
Okay.
That means we got to adjourn it because 2 of you never had an attorney and 2 of you, your attorneys didn't show up. So we're going to adjourn it until the 14th.
I'm gonna get you guys notices, so just sit tight.
I can't even find function system on the docket. Joe, do you know where we lost Mr. Wallace while we were looking for it? Yeah, where was he? Oh, the computer just fucking took shit.
Went bad, so we got plugged it in.
Yeah.
Right?
Coach, when you get, I think it's Drew Shell Fabricating, 10 o'clock.
I probably don't have it. Is it just, oh, I do have it.
Yeah, we'll have to miss that.
There's a rest of me.
Yeah, I'll bring it back in just a minute.
What time was that?
It was at 10 o'clock.
Thanks. We didn't do anything with a Michael McDaniel, did we?
Page turned him.
We've had a pretty good,
Yes.
hey, let's check the docket too for no shows when you can, Joe.
Well,
Yeah, when you can. Yeah, how's everything going?
oh, man.
Yeah, go ahead.
This one's not going to stay with me. It's just going to go to whoever's in my DC council on the state docket in a couple of weeks.
Thank you.
Yes, sir. Wait a couple minutes until we get Heather. We're still rolling.
We're rolling. Alante Reeves.
Thank you, Your Honor. Attorney Josh Shadley, my DC counsel. You're going to be having with Mr. Alante Reeves this evening.
Good morning.
Your Honor, this is a little bit unusual. The people are asking for a 2-week adjournment approximately. I don't know if this case was sent to the Wayne County Prosecutor's Office by accident. The case code has a WM. I just spoke with the prosecutor, James Minna. He currently has this individual on a probation case.
Right.
For trespassing. It was almost the exact same time. They're a couple weeks apart.
Okay.
In fact, the case that he's on probation for right now happened after
This one.
which was sent to the state prosecutor for some reason. I will speculate that the wrong box was checked by law enforcement, and that's why it wound up with Wayne County, but pure speculation.
All right, so we're adjourned until the 14th.
I think that's.
That'll be by Zoom. We'll do it at 10 o'clock in the morning.
Is it my email?
No, you're gonna have a seat. We're gonna give you notice. Reeves. But it says, okay, that other file you're talking to, he owes money on. You owe $150. All right, what are you doing on that? Pardon? You have a payment plan? When's your payment due? Because we're showing money due right now. Have you missed a payment?
He may have, the plea was entered on the 18th, April 18th. Mr. Reeves is currently, without housing,
Okay.
not employed.
Have you set up a payment plan yet or not? That's the problem. Yeah.
Oh, this phone guy, when he was on Zoom.
Are you in a position to commit to some payments? All right, so just set that up before you leave, get it on paper.
And that's like focus. Just go down to the first floor. After they get you your new piece of paper, just get that paper. That's on the other case. Thank you, Your
All
Honor.
right, we'll get you a notice for this court date on the 14th, then you can go downstairs and set up that payment plan.
We'll bring out whenever it's ready.
Michelle, any luck finding Mr.
We
King?
he's here now. Mr. King, we have Mr. Rosborough Wallace. What are we doing?
Setting an exam and addressing bond.
Okay. Did you hear that, Judge?
Yeah, is this prosecuted by Mr. Mohammed, Mr. King?
Yes.
All right. Hey, can you do me a favor? Tell Mohammed I need him on a bond discussion for Roseboro Wallace. Counsel, we already gave you a couple exam dates, didn't we?
Yes. For the.
You want to tag this on one of those dates?
That'll work.
Give me a date you want to use. Date and time.
The 7th. I think you have me down for 1:30 on the 7th already.
Okay, let's just tag this one on at the same time.
Okay.
Mr. Roseboro Wallace at work next Wednesday, 1:30.
Yes, sir.
Thank you. Counsel, I'm gonna wait until we got the prosecutor in here so you can make your bond argument.
Very well.
What do you want me to highlight? No shows or?
Yeah, I'm gonna give you some names. You tell me if they're here or
Okay,
not.
let me.
9 o'clock.
9 o'clock.
Neff or Polymer?
And Polymer's mine too, Your Honor.
I'm just checking to see if they ever showed up.
Okay.
Oh, Neff, yes, Neff is here.
Neff is here. Polymer, PAL.
No, no show.
Polymer is a no-show, counsel.
Thank you.
How about Sidoranius? We did. Swoveland, that was adjourned. All right. 9:15 Griggs.
9.
All right.
Aaron Griggs.
Oh.
You want more than one or one?
No, one's all I need. Thank you. Thank you. Thank you. Appreciate it. That's exactly what I needed. Schmidtly.
I think he was.
Schmitley's here.
Broughton at 9:30.
Nope, no show.
She called for an adjournment from what I understand. So if you hand me that one. Please.
Yeah, I gotta find it. Sakuro,
Help me with the time.
9:30.
No show. She's very Italian.
Vertes.
Yeah, they're here.
It was a pre-hearing.
Buddies at 9:45.
Buddies was done. Well, we couldn't find that ticket, but
Yes.
Oh, that was Murray's. That was Murray's.
okay,
Yeah, Willoughby, 9:45.
no show.
Javion Jones, Tim.
No show.
Not 10:15 Deal.
No show.
How about Travis, or excuse me, McNeil?
No show.
Scott, 10:15.
Here, they're here.
10:30 Jones,
They're here.
Pugh, Vasquez.
I think they're here. There's a,
That one was done on a.
Oh, yeah, that, the attorney was in here.
okay.
Al Turkey, we did at 10:45. That's enough. Thanks.
So are we done with Rossborough?
Yes.
File?
No. But you want to have him come get a notice? He's in custody, so the guys can take it to him. All right. Mr. Rossborough Wallace, we're going to give you a paper notice. Just a few minutes. Understood?
Can you explain?
We're just going to give you a notice for your next court date.
You're breaking up, Your Honor.
Are you done with it?
Yeah, we've been asked.
We are going to give you a paper notice for your next court date.
Yes, sir.
Can we?
Is there a bond argument? No. I dismissed this.
But she does not have an attorney.
Who?
This
guy?
But the misdemeanor was dismissed, so I don't know.
Are we done with Mr. King now?
Yeah, so he's not dealing with me. He's just going down to the counter.
Oh.
I don't know if Mr. King has any other files or not.
No, I wanted to address the bond though for Mr. Rosenborough.
Oh,
That's what we were waiting for.
Oh.
Spoke up. If you just dismiss that one.
Yeah, that file back.
Oh.
We lost him. We lost the defendant again.
Yeah, we didn't know.
Just bang on that door and see if they're in there. Because I think they got him right there.
I'll just stay.
Please.
So he's paying he agreed to the whole.
Yeah, no, he's still going fraction. Yes.
40?
Oh,
Okay.
is that how much those two things?
Yes, 300 and then 500.
Oh, those look very expensive. Yeah.
You're good. Okay, so we want to go downstairs and I'm gonna send the files out.
Okay.
Okay?
Thanks so much. You're welcome.
Hey, who's in lockup right now with Rossborough? No, with Rossborough Wallace. Who's back there? I think Joe's back there with him.
That's the big radio one.
Yeah, so I either need him on camera or in the courtroom. We're going to talk about him. Counsel, we can probably get started without your guy, can't we?
I'm fine with that.
All right, so currently I've got the bond set at 50,000, 10% with a GPS tether, location, not curfew. Mr. Mohammed's in my courtroom. Go ahead.
Yes, Your Honor. So the bond as it stands right now is unattainable by my client. I think it's this obviously the allegations are serious. However, I will say, Your Honor, that I at least right as of the last time I was on here, I didn't see the victim's name on the Zoom, nor was I notified that the victim was in court. But this is an incident that occurred. Obviously, the allegations are that this is an incident that occurred between two people that have some knowledge of each other. Both sustained injuries. As he is there today in the courtroom, my client has a very serious wound to his knee that has required staples. I think not I think, and reviewing just the paper discovery that I have, he was completely compliant with the police when they came, and he in fact was one of the people who called the police to try to address the matter. He didn't try to flee. And as it stands now, I believe the court can fashion some conditions that can guarantee his return to court with the stay away to address any safety issues. I don't see any failure to appears or warrants for missing court. in any of the documentation that I have. And I think that's also indicative of him not being a flight risk. Although he does have ties to another state, he is here now and has no intention on leaving the state of Michigan for any time in the near future.
Good morning, Your Honor. Mohammed. Well, did you say the bond was 50,000 cash?
50,000, 10% with a tether.
Of the case, the offense, the facts, I think 70,000 cash for. This individual defendant, I think, poses a serious danger to the public, and the reason is the type of weapon that was used was, I believe, a knife, and there was multiple stab wounds in the case, and the victim was actually the defendant's friend, as my understanding. So if you're willing to do such a heinous crime against your friend, imagine what kind of danger you pose to the general public. So to ensure the public is protected, I'm going to object, and I'm going to request 70,000 cash surety.
Thank you. Mr. King, and I'll ask your client, but I did this arraignment. I set the bond. It seems to me when I asked him about his South Carolina address, he had not been in Michigan long at all at the time of this incident. Do you know, or should I confirm with him?
Now, I think the court's accurate. That is an accurate account of his current situation. But my understanding is that at least 2, maybe 3 of them were coming here seeking permanent residence, and that's still the intent as to date.
Right. All right. Anything else, Mr. King?
And I guess I'll just say, like, with regards to the incident, Mr. excuse me, some of the things that Mr. Muhammad addressed. Again, my client was completely compliant with the police here, gave an account of what happened, waived his Miranda rights, again, didn't attempt to flee. And this seems like a personal matter that happened literally within the confines of a hotel room. A hotel room that was occupied by my client and these other individuals, but it's not as if he was out in the community assaulting people or robbing people or trying to do any harm. So I just asked the court to give him a $5,000 personal bond.
Thank you. Mr. King, the reason I set the bond the way I did is because of his ties are deeper in South Carolina than they are in Michigan, and that's a concern to me. I understand these are allegations only, but I'm going to leave the bond as is. If he was waiting, 3 months or 3 weeks out for an exam, I might have a different attitude, but I'm going to leave the bond as it is until next Wednesday. We can readdress that if he gets bound over.
Thank you.
Thank you. Thank you, sir. Mr. King, do you have anything else left? I guess not, because he's gone. Okay. All right. You can, but it's not going to change anything I just did, so I don't know if it's in your best interest to do that.
I was gonna say, I don't know that dude that I got the case against, I don't know that kind of thing, we're not friends.
Okay, well, your attorney just said you were in a hotel room with him, so it doesn't change anything. All right, good luck.
So then you can find another best favorite.
Thank you. Well. Time to run down my car, I just had some.
Unfortunately, yes.
Okay, great, no problem. I figured we'd have to wait, but I have a bottle of water. Are we allowed to bring?
Yeah. Go ahead. Go.
Didn't know if they let me in. Does anybody here, do you guys want one?
No, thank you.
Farm, so.
Mr. King's.
Is it pretty nice out?
It's decent. It's nice and sunny, but it's not,
I'll take the sun.
Don't, if you have your air conditioner on yesterday, you probably turn it on today, that's what I would say.
Okay.
I can't figure out how to put the AC, and that's the trouble.
Spring. Mr. King, you back?
Yes, John, I'm sorry. Was the court addressing me again? I thought I was done.
I was just asking you if that's the last file you had.
Yeah, I had Palomar as well, but I believe you said that she was
Yes,
a
yeah,
no-show.
we got them in the no-show pile. Have a great day.
You too.
Each with a minute. Cause I love my line, which takes a shit show. And it's,
Part of it's because of the too much.
you would have absolutely no
Yeah,
issues.
I was gonna say it's the live isn't the problem. It's too much. Too much.
I mean, it's because they don't talk to their clients at the time.
Right.
I have these, if you guys need to go get copies. Please. Do it in Michelle's office, though, please, because mine have her.
Okay.
Seriously, going through
Good.
Yeah, grab a seat. You know where the seat was. Yeah. Please invite them. Hello? These copies of these minutes, do you need to know who they are and what they're for?
Yeah, are you here on one of the exams?
Who's doing some work in the background?
No, no problem.
Yeah. All right. Bye.
James Kings. Down behind.
Okay. Well, no, then I can give you an MTA with the, I mean, are they gonna let him have that piece?
He's in there when he's shit.
Here.
Shows the city more something. I'm not gonna have my way. I was gonna go on my way to freaking
No.
talk to him. You lost that.
I hope it's not fucking going to the not. I'm just not. Logging it.
Oh, I don't know how he thinks that's helping anything.
Get your copy, then. Thank you very much.
Any police or?
Be your- Sorry, man.
What exams do you have?
I think 5. Oh, I don't know.
Let me. These were working together. No, yes, I do.
Hey, Ken, can you confirm that a Danielle Jones is out there? Crystal Medina is listed as her attorney, please. Oh, yeah, I think you're right. We heard Brian Prane talking.
It is. Mm-hmm. Yes. Look at someone. I hope you enjoy.
Joshua Patton, I've got a bunch of files here, but you crossed them off the docket.
Yeah, I crossed him off. I just didn't know if Kelly was gonna put him on the screen. He's our guy that escaped.
Yeah.
Judge, she is here. And we're just waiting for Josh to talk.
Thank you.
Got a whole bunch.
Thank you. Yeah. Same with Jadal Pugh then.
Who is this, Josh?
Gregory Pugh. But we're still working on.
I got him.
What was that date? Oh, we didn't write it. We still wrote after.
I think it's June 23.
Yeah, as long as it's after that, that was the prosecution and
I don't have any dates that late.
after June 23rd. I wasn't sure going that far out what we had.
June 25th. That'll be Judge and is that what I'm doing on this page?
Got a Third Circuit matter. Do you want to go? Do we need to go on the record for this one?
We are on the record though.
Mr. Prosecutor, did you know your estimate on this one? Okay.
So that's June what? 25? Time,
9:15.
courtroom?
Agree. Yeah.
I'll let Mr. Jadal know.
Mr. Pugh, you owe us $545 on a resisting arrest file.
Yes.
You got a payment plan on that?
Yeah, well, I called them and I also said for the workforce I was supposed to do, they said that they'd be calling me back about that. And
Get something set up on that today before you leave the building.
I do that, the
Downstairs, yep.
I'm sorry, John, do you want like a final or?
Yeah, just do whatever it was previously, final. If that's what it was, stick with what it was.
It's right now for a pre-trial.
Oh, where you, I guess,
I show final pre-trial.
I'm okay with final.
let's do final.
With a complainant to be here?
All right.
Got that, Heather?
Yeah.
So that, I mean. Thank you, Jake. I will let Mr. Jadala know. I'll email him the new date that's, complaint to appear.
Have a second.
Yeah.
Travis Deal.
Have we called that, or is there an attorney present, or have we called that again?
Travis Deal's in the no-show pile.
You can grab a seat. They'll bring you your notes of your. Please, we're all set. Mr. Peter.
Correct.
Beach. I'll bring it over to you just a minute. You're welcome.
Mr. Hadley, I'm showing Scott, Schmitling, Jones, and Neff still looking for somebody to talk to.
Scott and Jones in hand. What was the other one?
Neff?
Yes, Neff is here as well. Neff drove to the criminal justice center downtown. So just a little.
Yep.
He's running Neff.
Come on up.
Good morning, my name is Josh Hadley, standing in on behalf of
Morning.
the less than half on behalf.
Thank you.
Today's the day is time set for a PCC in this matter. After speaking with Ms. Neff, Mr. Neff, what we're gonna be asking for is an adjourned date of May 28th for the PCC. This is an older case, Your Honor. It's an OWI from, I believe, a 2023 offense date. Ms. Knapp is in the process of collecting all necessary discovery for potential dispositive motion. That's the basis for the request.
All right.
Waive any 21 day, 14 days as to the PCC.
Yep.
What time do you want?
May 28, 9:30. That work?
Yes.
That's Judge Martin. Bond will be continued, sir. We'll get you a paper notice. I just lost my docket sheet. Hey, Joe. Eventually, these can go down to Mackenzie.
Oh. Being released from good with that. But nobody else. Your Honor, if we could recall Mr. Neff's matter, we have some concerns about bond. Okay.
Let's see. Looks like the bond is 5,000 personal.
And
Do not leave the state of Michigan. Do not commit any crimes. I don't see anything. Oh, alcohol tether.
that's where we're at. So Mr. Neff was released from custody by Romulus Police Department and was told, don't worry about that, meaning that being the tether. We'll send you some paper. Mr. Neff needs to get the alcohol tether because looking at this point for how we're moving forward, but hasn't been given.
Let's just drop the tether.
Okay. Greatly appreciate it. He just wanted to be in compliance and was quite concerned with me.
You're good to go.
He will not be drinking. We will see you the next day.
All right. You're welcome, sir.
I'll be back. Yeah, go bring your emails. So that takes care of it.
Oh, check it out. I was like, what? Thank you. This is Rob.
Literally in there. Let me come back.
CW failed to appear dismissal.
Make sure to look at the mouth.
If you want to take a break, I didn't want to pull it down.
I believe. Make sure.
Oh, you're good.
Wait a minute. He has a bond.
Yeah, two others that are waiting for me. If he wants me to go take care of those, I can bring everybody in.
Okay, that's fine. If you want to do that.
Back if you want to.
Hey, ma'am,
Yep.
I left you a message a little while ago. My name is Stephen Schmitling.
Oh,
I
okay.
just wanted you to listen to me.
Okay, good. I haven't listened to him yet, obviously.
Yeah, I went on Zoom this morning,
Okay.
so it was just a big misunderstanding.
Okay.
I'm here now. so-
Okay. Currently next to is just a dismissal.
Yep.
The surety bond, just so I wanted it on record.
Yep.
It is a hazard one. He said he can wait if you wanted to put it. You just.
No, we don't need it. You're Mr. Schmidtling? You're okay with this case being dismissed? All right. Looks like you owe us some money on some other stuff. You got a payment plan? Good. You're all set.
Yeah, well, okay.
You too. Any scrap paper down there?
Hey, it's John, you're going. But either one. Clean up. Yeah.
Still, did you want to join them all for lunch? They have a few hot pockets, water with ice. I'm asking Dale if he wants to.
Does it matter?
Oh, Pravanchi, when he was on this morning,
Yeah.
he's done. Friday's his last day.
Good for him. I wish I could have congratulated him.
Yeah.
Do you have a phone number for him? He probably won't answer.
I bet he would.
Hold on a minute. I got. Yeah, let's take care of this first. Remind me, I got something from Crank about her. Go ahead.
Okay. Oh, and I lost it. It's 586 942 1453.
He's corporal, right?
I think so.
Brian Oakley calling. I just heard the very bad news for us, the very good news for you. Happy retirement. I just had to call and tell you that we will miss you. You are the consummate professional and always with a smile on your face. I always suspected mental illness, but I was happy you were like that. Yeah. Right, right. Oh, it's been so good for us. We're gonna miss it. We're gonna miss it. But I wish you all the best. Thank you. Stay healthy. Bye-bye. 22 years in the military, then the department. Yeah. We're wow.
So we're done.
Did you guys hear that? Provanchi's done this week.
Yeah.
We're gonna miss him.
Yeah. Judge, we told him, he says he has mental health issues and anger issues, and you don't want to see our mental health issues. So just eat your lunch, go to sleep, and we'll get you out.
Get you out of here.
Wait, he said that, so he's staying here for 6 months, selling his family's property up north, moving to Hawaii.
Moving to Hawaii?
Yeah.
Moving to Hawaii. He says he's gonna lose 50 pounds, because the last time he was there, people were paying him for shade because his stomach was so big.
That's funny. Yeah. Yeah. That's a good one too. I wonder where his property is up north.
Yes, but I didn't.
And good for him.
This is his girlfriend, the last I talked to him about it, she lives in California. And she's moving with him too whenever that's their plan is Hawaii.
Well, grab a seat. Heather, I think it comes here to do a little bit of housekeeping and.
Want me to prosecute you?
Yeah, that's fine. Oh, housekeeping, I think I got one or two that I'm not sure exactly.
At some point, you're gonna tell me who this guy that you got dragging around?
Ah.
You've been in here 4 times. I've been waiting for you to tell me.
MIDC.
What's the title?
I guess I'm familiar with the, like where Judge Patton used to work, regional manager.
Yeah.
Yeah, so I'm working as an attorney there to, deal with the CLEs.
Yeah. Like the in-house guy.
Yes.
Right.
Figure out, Mr. Hadley, what is exactly you would say you do over 34th?
Yeah.
And this
This is actually pretty good then. Thank you. Because I mean, now you know what's going on out in the field. Yeah, good for you. Good for you.
There's that one.
Scott. This on yours?
Yes.
Yeah. Cordell, Scott.
Thank you, Your Honor. Attorney Josh Hadley, here on behalf of Cordell Scott, standing in place for MIDC counsel, Ms. Krista Medina, with my client's permission.
Good morning, Mr. Scott.
Cordell Scott.
Thank you.
Your Honor, we have reached a resolution in this matter. The current charge of the operating while intoxicated with a BAC greater than 0.17 will be entering guilty plea to straight OWI.
All right. Sir, did you discuss your rights with Mr. Hadley or with Ms. Medina, some attorney? You understand the rights you have and the options they present? Understand the possible penalty for this charge? Understanding all of this, are you pleading guilty today to the added charge? Are you doing so freely and voluntarily?
Yeah.
Mr. Hadley, can you voir dire to get the facts I need? A May 4, 2024 incident date?
Mr. Shaw, May 4th of 2024, were you state of Michigan, County of Wayne, city of Romulus?
Let's see that. Where was the incident at?
Michigan's going to be a big reason.
In or about the general vicinity of this district?
I'm going to tell you just a minute. Rossville Road 94.
There you go. Were you at Rossville Road 94, Wayne County, state of Michigan, on May 4th, 2022? Yes. And at that date and time, you consumed alcohol prior to driving? Yes. And was your blood alcohol content above a 0.08? Yes. And did you review the Michigan State Police blood test with me that showed the result over a 0.08? Yes. And do you have any reason to think there's any errors or any scientific reason that test was wrong? No. Okay, and did that alcohol that you ingested that night in any way impact your ability to drive? Your Honor, I think we've satisfied the element.
I'm satisfied as well. I'll accept the plea to the added charge, dismiss the original charge. I'm going to send you downstairs to hook up with the probation department and schedule an interview date. You also find out when your sentencing date is. When you come back for your sentencing, you have a chance to go over the report that's prepared by probation. They're going to also recommend sentencing. You'll go over all that with whoever's here, Miss Medina. Yeah. Yeah. I'll look at that report and then you, the attorney, myself, will have a conversation about anything you want to talk about, and then I'll determine what the sentence should be. Do you understand all that? In the meantime, your bond is continued. Any questions? You're welcome. Downstairs, listen for your name. You as well. He's pleading to intox.
All right.
Did I tell you this already? Mackenzie, whenever.
When I'm gonna move, you told me, but I was hustling.
Yeah, and we don't want them when we're doing witness exams or exams with witnesses.
Yeah. They're over there. Yeah, I gotta keep it. Says.
So there is, it's not related. I mean, it is.
When do you want this one adjourned to?
Meeting with Miss Medina, 2 weeks out.
Okay.
I think that should just 2 weeks work for you. Would it possible that we would land on a Zoom date?
Yes, and 206 a Zoom date.
Perfect. They were very patient, slow moving, Mr. Hadley today.
Thomas way back though. So I've got 2 11 o'clock exams. You're done, aren't you?
I think so, sir. What, I don't know why that felt like I was pushing a piano uphill today. I don't know.
Just said this did not go smooth like it usually does. Well, as smoothly as you.
In a
Part of it is too much Zoom stuff.
I don't, we blow through busy Zoom dockets too. I think it's when it's the jumping, yeah, that come back.
When it's purely Zoom, it's different.
And then I am not here, I'm not here to talk shit about Wayne County prosecutors' policies. Yeah, a little bit. But it's still bifurcating DVs between dating and non-dating.
Yeah.
It creates another weird, sometimes.
I understand it, why they're doing it, but it just adds another layer of if you.
It ain't a different case caption. We don't know kind of thing.
I was like, just leave it.
You know what I mean? It's one of those, it's like, okay. Now, mom against dad, son against mom. Your brother or like your family member slapping you over, family. It's just a different dynamic emotionally. Trust me, I mean, what these.
We should.
I don't think Judge would have a hard time with that. So I think I'm gonna take a deep breath. Yeah. Who was over here the other day? Peter was here. Did you meet Peter when he was over here the other day with MIDC? About my height, a couple of years older.
What's his last name? Yes.
Okay. That's great. Oh.
Yeah. Thank you, Alex. Yeah, I did meet Granada.
So, yeah, I guess I didn't realize who you would have and have. I wasn't sure who I.
No, it's all right.
35th. We were here, but it was. Okay, that's what it was. Because I've worked with you here now twice. So I've lived with Martin, also third. With Judge Oakley here last time, and then ladies here.
Anyway,
I like common sense to sink back in. I feel like I'm forgetting something.
Washington showed up
When was he scheduled?
like 9:45.
What the hell does he expect us to do now?
They just told him to go talk to Mohammed, which is a problem, because then that's gonna back up Mohammed.
No, yeah.
This one for crystals.
We're ready to go on, Gilly.
I'm son, oh no, Crystal.
Oh, God.
That's your defendant.
Well, we could.
Do you want me to just tell him to leave, Judge?
I don't care if he wants to sit around, but I don't want him to hold up Muhammad.
He's not Mohammed right now.
No. Okay, if we're ready, where's Muhammad? Tell him I don't want him to even say hello to Mr. Washington, who's 3 hours late, and hold me up on my exams.
We're trying to hold.
Oh, this is my, in case I'm covered. But the discovery.
Thank you very much.
Great afternoon.
Good morning, counsel. Are we ready on Gillikin?
Yes, we're starting the exam.
I don't know what we're doing. Here I am, ready.
Again, okay, thank you.
Have a good day, guys.
Ron, thank you. If you need anything else, just let us know.
Yeah, it's sort of videos they went. Yeah, did you get it? I get all that.
A question about what do you want to docket?
Yeah.
It's just that when I'm doing those invoices, the way they ask us now, sometimes I forget.
Thank you.
No, behind you, off the attorney.
I am covering Dinsmore.
Who?
Dinsmore, 11 o'clock. What are you doing now?
What's that?
What are you doing?
Well, Miss Dinsmore is not here,
Oh,
but yeah. And she has some memory issues.
probably transportation issues too.
Yes, so I'm trying to get her on Zoom because I do need to refer her for help.
Okay,
Oh, okay.
So, okay,
just let me know.
okay.
Cause isn't she like on Saginaw?
Something like that, we'll have to be able to transport her or get her to my office.
What's the charge?
Accommodation.
Ugh, they got a complaint? Family too, I'll bet.
Sort of.
Yeah, she's in Waterford. Is she the one?
I think so.
You want my wife to bring you something to eat? I just told her I was gonna make it home for lunch and she's offering.
Oh, I don't know what I want.
I don't know, what do you want?
I don't know, cause you're probably not eating.
I wasn't going to.
I know,
but-
so your wife's being nice.
Yeah.
Oh, thank you.
You sure? I'll just tell her to surprise us.
Oh, wait, you wanna keep that? Yeah. Probably better than my order. But I think she's the one. She.
Probably. I know that her memory issues came up in the past.
Yeah.
So I'm trying to get her on, but I'm gonna try to call her again.
Oh, thank you.
Well, if it's almost family,
True.
I was pretty upset. I don't think I'll have any of that on the phone. Oh, I'm sorry. Would you like my wife to bring this? No, I don't see.
She just wasn't.
Well, I'm just looking to see when they set the complaint, that when they approved the complaint.
In 2015.
Oh, it's literally they pick around on it.
She literally, nothing has been done since March of this year.
Yeah, it was authorized January 15th. She's probably out of state or something. Yeah.
You know, I mean.
Any ideas?
Supposedly logging in now.
Okay.
You know, something like that. And
Yeah.
yeah, maybe I should. Wrangle some more.
Let them know that my exams are starting at 11 and it's now 12.
Yeah, we got 2 at noon with Mr. Ignati that are synopsis.
Council said Dinsmore's supposed to come on soon.
Yeah, but you want to go.
Mohammed is acting more frazzled than normal today. Doesn't seem like it's very contentious.
Yeah. Dale Pearson.
Who's been sitting in here for an hour, now he's gone. Who's been sitting in here for an hour, now he's gone. What are we doing, guys? Are we holding? Okay.
No.
All right, appearances for Gillikin, am I saying it right?
Yes. Good morning, Your Honor. Mohammed on behalf of. Good morning, Your Honor. I'm Brian Baker on behalf of Mr.
All right. So, gentlemen, I'm waiting for a lady to come in on Zoom, and when that happens, I'm going to stop you so we can take care of her. Don't go away. All right, I'm ready. Call witness.
Judge, can we ask for a mutual order of sequestration? I also want to make a record with regard to a discovery update.
Sure. We got anybody in the courtroom that is a prospective witness?
Judge, so yes, I was gonna also join in the mutual order of sequestration. Stacy English is gonna be the first witness, and so she's in here.
Okay.
Hi.
Nobody else in here? Hold on, one at a time. No other prospective witnesses here?
Not from our side, Judge. We do have a couple of people here, but.
Okay, then you're satisfied with the courtroom as it is?
Judge, I'm gonna ask for acceptance of the officer in charge, Dale Harris.
Granted. Granted. All right.
The only other thing with regard to sequestration is I don't know if we have a full Zoom panel on, but I did see in the previous time there was an observer for the Gilligan case who was unnamed.
I don't see anybody now.
We just don't know who might be able to.
Yeah, yeah, everybody right now is accounted for. All right, and then you wanted to say something about, what's that? Yeah. Yeah. Well, yeah, you understand we're live streaming, so I don't know who's watching YouTube.
Fair enough. I do understand. Well, hopefully they heard what you said there.
Aren't you nice? Go ahead.
Anyway, Your Honor, there is a discovery update at, yesterday evening, just before 6 o'clock. I did receive 2 new, Axon emails with links to videos. Videos are one of the issues that we've been, discussing between Mr. Mohammed and myself. Many of the videos that I received, I didn't count them all up, and frankly, didn't get time to watch them all. From what I've seen, there were mostly videos that I believe we already have, if I'm not mistaken. There were 2 videos from Officer Valevska that are new. Neither of them are the ones that we were looking for. There are 2 very short snippets that we received. The ones that we're looking for, and I was just telling Mr. Mohammed and Detective Harrison, are one where she approaches the property, Mr. Gilligan's property, walks up to the driveway and sees the pellet gun at issue resting against his Ford Bronco. She recovers it, places it in the trunk of Sergeant Stanton's car. So that's something that we're looking for, the key piece of evidence being recovered. The other one is when she returns to the English's home and picks up their completed written statements. I have video where she drops them off. I have video where she is coming back to the house at about 11:06 a.m. with the completed statements already in Miss English's handwriting. I can see in her hands. She comes to clarify a few questions and have her answer some questions that she's handwritten on the sheet. What we're missing is where she goes and actually picks up the statements from them. So we do have her under subpoena. I can ask her today about the use of her body worn camera.
Mr. Muhammad, I don't think he's disputing. I'm stipulating, so the defense's request, I think he's entitled and should receive all the body worn cameras associated with this case. So if there's any kind of ordering sound, no, I just send the request to OIC.
Understood. Understood. So you can submit a stipulated order when it's convenient to do so.
We do have one, there's other ones too, like there was one from Officer Short.
Okay.
That missing.
But I'm holding an exam today, right? So any discovery issues you guys have, it sounds like you're going to stipulate, and if you don't, work it out downtown, because none of them are going to stop our exam today. Okay, well, if you don't go downtown, I guess it's all moot anyhow. So let's call a witness.
Thank you. The people called Miss Stacy English.
Miss English, come on up. You're all the way up front, ma'am? Yeah, watch your step on my ramp. Before you jump in that chair, raise your right hand for me. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth today? Settle in. English like it sounds?
Yes.
When you're ready, Mr. Muhammad.
This English, can you please restate the name of the record and spell it?
English.
Okay, I'm gonna ask you to speak a little bit louder because these microphones have to record what's being said.
Yes, sir.
Thank you. Okay, Ms. English, I'm gonna take you back to the date of November 17th, 2024. Did something occur at or near the location of 40127 Rob Road? And for the record, that's spelled ROB Road.
That's correct.
Was that located in Van Buren Township, County of Wayne?
Yes, that's correct.
What happened at that location that drew your attention, if anything?
My neighbor got a little pointed a gun at me, where he was standing on our property. So.
Okay, again, ma'am, it's very difficult to hear you. So you
Oh, sir,
have to
yes.
speak loudly.
Okay.
Hold on, hold on, ma'am. You can probably pull that mic a little closer to you, and then you don't have to
Thanks.
sit up, probably comfortable and pull. Go ahead.
Yes, my neighbor had me pointed a gun at me and was a my former little son. He was pointing into our kitchen window. At the time, he was standing on our property. So the address would be 14310 Road. But the address initially was this address.
Okay, and you indicated you were holding your son?
Correct.
What is the name of your son?
Theodore?
Okay, and you indicated that a gun was pointed in your direction?
Yes.
At you. And how did you feel in that moment when that gun was pointed at you?
An initial shock. However, I was slightly prepared for it because there were actions leading up to this that made me think something might happen. Including he had his branch and chainsaw over his head, within the 10 to 15 minutes before this. And he also did this gesture directly at me.
This is now the other.
Yeah, it is a little bit narrative. Let's stick to question and answer.
I'm sorry, can you repeat the question?
Yes, so I'll change the question. So did something happen leading up to the pointing of the gun that drew your attention?
Yes, so, yes, I was feeling. Luckily I was prepared because I remember telling my husband, if he gets a gun, we need to call 911.
Check.
Any response? Well, she testifies as to what she said. So that's okay. Go ahead.
Yes, he pointed the gun at my son and I, and initially was shocked, but then I quickly,
What actions occurred prior to the gun being pointed at you that made you feel prepared? You indicated you felt.
yes, I had already told my husband, we'll need to call 911 if he does anything crazy that it's a weapon, and he had already done this gesture too. So,
Okay, Your Honor, please let the record reflect that the witness is taking two fingers, taking it to her eyes and then pointing it away.
Yeah. Universal gesture, meaning I got eyes on you.
Yes.
All agreed? All agreed?
Yeah, I didn't see the gesture, but I was.
You agree that's what that means? Okay, thank you. Okay, once again, we're getting into telling stories. Let's stick with questions and answers. You're all right.
Okay, but when he did the hand gesture, it was at your direction?
Yes, that.
Okay. And I guess my follow-up question is, again, how did you feel when that firearm was pointed in your direction?
Terrified.
Okay, and what did you do after that firearm was pointed in your direction?
So I told my husband.
I object to, I apologize for the late objection, I'm objecting to the term firearm, it has not been established that there's any firearm.
Okay, I can rephrase it.
Okay.
What was perceived as a gun, what did you do after that the alleged gun was pointed in your direction?
I took my son to our living room, which because there's a wall. So I had to protect, and I was laying behind the couch and I told my toddler to come. So I could put it in my head.
Okay, why were you hiding behind the couch?
She wanted to shoot us.
Oh.
Sorry.
No, it's okay. Wait.
Joe. Jackie,
And then my husband called 911 and we were, he told
Did
us.
you tell your
he told us-
Did you tell your husband to call 911? Why didn't you tell him that?
But I don't think it's gonna shoot us. So we're working.
Okay. The gun, can you describe it?
It was long. I tried thinking about detail, like I couldn't tell you color or anything like that. It was long. It was.
Was it a handgun? Was it
No.
a rifle, a shotgun?
I had no guns.
Okay, can you describe the length? You said it was.
It was
long.
a longer gun. That's what all that registered. One gun.
Okay, so a long gun.
Yes.
Okay. Now, this individual that pointed this long gun at you when you're driving, you see this individual in the courtroom? This
Yes.
individual in the courtroom today?
Yes.
Can you please point to that individual and point out an article of clothing that person's wearing?
Yes, he is wearing a white shirt.
Can you point to that individual?
Yes, I did not know his last name until this year.
Your Honor, please let the record reflect the witness has identified the defendant and no further questions.
Noted for the record. Mr. Prane, your witness.
thank you, Your Honor. This initially afternoon, I think it's afternoon, right?
It's always afternoon somewhere.
I may have seen you here at Corporal, but we've never been introduced, correct?
Correct.
All right, my name is Brian, I represent Adam Gilligan in this case. Adam Gilligan is your neighbor, right?
Correct.
And his house is adjacent to yours, is that a fair description?
Yes.
The back of your house, or let's say it this way, your house is to the east of his, correct?
My house is southeast.
Right, because his house faces north, right? Your house faces east, correct? So a section of your backyard abuts to his backyard, right?
Yes.
The rearmost or the southernmost portion of his backyard, right? You moved to Rob Road when?
21.
Okay, now, you don't really know Adam Gilligan very well, do you?
No, I do not.
In fact, you don't really know him at all or anything about his life or him as a person, correct?
Yeah.
Okay, you said before that you had one interaction with him previously, right?
I believe it was 4.
All right, you remember
Very, very
telling,
no.
you remember speaking to the officer on November 17th?
Yes.
Okay, that was Officer Valevska. Do you recall her name?
What was her name? Is that the same officer?
It was a female officer.
It was the officer.
And you recall saying, that you only had one interaction with Mr. Gilligan before, correct?
That would not have been true, but because I have had 3 or 4.
Well, you remember saying you only had an interaction with him because his chickens got into your yard?
Yes.
Correct?
Yes.
So you said that first, and then later on you talked about a property dispute, right?
I wouldn't call it a property dispute, but sure.
Several times throughout your interactions with the officer, you complained about Gilligan, which you claimed encroaching on your property, right?
His chickens, sure, I wouldn't call it complaining, I was just, that's obviously not something I feel about this.
Several times.
But
My apologies.
that I was just letting her know that that's the only share.
All right, several times when you brought that up, right?
Okay, perhaps, I
True.
didn't recall it.
Okay, well, you do,
Okay.
even though you don't know Mr. Gilligan, you already formed some ideas about him, right? Prior to that day, correct?
Yes,
Right? Because you said that, you told the officer that you know he has a history, right?
yes.
What type of history did you know that he has?
I know that he has.
I'm talking, and I apologize, I mean, on that day, what did you know?
On that day, oh, sure, on that, okay.
Yes.
On that day, I had known that every time officers come to his property, there's always 4 or more police officers called to his property. Everybody on our street knows that information and is alarmed every time police are called to his residence, which is frequently in the last few years.
And you'd agree that gives you an impression about him before you ever met him?
Certainly.
Okay, and in fact, what you told the officer is you know that he has a history, but you don't know what extent, right?
Correct.
You know details, correct?
I didn't know the details, sure.
Okay.
I grew up on the road, I lived there since I was 2 years old, and my dad lives down the road, and Mr. Gilligan had bragged to my father how he set me responsible.
Well,
So yes, I have.
I object to that hearsay.
Okay. Sorry.
Noted.
Ask me, so I'm letting you know everything that I know.
Well, the fact is, people had told you negative things about Mr. Gilligan,
Yes,
correct? And you were bearing those in mind on this day, correct?
of course. Yeah.
Exactly, how could you not? Just like if I told you that we're gonna meet a friend of mine, but you should watch your purse because he's a little shady, that would color the way you see that person, correct?
Sure, that's fair to
You
say.
would agree that happened with regard to Mr. Gilligan, right?
Yes,
So you said that you saw him, you claimed that he pointed a gun at you, correct?
yes.
Um,
I know he wanted to do this.
that is your claim, correct?
That is all that he is.
You were home with your husband that day and your 2 children, right?
Yes.
Your children, to your knowledge, don't claim to be witnesses to this, right?
I don't know.
And your husband does not claim to be a witness to this alleged crime, correct?
See, I'm pointing the gun at
Okay.
us certainly.
In fact, you say that he was at the stove, correct?
He being the husband.
Yes.
I don't believe he was, I don't believe he was at the stove when Adam was pointing a gun at me directly. I believe he was in a different room. But I don't recall that specifically.
So if he said that to an officer, that's not how you remember it, correct?
Can you repeat what you're asking?
If he, your husband, let's identify, so your husband is Kevin, correct?
Yes.
If your husband, Kevin, told an officer that he was at the stove during the alleged incident and didn't see it because he was cooking, that's different than the way that you remember it, correct?
Sure. Yes, yes.
By the way, you have, friends and associates in law enforcement too, correct?
Objection, relevance.
What's relevant?
The relevance would be to show bias in motive, judge. If she has partiality, a professional or personal relationship with anybody in law enforcement, then I think that's relevant.
Judge, that is totally inappropriate. My dad's a physician, so does that mean every question that's related to medical makes me biased? Absolutely not.
Judge, is that
We'd have to inquire about your relationship with your father.
I'm sorry?
We'd have to inquire about your relationship with your father to answer that question.
Well,
I agree it's not relevant. It assumes that just because she knows law enforcement officers, she's going to lie about an incident.
Well, not that she would lie. I'm not necessarily making that assertion.
Given the fact that she's not making allegations about a law enforcement officer, it's not relevant, so move on.
Do you know any of the officers that responded to your house on November 17th?
I didn't know, but I didn't.
Had you ever met any of them before?
No.
Do you know anybody that knows that?
No.
Do you have a brother that's a police officer?
objection, relevance.
Not relevant, move on.
You said that you only saw Mr. Gilligan for a second, right?
When?
When you claimed that he pointed, what you believe was a gun at you, you said it was only for a second, right?
In that moment, yes, because once it registered.
I'm not asking why, just my question is you saw him for a second, right?
Yes.
And then you said you quickly took off and went to another room, right?
Yes.
Okay. You told us today that he made a eye gesture, right?
That was prior to him having a gun.
That was prior, how much prior?
I'm not certain, but I would guess around 5 minutes.
Okay, would you agree that when you explained it to the officer, you stated those 2 events, pointing the gun and the eye gesture, to be at the same time?
I don't know what I don't remember this almost half a year ago.
Okay,
I don't remember.
you agree that your memory of the events in question were better, fresher on the day of the incident, right? Okay.
Mr. Prane, I hate to do this, but this is kind of a unique situation. I've got Ms. Dinsmore on camera.
I'm sorry?
Counsel, you want it? I got Dinsmore on camera. Well, I'm just gonna take a break. Are you okay to sit there, ma'am? You all right?
People have no objection to the defendant's, for the defendant's request for the competency. Is it okay if I go?
Yeah. Ms. Dinsmore, are you there?
Ms. Dinsmore, can you touch your screen and hit the little microphone button to unmute?
You want to just try to do it on speakerphone?
I can try to. Well,
Yeah, I'd like to accomplish something.
hi, is this Ms. Dinsmore?
Yes, it is.
Ms. Dinsmore, this is Attorney Nancy Richards. I have you on speakerphone in front of Judge Oakley. Can you state your full name?
G.D. Dinsmore.
Thank you, ma'am. Can you hear me all right?
What, can I hear something?
Miss Dinsmore, can you hear me all right?
Yes.
This is Judge Oakley. Thank you.
My phone's about to die. And Judge, today is a preliminary examination date. My understanding is the people are ready to proceed, but after speaking with Ms. Dinsmore this morning, I feel it necessary to refer her for competency.
No objection.
So ordered.
Thank you.
All right, we're back on the record on the Gillikin matter. I'm sorry for the interruption, ma'am. Mr. Prane, if you can figure out where you were at in your stream and pick up.
Sure can. Okay. This was early in the morning, you said this happened, correct? Would be like sometime around 8 a.m. be about accurate?
Yes.
Okay, so the sun is rising to the east and anybody looking at the back of your house has got the sun in their eyes, right?
No, it was the summer, I should probably be watching it, considering what time here is snow.
It was a sunny day that day, you recall, right? Very sunny.
It was, yes, it was Sunday.
Okay, well, you just told the court that the weather will be blocking the sun, so I just want to make sure it was a sunny day.
Honestly, you know, I'm sorry that I said it was a sunny day. I honestly don't remember what the weather was like. I should have said it.
Okay, so
I don't recall.
I see.
Sorry.
If I was to show you, you said that he was standing toward the back of your property, is that correct?
Yes, he was on the southwest corner of my property.
Okay, do you think if I showed you a map, like a Google map, you could like identify your property?
Certainly.
Okay. Let's show them this. All right. Can we do A, B, C, D for defense, Your Honor?
Heather, how you doing?
Okay, I'm gonna mark this as defendant's proposed exhibit A, may I approach, Your Honor?
Yeah.
All right, what I have here is a map. Do you recognize that?
Yes, I do.
Okay, is that a map that shows both your property and Mr. Gilligan's property?
It does.
All right, and if I give you a pen, would you be able to mark the location where you say that Mr. Gilligan was when you say that he pointed the gun at you?
I can estimate, however, the trees that was the very.
Okay.
We have a fence line, and we also own property that goes beyond the fence line, closer towards just a little bit right. There's actually a rusted older fence in the ground that people can trip on, it's actually a hazard. But it remains, and then so it's somewhere in this chain.
But
Yeah, and I understand, just for the record, Judge, the map that I'm showing, Miss English has trees on it. And I take it in November, the trees were not thick, right?
no.
Okay, well, Google didn't have a picture of that, but you know, generally, can you show us where he was at?
Yes, generally. Right here.
Could you mark an X where you say that he was standing?
My house is.
Understanding that it's not exact, I just want to get a general idea of where you would say he is.
Here has a property that goes back east as well, so it's like the corner.
Yes, his plot doesn't go all the way back, does it? Okay, you remember saying before,
Roughly in.
okay, and you've marked an X and that's where you say it roughly was, correct? So this would be to the northwest corner of the back of your property, right?
This is the southwest corner of my house.
Okay, would you tell us which house is yours, please?
Sorry. Well, actually, that's somebody you asked me. My name.
Sure.
This is my house. I was thinking this was stars.
Okay,
So then. He was further south than what I initially needed.
so would you say that he was basically due west from your back window that you were at?
Yes.
Okay, and I'll show you. Were you in the, what window were you at when you say that he pointed the gun at me?
He wanted the gun at me. That was.
Okay, did you ever say that he pointed the gun at the house and not you?
Potentially, sure.
Well, you'd agree that's a different thing, right?
Oh, yes, I agree with that.
Okay, so if you said the
He
house,
pointed the gun.
okay, that's what you say now, but you just told the court that you previously said you pointed it at the house, right?
He did that as well, but the threat was that he wanted that and he made the gesture. I'm looking at you.
Okay, so you told us that he made that gesture 5 minutes before pointing the gun?
Roughly, yes.
Okay,
Probably 10.
so you're looking out your, what window were you at when he made this gesture?
I was at my sliding glass door, which is next to the beach.
Okay,
So that he had a full view of me.
okay,
I was
so
next.
he meant,
I had a full view
okay,
and I was at sliding glass.
and you told Mr. Mahama that there were things that he was doing that concerned you, right?
Yes.
One that you mentioned was that he was using a chainsaw, right?
And branching over his side, yes.
Okay, a chainsaw, have you ever used a chainsaw before?
I have not.
Okay, you've seen people use them, though, right?
Yes.
You know that they're using cut branches, right? In fact, you told Officer Valesca that he was using it to cut a branch or a tree, right?
He was.
Okay, and so that would also be known as using a chainsaw for its intended purpose, right?
At points, sure, he was. He also sheared after chopping down a very tiny tree that had a maybe 10-inch diameter. And was shearing after that, and then I thought like physically I saw his body, and then he brandished a chainsaw walking up and down our property. And
When you say brandished, is that another word for he held it?
yes, and made strong motions with it in the air.
Okay, so when you say that he cheered, you never said that, right?
I don't know if I said that.
Okay,
Some of it, perhaps.
what has surprised you today is the first time that you've ever said that?
No, it was.
Okay, so,
Besides,
I'm sorry?
besides there. Oh,
Okay, so you're telling us that you've gone to therapy sessions to discuss this
yes,
thing? Oh, I see, okay, and how long have you been doing that for?
roughly since January.
Okay, and is that through is that for something that deals with just this incident?
Correct, I never been there before.
Okay, and when did you start doing that?
January.
Okay, well, who do you see for that?
Should I be answering all this? Sorry, I prophesied on it.
No, I'm gonna object, that is it.
Where's it relevant where she's going?
I just want to know what type of therapist is. This is the first time we've ever heard anything like this.
Why is it relevant?
Because, there's.
I think if anything, it only shows that this incident was a more traumatic incident and that it.
Well, do you want it to be relevant or don't you? What's the relevance?
Judge, she mentioned it in response to my question, so I think she kind of made it relevant because my question was, you've never mentioned this before. She told us that there are basically things she's mentioning for the very.
I was here, Mr. Prain. I heard everything that she said. I want to know why it's relevant where she's getting her therapy.
The relevance is that new facts that were never stated to the police are apparently coming out in therapy sessions, so I think we need to figure that out.
It just came out in the courtroom.
I'm sorry.
It just came out in the courtroom.
Well, she said it
Today.
Therapy.
Move on. It's not relevant. It's probable cause here.
Understood, correct. You remember when the police officer, your husband called 911, correct?
Yes.
Where was he when he called 911?
Where was he?
Yes, were you together with
In our
him?
home, yes.
Were you listening to him call 911?
For only part of the call, the he's trying to sit over the basement.
All right, did you tell somebody that Mr. Gilpin was wearing a jumpsuit?
It appeared that it was the same, it appeared like the same color, like a all white. Well, so I don't recall calling it a jumpsuit.
Okay, you don't use that word?
She just said she
I
doesn't
don't
recall.
know.
Okay. Well, was he wearing a jumpsuit, if you remember it today?
Sure, I wasn't close enough to know if it was a jumpsuit or not, but I saw him on camera and he was at the elevator police department, and it appeared to be a white shirt with like over shorts.
You saw him on camera?
I don't, yes,
All right, you remember the officer arriving at your house, right? Female officer? You now recall it was Officer Valesta?
it was done her name that I said, I don't know if we're talking about the same.
You only spoke to one officer, correct?
I believe so, yes.
She left and came back to your house several times that day.
Correct.
You made a lot of statements to the officer, correct?
Yes,
Okay. One of the things that you told the officer is that you woke up because you heard loud music, correct?
I did not wake up.
Do you remember making the statement, so we woke up because there was blaring music over there, do you recall?
My husband did.
All right, but those are your words, do you recall that?
Okay, I did not wake up. I did not wake up.
Okay, did you wake up, was that statement true to the officer?
If I said that we collectively, I think, that's when my name first woke up in the morning.
Okay, but you said that you woke up because you heard music, is that right?
I heard music, but not just like I.
Okay, as a matter of fact, there was no music, was there?
I sleep with
Objection.
a.
Hold on. Ma'am,
Judge, she answered the question. She said that she heard the music, she heard music when she went downstairs. I don't know.
yeah. As a follow-up, there was no music. Doesn't make sense.
It wasn't music that you heard, it was actually political commentary, right?
I have no idea. I have no idea.
Okay. All right. Well, maybe I can do the same thing here, but what he was actually playing was conservative political news, right?
Okay, I don't know.
Do you recall that?
No,
All right, you thought that you heard music, correct?
correct.
Do you remember you and your husband making statements to the officer about political things and Adam celebrating the election
Yes,
and how that upset you guys?
yes.
That was just prior to this
We
incident,
had
correct?
explosions in the middle of the night, and we haven't been in the top. Yes, it's frustrating.
Well, you heard explosions in the middle of the night?
Election, yes.
Okay, you never said that before, right?
Well, I don't know how I described it, but that's,
Well, you and your husband claimed to the officer that you heard air horns, correct?
yes.
The fact of the matter is, politics is something else that you and Mr. Gilligan differ on, correct?
I would imagine.
I'm gonna object. I don't see why that's relevant.
Sixth Amendment confrontation bias, Judge. We're allowed to exploit it.
It's a stretch.
You described Mr. Gilligan as parading in his yard, correct?
Yes.
Okay. And I noticed that you're smiling. This isn't humorous to you.
It's not humorous at all.
Okay.
I'm sorry. I'm thinking about, I'm thinking about the.
That's argumentative.
You said that Mr. Gilligan started parading his yard, right?
Correct.
That's the word that you use, correct?
Probably.
Also known as walking, right?
Enthusiastically and angrily.
And
Yes.
you're saying that you can look at how he was walking and tell him how he was feeling? Is that what you're saying?
Why don't we do it this way? What did you mean when you said he was parading?
What I meant was that he was vigorous when he was walking. He was swift and aggressive and appearing to be angry.
I assumed that from the chainsaw that he was waving over his head and the way that he was almost thrashing his body at certain times.
Do you remember making a specific statement to Officer Gillespie that you did not see the chainsaw as any threat?
Initially, I probably did not feel that way.
Well, that's the only thing that you said. You said you felt no threat from the chainsaw, correct?
I did not feel it at that moment. I
I'm not
did
asking,
I did
I'm
not.
not asking you to hold the officer.
I don't know. It was 6 months ago.
Okay, yeah, I mean, guys, seriously, ma'am. Okay, I know you've got a story. I know you want to get it out, but we can't have all these voices at the same time. It's just a mess on the record. Everybody take a deep breath. Ask your question again.
Thank you. All right, the question that I was asking is, do you recall telling the officer you felt no threat from the chainsaw?
In the smoke, do I?
Ma'am, it's a yes or no. Do you recall? Yes or no?
No, I don't.
Okay, today you told Mr. Muhammad that the chainsaw was a precursor that let you know something bad might happen, right?
Correct.
The chainsaw, according to your testimony today, was ominous, right?
The chainsaw let me know that you should be looking at this behavior in case something escalates.
So before anything ever happened with the alleged gun that you say that he supposedly pointed at, you're already telling your husband, we might have to call 911, right?
Correct.
Because of the chainsaw, right?
Because the chainsaw and him doing his gestures.
Judge, it's on the record, but doing the and
I got eyes on. Record reflects.
okay. Had you when your husband called 911, were you in the same room as him?
I don't believe so. Our rooms are connected. So we have a dining, a kitchen, and a living area that are separated by a small wall, but they all flow into each other. So we were all on the same.
Right. My question was, when you called 911, were you in the same room?
It could have been in the same room, yes, and then my husband went to look out the window while I was staying.
Okay. Are you saying that Mr. Gillikin was on your property when he allegedly pointed what she claims about you?
Yes,
Okay. And you say that because he was on his side of your fence, but your property extends beyond the fence, right?
yes.
Okay, the fact of the matter is, you and Mr. Gillikin had discussions about where the property line was, right?
I don't recall.
Well, do you remember telling Officer Gillespie that that was something that you specifically had a conversation with him about when he moved in?
I remember us talking about a dangerous fence line, and I was wondering if it was Metro Park or not.
Well, your property doesn't, Metro Park, does it? Neither does Mr. Gillikin's, correct?
Yes, it's.
Actually.
Oh, wait, I'm sorry, he has that one small stretch.
You were telling the officer that he's encroaching on the
It
Metro
feels
Park,
that way
right?
because it is.
Okay, good.
Yes.
Property is something that you, ever since you guys moved in, you and Mr. Gillikin have had property disputes, correct?
No, I would not call him property.
You told Officer Gillespie that he was encroaching on your property, right?
I believe what I shared with her, which I will share with you now, is that when we first moved in, we had chickens that would come on our back deck, and we have dogs. We did not have a fenced in yard at that time. We now have a fenced in yard to keep our dogs in our yard, so they're not tempted to chase chickens.
Question was, you told Officer Gillespie that there was a problem previous to this date with Mr. Gillikin supposedly encroaching.
I don't recall, I'm sorry, I don't recall specifically what I told.
Well, did he
That's
do
okay.
that? Did he do that?
Did he do it?
Encroach on your property?
Call 273 and tell me.
His chickens came on our property.
But not him.
But not him, but on this instant. Yes, we had a gun.
Here it is.
Did you ever, you said that you saw Mr. Gillikin pointing what you believe to be a gun at your house, correct?
Yes,
Did you see him pointing anywhere else?
I saw him pointing at me, and that is what. And then I left.
But my question is, do you recall seeing him pointing at anywhere else?
I recall him pointing with his fingers at other houses. I did not recall. My brain retained the information that he pointed at his. And then I left.
Well, you said something different before, right?
I don't, what are you referring to?
Do you remember telling Officer Valevska that you saw Mr. Gilligan pointing the gun at other houses? You didn't see that, did you?
She just said she didn't recall that.
She said she didn't recall saying it. I wanted to ask you, do you recall?
I don't recall that, but
Well, did he do that?
what? The trauma response, and
I'm not asking why you recall it different. My call that he did that. Did he point the gun at other houses?
I saw him pointing the gun at me. I saw him pointing his fingers at other houses.
But not the gun. Thank you. Officer Valevska had you write a statement, correct?
Yes.
She showed up with a piece of paper on an official form. Yes. And told you to write down what you saw, correct?
Yes.
You wrote it out and you gave it to her. True?
Correct. This
You wrote it
was within an hour of this.
right at your kitchen table, right? She was in there with her. Did you know that you were on body worn camera?
At the time, no, I did not.
Okay. But you wrote up the statement, you gave it back to her, correct?
Yes.
And then you expressed some concerns. You said, I don't know how he's still able to own guns, right?
Yes.
Now, you did not, do you know what type of item that he had in his hands that you said that he pointed at you?
No.
All right, did you ever learn what it was?
Supposedly it was a fake firearm, correct, or a pneumatic weapon, which I have no gun knowledge.
You don't have, okay, so you don't have gun knowledge, but you saw something, right?
I mean, yes, I saw a gun.
Okay. And you made the statement to Officer Valevska, I don't see how he's even able to own guns, right?
Yes.
But you've told Officer Valevska before that you didn't know the extent of what issues you claim that he might have, right?
Correct.
Okay. Officer Valevska is the one who told you that it was a pellet gun, correct?
Yes.
And she made a statement to you. I mean, at this point, obviously with your statements, we're first trying to figure out if we have a crime or not. Do you remember her saying that? Okay. Do you recall that you and your husband were upset because Officer Valevska was suggesting that maybe a crime wasn't committed?
No, I don't.
Do you recall her saying, we're first trying to figure out if we have a crime or not? That's why I needed your statements or not. But you guys, I've only made contact with him once prior. Right? Do you recall her saying that?
I do not.
Okay, do you remember a conversation where your husband was particularly upset because Officer Valevska was saying that there was not a crime committed? Or was suggesting that there may not be a crime committed?
Yes.
Okay, do you recall something about that?
No, I don't.
Okay. As you were, do you remember anything that your husband said to Officer Valevska?
I remember him explaining how he used to was just like the basics of what was going on. You know, like having to be born, nursing at some point in this morning, our toddler running around, having our own music playing in the house, having, you know, like those details of just like, there was a lot of.
As a matter of fact, when Officer Valevska said, we don't even know if we have a crime or not, your husband tried to convince Officer Valevska that there was a crime, right?
I just really don't recall
You
that.
don't
It's
know?
not- No.
Okay.
I also know that
Okay, there's no question on the floor.
A gentleman, as you and your husband are talking to Officer Valevska in your dining area, a man walked through your rear sliding door, correct?
Yes.
That was your father, right? Did you invite him over?
I actually, no, I texted him that we were in our basement.
He lives down the street?
Correct.
So all of a sudden, he showed up and started talking to Officer Valevska, right? Officer Valevska, up to that point, had said she really didn't know anything about Mr. Gilligan, right?
I think that is most fair to say. I did not even know the man's last name.
Adams West, right?
Correct.
Okay, so, you recall Officer Valevska, saying, I mean, but regardless, like you mentioned, like whether or not a crime has been committed.
if you're making a threat, excuse me, I apologize, I have to withdraw that question. That was your husband made a statement to Officer Gillespie in the presence of your father. Call him saying, I mean, but regardless, like you mentioned, like whether or not a crime has been committed, if you're making a threatening gesture, to me, that's a crime. You recall your husband saying that to the officer? All right. Your father also made statements about Mr. Gilligan to the officer, correct?
I don't.
Negative statement.
Sir, I do not.
Well, what if I said that your father told the officer that Mr. Gilligan was attempted on suicide?
I don't know if that's factual.
Right. But that's what was said, wasn't it?
I don't know if that was said. I don't recall this conversation. I do recall having to breastfeed my son. He's crying. He should have had a nap like 45 minutes prior. That's where my brain was.
Officer Valesa told you that the issue of whether a crime or not was going to come down to what other neighbors, right?
Can you repeat that?
Yeah, Officer Valesa, after saying there wasn't certainty whether there was a crime or not, told you and your husband that whether or not a crime had been committed might come down to what neighbors had to say, other neighbors, right? Do you recall that part of the conversation?
I don't.
You don't recall?
I got to stop you, Mr. Crane, because I've got a lot of exams scheduled today. I'm not sure how any conversation between this lady and the cops after the alleged incident is relevant for a probable cause hearing.
The relevance, Judge, is that they weren't stating something that was a crime and that it evolves into statements that give them what they believe is probable cause to arrest. And that's where this is going. I apologize for.
So you want to attack the probable cause for the arrest?
Well, I understand that probable cause to arrest and probable cause here are a little different, but they're both the totality of the circumstances. The point that I'm making, Your Honor, is that initially, even the officer on the scene is saying, we don't know if we have a crime. And then people become upset about that, and then it becomes.
That's nothing that's going to be judged today. The only thing I'm going to determine today is there's a reason to believe that there was a crime committed, and there's a reason to believe that your guy was involved. And if those are both with yeses, you're going downtown. So whether or not the cop on the scene was confused or not confused doesn't change anything. All might be great stuff for the trier of fact at a jury trial or a bench trial, but the probable cause hearing, I've got a very low burden that the people have to meet. So attack that.
Did you, Miss English, go and speak to any neighbors while the police officers were at your property?
No, I did not.
Did your husband do that?
I don't know if they were at this property or not, but yes, my husband had a conversation.
After speaking with Officer Gillespie, your husband went out and talked to a bunch of other neighbors, right?
He talked to a few.
And once again, I've just tried to explain nicely why I don't think that's relevant. So now I'm going to quit being nice and move this damn thing along. Let's talk about what happened leading up to and at the time of the alleged threat, because anything after that, I don't really care today.
Oh,
clear enough?
I do, but I just.
There is no I do, but.
Okay.
It's I do, Judge. I'll follow that directive.
I understand. Did you have the understanding before this investigation by Officer Gillespie was finished that yours and your husband's cooperation was going to be critical as to whether or not Mr. Gilligan was charged?
Not relevant. Not relevant. I'm going to give you one more shot, and then I'm just going to kick you out of here and make my decision before you're done.
All right. I'm sorry.
What happened after the alleged pointing of the weapon, I could care less about.
It's when the statements changed. That's all.
It doesn't matter. It doesn't matter, because the only way this is not getting bound over today is if I think this woman is completely unbelievable.
Right. Do you recall that did you believe, as this investigation, you would agree that they based charges against Mr. Gilligan on statements you made, correct?
I don't know. I don't feel I'm going to assume what they're thinking.
You're the one and only eyewitness to this alleged crime, right?
Yes, I let them know that I was.
I think that question, she lacks personal knowledge to answer that question.
I'll take judicial knowledge. We wouldn't be here if she wouldn't have said something to the cops.
Yeah, and
How do we have a crime if there's no alleged complaint?
I guess my objection is based off of whether or not she's the only person to witness this incident. She doesn't, we don't know who else.
Is that your question? Is she's the only witness?
Well, that's my question right now.
Do you know if you're the only witness?
I am not the only witness to him having a gun.
Well, that's not the alleged crime though, right? Is that he's supposed to have a gun. The alleged crime is that you claim he pointed it at your house, right?
Judge, I'm objecting. How does she know? What if there's a neighbor that's upstairs looking down?
Let's ask her. Do you know if anybody else witnessed the pointing of the gun?
I don't know this.
Yes or no, ma'am?
There was a neighbor that.
Is that a yes?
Yes, there's a.
Okay, there you go.
Okay, did Officer Malevska, after the officer left and you gave statements to the officer, did she come back hours later seeking further statements from you?
I don't know if it was hours later. She came back to get the document that we wrote,
And there was further discussion, correct?
probably.
And your statement, shall we say, improved during that conversation, right?
I didn't go back and add, if that's fair.
Well, as a matter of fact, she wrote down questions for you to answer and you wrote answers, right?
I don't remember this, no,
Do you remember her standing there telling you what to write?
no, she didn't tell me what to write.
Do you recall
Right,
this?
my ID. No. What I was.
All right, do you remember the officer telling you that she was there that she was gonna help you paint the picture? Or use the words paint the picture?
She may have been helping me recall what had just happened, which should not have been, that just, perhaps she was helping me process.
Well, she helped you process it by telling you what to write, and there were things that you had not said, right?
Perhaps, I honestly don't recall going through this process.
One moment, please. Judge, that's all the questions I have.
No further question.
No further questions? Ma'am, you can step down, watch your step. Mr. Mohammed, line up your next witness. Mr. Gozi, come on up. Mr. Gozi, your appearance for Mr. Reeves.
Yeah, the
A waiver, I understand. All right, Mr. Reeves, do you understand your rights and options after discussing those with counsel?
Yes, sir.
Do you understand the purpose for the exam? You understand if you waive the exam, that means the file's going downtown and it won't be at the district court where you stand now.
Yes, sir.
You're waiving that exam freely and voluntarily today?
Yes, sir, Your Honor.
Counsel, you satisfied? So am I. AOI date is May 14, 9 a.m. I need signatures from you two, and then we're going to get you out of here. Say again?
Okay.
Mr. Gozi, where you been? We haven't seen you for a while.
Have been blessed.
To not be here?
No, she manages it, so it's how's that?
Well, it's good to see you.
Always.
You ready?
Judge, for the second, what is people call officer the last?
Valeska, come on up. Officer, watch your step on my ramp. Come on up here. Raise your right hand, swear affirm, tell the truth, the whole truth, nothing but the truth. Have a seat right there. Spell your last name for Heather.
Veledska.
Thank you. When you're ready, Mr. Mohammed.
Thank you. Officer, please restate your name for the record.
Katerina Veleska.
Thank you. Officer, are you currently employed?
I am
Who's your employer?
behavior conscious
And in what capacity are you employed there?
police officer.
Okay, were you employed in that capacity as a police officer on November 17th, 2024?
Was.
Did you work that day? Did you work that day by yourself or with a partner?
Bonus.
Okay, and on that day, did you work in full uniform or modified?
Full uniform.
Okay, and on that day, did you operate a scout vehicle or did you work full patrol?
No, I patrol.
Okay, was that vehicle fully marked or semi-marked?
Fully marked.
Okay, your duties as a police officer on that day, November 17th, 2024. Taking at or near the location of 40127 Rock Road. Is that located in Van Buren Township, County of Wayne?
Yes.
Okay, what took you to that location?
I was dispatched in.
Okay, what was the nature of your dispatch?
The call was a caller, neighbor call regarding their neighbor who, had a gun pointed at their residence.
Okay, and when you made that location, what did you do?
All officers, or there was multiple officers that responded. So when I was seeing the other officers, I kind of separated. So I was one officer waiting and the other two officers, when
What did you do?
I just waited till further direction.
Okay, and then what happened next?
Once we were advised that it was secure, myself and Officer Davis walked up to the residence. The apartment residence.
Okay, what happened next?
When I walked up to the residence, then we met with the other officers who were seen. And while I was walking up to the residence, I observed a what looked like to be a long gun just popped up from a vehicle. I actually secured that.
You observed what appeared to be a long gun?
It was
It's a yes or no question.
Yes.
Okay, and upon your observation, what did you do? Did you approach it?
Yes.
Okay, did you observe this in plain view?
Yes.
Okay, and what did you do next after you approached the perceived long gun at that time?
I secured it. I took it,
Okay,
looked at it, and then I secured it.
okay, upon looking at that gun, did you discover anything new?
Yes, it was a poly gun.
Okay, can you describe it?
It was a tan in color with black.
Okay, and you learned it was a pellet gun?
Yes.
Okay. No further.
Mr. Bray,
Yeah.
please.
All right, good afternoon. My name is Brian, I represent Amicable. You and I have never spoken before, correct?
Yeah.
All right, and you were working on November 17th, yes? That was a Sunday?
Don't remember what.
That's fine.
Sure.
You remember being dispatched in the morning, Bill, right?
Yes.
8:17 a.m., correct?
Approximately, yeah.
All right, you wrote that in your report. If I told you that, was you wouldn't get it, correct?
Correct.
Okay, now there was a mail caller saying that someone was in the back of his property, correct?
The call was that a neighbor saw another neighbor in the other property, yes.
Okay, did you write a report in this case?
Yes.
Okay. You write a report, you're full and complete and accurate in that report, correct?
Yeah.
You include all the important details, yes?
Yes.
Did you review it before testifying today?
I did.
Okay, just outside here? Okay, in court here this afternoon? Okay, so you remember saying, that he was pointing, there was an allegation that someone was pointing a gun at a neighbor's residence, correct?
Yes.
Wearing a white jumpsuit, right?
Yes.
Now, there was no jumpsuit, you ultimately learned, correct?
You mean the person that was.
Let me ask you this, somebody, according to your understanding, was saying that he was wearing a jumpsuit, right?
Yeah.
Okay, and a jumpsuit, you'd agree, it's kind of an odd item of clothing to be wearing out in the yard, correct?
Yes, I mean, I feel.
Kind of.
My jumpsuit, that's what it was said, I don't know what, I mean, I know what a jumpsuit is, it's just, yes.
You'd agree that to say somebody's wearing a jumpsuit kind of makes them sound a little maybe crazy or offbeat, right?
I don't know, that's what it was, that's what, that information was given to me, I don't know.
Understood.
Yeah.
You know, there was no jumpsuit, right?
You mean, I never saw a jumpsuit, is that what you're asking?
Yeah, Mr. Gilligan, my client, when the officers arrived there was no jumpsuit.
It was just a white outfit, and yeah.
Shorts and a t-shirt.
Just a jumpsuit, I mean, the jumpsuit is an overall, that's mine, just needing a jumpsuit.
Sure.
So, and overall, that is a jumpsuit So I think that's the jumpsuit, yeah.
Okay, he was wearing shorts and a t-shirt, correct?
I don't recall now.
Fair enough. When you drive to the house, you came in your own car, correct?
Yes.
You get out and you have your rifle, right? An AR, correct?
Yes.
You are staying with Officer Hernandez at the front of the property, correct?
Yes.
Two other officers, Officer Champagne and Officer Short are coming around the back, right?
Yes.
Because they're gonna find Mr. Gilligan, correct?
Yes.
You didn't see what happened back there, right? You just got word over the radio that Mr. Gilligan had been detained, correct?
Yes.
And then you and Officer Hernandez approached Mr. Gilligan's house, right?
Yes.
And it was after Mr. Gilligan was detained, right? When you did that, you wear a body camera on your uniform, correct?
Yes.
When you walk up the driveway, you told Mr. Muhammad you found a pellet gun, correct?
Yes.
Black and tan, right?
Tan, but yes.
Okay, you saw it leaning up against Mr. Gilligan's front, correct?
It was the other front. And I said, "Rock, yes, in the back."
Now, suppose we wanted to see how it was, we wouldn't be able to, would we?
I'm sorry, I don't understand.
I'll withdraw the question. Did you have your body camera working when you retrieved the site of evidence?
No.
Do you have a policy that says that when you're doing something like that, you have to have your body cam working?
Yes.
You turned over a number of other body worn camera videos in this case, correct?
I did not myself.
Okay, someone else downloads them?
Yes.
Would it surprise you to hear that the body worn camera of you retrieving that item of evidence is not provided?
I did it right, so that's not, yeah, I have no control over that, that's,
Okay, let me just ask you this. Do you know if you were using it?
I don't know.
Okay. This was you had never met the Englishes before, correct?
No,
Mr. and Mrs. Stacy and Kevin English, is that right?
no, I did not know them.
Okay, had you ever been to their house before?
I don't recall, no.
All right, well, after you retrieved this item, this pellet gun, correct? And you placed it inside of Officer Stanton's vehicle, right?
Sorry, Stan, yes.
Sorry, Stan, my mistake. You grabbed this with your bare hands, right?
Yes.
All right, so it was not secured as evidence or made safe, right?
No, it was just, I mean, it was, look at it and then I secured it in his vehicle, yes.
All right, did you check to see if it was loaded?
I don't recall.
All right, would that be normal protocol?
It depends on the situation.
All right, did you find out at some point whether it was loaded or not?
I think I knew it was a pellet gun, so I don't.
Well,
I saw it, but
I want to go back. You said you knew it was a pellet gun right away. That's the way.
when I picked it up, yes.
Okay, is it true you had no idea what a pellet gun even was that day?
Possibly, I don't know what. I saw it, I picked it up, I secured it, and my sergeant saw it.
Okay, but my question is, did you even know what a pellet gun was on November 17th of 2024?
I don't recall.
Okay, you were calling it that day a Pelican gun, right?
Pelican gun?
Yes. Do you remember that?
I don't recall.
Okay, you didn't, to be fair, you didn't know what it was, right?
Sure, I don't, like I said, I don't recall right this time, but. He said, Pelican gun, and could be, I mean, I see, maybe I said that, I don't know.
Okay, then is it possible that whatever you learned about a pellet gun, how it operates and what it is, you learned after November 17th, after you cleared that scene?
I never had a pellet gun myself, so I don't know how it's used, to be honest. I thought it was there, I don't know how it's used.
Okay, you know that what crime was Mr. Gilligan under investigation?
At that time,
Yes.
pointing a gun, it's the residence.
What crime would that be?
It's pointing a gun at, it would be assault, aggravated assault with a weapon.
Okay, do you know anything about the elements of that offense at all?
Yes,
Okay, does it require a specific intent?
yes,
Does it require the weapon to be capable or, excuse me, likely
cause serious death or bodily harm?
Yes.
All right. A pellet gun, is that a firearm?
No.
Okay, what does it use? What did this pellet gun use to shoot a projectile?
From my understanding, it's just a for animal use or it's not a firearm.
It uses air, right?
Yes.
And there are different types of pellet guns, correct?
I guess I don't know much about Pelican, but sure.
You received this one into evidence. What caliber was it?
I don't know, sir.
Do you know what calibers they come in?
No.
Do you know what model it was?
No.
Do you know what make it was?
No.
Do you know anything about its capabilities?
No.
And it turned out to be unloaded, correct?
I don't recall.
Did you check it at any time, even if you not initially, did you check to see if it was loaded?
Once I secured it, no, I didn't check it.
Okay, did anybody check it to your knowledge?
I don't know that.
Okay, so you wouldn't be able to tell us who might have checked it to see that it was unloaded?
No.
All right, if it was loaded, would that be an important fact?
Possibly, yes.
Would that be something that would go in a police report?
Yes.
Okay, how many pellets at a time does this pellet gun hold?
Awesome.
Okay, and I'm sure I probably know your answer, but just for the record, how many times is it able to fire a projectile or pellet before having to be broken again and reloaded?
I don't know.
Okay. When you interviewed the Englishes, they told you their story of what they claimed happened, right?
Yeah.
It was your understanding Mr. English claimed that he didn't see anything, right? Excuse me, he did not, Mr. English does not claim to be a witness to any allegation of pointing any item at the house or his wife, right?
Judge, I'm gonna, that's a common question.
Sure, I'll fix that.
Yeah, break it up.
Yeah, Mr. English, you spoke to him, correct?
Yes.
His name is Kevin English, right?
Yeah.
Okay, and he talked to you at length?
Yes.
You wanted to know what he knew and what he saw, right? Okay, and he told you that he was not a witness to this alleged crime, correct?
Yes, at least his wife told him wasn't she was leaving, right?
Okay, so even though he's the first one you spoke to, he wasn't the person who could tell you whether there was probable cause or reason to charge him with crime, correct?
Right.
He did mention that he saw Mr. Gilligan using a chainsaw, correct?
Yes.
You were told by you were told by Stacy English that the chainsaw was not in any way, in her opinion, a threat, correct?
Correct.
So if she said something different, that's the opposite of what she told you, or it's different than what she told you, right?
Is this something that she never phrased it?
Yes, sure. Your understanding was that when you're there on November 17th, 2024, Miss Stacy English is telling you that she saw a chainsaw, correct?
Yes.
As did Mr. English, right?
Yes.
But she told you it wasn't a threat to her, right?
It wasn't near, so yes, it was not with her.
Well, she specifically said the words, "I did not see that as threatening," correct?
Correct.
Did you watch your body cam and get any of your body cam in preparation for your testimony today?
I did not.
Okay. You didn't have reason, you didn't mark down the chainsaw as any alleged crime or anything, right?
No.
She certainly didn't tell you that the chainsaw was something that led her to believe she might soon have to call 911 later that morning, right?
Repeat that again?
I apologize. She didn't tell you that the chainsaw was something that led her to believe that she or her husband might have to call 911, right?
Judge, I'm gonna object. Know that false speculation.
I'm just asking what she said. This would be extrinsic impeachment now.
Hello.
I don't recall that. So.
Okay, all right. And she, to be fair, Miss English said that Mr. Gilligan was cutting a branch or cutting a tree, right?
She did mention that, yeah, was cutting a tree or being something that she didn't want.
And you recall when you walked up on his property, there was a big branch that had just been cut right on the ground, right?
I don't recall that.
Okay, but cutting branches and trees and holding a chainsaw up, that's what you use it for, right?
Right.
Okay. At some point, when you are speaking with the Englishes and you talk to both of them at length, right?
Yeah.
You did not separate the two of them, correct?
Don't recall.
You spoke to, okay. When you had talked with them, there came a point where you made a statement that you weren't, it had not been determined whether a crime had been committed or not, right?
Yes, when I was there at that house. that was-
Yes.
Yes,
During one of your visits, after they each had an opportunity to tell their story, you made a statement, we don't even know if we have a crime here yet, right?
yes,
And the reaction that you got to that from Mr. and Mrs. English was definitely one of disappointment, right?
I don't recall,
Okay, do you remember you made the statement? We're first trying to figure out if we have a crime or not. Remember saying those words?
yes,
And you said, that's why I needed your statements, right?
okay,
Did you recall something like that?
yes,
And you recall Mr. English became upset, right?
I don't recall it, I mean, I don't know what. If he was upset or not.
Okay, he told you, I'm a school principal, right? You remember that?
I do remember that he said it was, yeah.
And and I apologize, but he followed that by saying, I'm a school principal. In fact, you recall him making a statement, like you mentioned, like whether or not a crime has been committed. If you're making a threatening gesture, that's, to me, that's a crime.
Judge, right? That's all hearsay.
Response?
This is present, the sense of impression, and I'm really not offering it for the truth of that, because we're saying this didn't happen.
Then why are we wasting time with it?
Because it changed the officer's opinion, because she went from saying there was.
Why do I care what the officer's opinion is? Explain that to me. I'm lost.
Because the whole thing, what happened, Judge, is she made an allegation against Mr. Gilligan. The officers were saying it wasn't a crime. They were ready to release him. They said that much on video.
Okay.
And then statements changed over time to turn into something that apparently they felt was a crime. I just think the court should know that to evaluate.
Well, then just get to the point where something changed. Establish the change.
Okay. You had, I understand. After, do you recall Mr. English? Let me ask you. The statements that made, when you said you weren't sure if there was a crime or not, do you recall Mr. or Mrs. English trying to convince you that a crime had been committed?
Well, I usually say that because I did not have the other side of the story, so I didn't know what we had yet.
The other side of the story is important, true? Yeah. You were not the officer that interviewed the other side of the Mr. Gill. Okay, but other officers were interviewing him, right?
I think so, they wasn't.
And they were communicating to you on radio what they were learning, right?
I don't recall that.
You can call it. I apologize.
What?
I apologize. Were you finished? Sorry.
No. Yeah, I was communicating over the radio with them, but I don't know if they didn't say anything on the radio when it comes to what he was saying to them. They can't tell me all of that on the radio.
Okay, they told you over the radio it's a pellet gun, right?
Okay.
Do you recall that? Do you recall telling Mr. and Mrs. English, anything that looks like a gun, even if it's a toy, to us, we treat that as a threat? That's what you said, right?
Yes.
Okay, is it your position as you testified today that if something is a toy, that a felonious assault can be committed with? Or anything that looks like a firearm?
Isn't that a legal conclusion?
It might be, but they.
Then move on.
I'll withdraw. Do you recall a gentleman walked in the rear slider door and started participating in your conversation uninvited when you were interviewing the Englishes?
I don't recall.
I'm sorry?
I don't recall.
All right, do you remember a man with a beard coming through the door and participating and saying negative things about Mr. Gilligan?
No, I don't recall that now.
Okay, you'd agree with me that as you entered their home that day to conduct this investigation, you really didn't know anything about Mr. Gilligan, right?
No.
Okay, anything, if you're making statements later on stating that he was, words to the effect that he was unstable or had issues or he shouldn't be allowed to have a gun, That was based on things people at that house told you that day, right?
Negative. There, I had some knowledge, from previous calls at that house.
You had said you went to one previous call at Mr. Gilligan's house, correct?
I don't recall.
And you essentially said that it was of no significance, right?
I didn't see, I don't recall this. That I went to this house. One time.
Well, I mean, what happened? You really didn't know anything from the one call that you said you went to Mr. Gilligan's house. That did not put you in a position to know anything about him or what happened on November 7th.
Correct. I don't know much about him.
Right, so if you were by the end of your conversation making prejudicial statements against Mr. Gilligan, stating that you don't think he should be, that he should have his freedom essentially, that was based on things people were telling you in that house, right?
I would not say that, that was based on the people that were saying that in the house.
All right, would it be fair during an investigation to allow people who don't know somebody to tell you things that they've heard and to allow that to affect your judgment as to whether a crime had been committed?
No.
All right, if that happened, if people just walk in a rear sliding door and say things that are negative against somebody, that could lead to officer bias, correct?
Not necessarily.
Not necessarily, but it could, right?
Fair.
Fair.
Okay.
Well, you agree it's important to document all witnesses that you spoke to, correct?
Yes.
Okay, in your police report, do you document a man that came into a rear slider door and made very negative and prejudicial statements about Mr. Gilligan?
Judge, I'm not sure. She's asked, and she's answered this question, I think, multiple times about this individual. Maybe or maybe not. I don't know. I don't know if I watched video, but you can answer the question.
Well, I'll.
She doesn't recall anybody coming in the slider door.
Okay. Did you ever document in your report talking to anybody?
Why don't you just ask her what witnesses are documented in her report? Try it that way. Yeah.
What witnesses are documented in your report?
Just. Maybe.
I take it you don't need to see a report to answer that?
Or if I can remind myself.
Yeah, would it refresh your recollection?
Yes.
Ma'am. All right, I'm gonna hand you something, tell me if you recognize that as your report first.
Yes.
Okay.
Yeah.
Okay, and to be fair, your report is actually a segment, a submission in a larger report, correct?
Yes.
Okay, did you have an opportunity to look at that?
Yes.
You only document having spoke to Stacy English and Kevin English, correct?
Yes.
Oh. Would you, Mr. Muhammad suggesting that I play the video. The problem is there's a lot of videos. I really don't have a problem with that.
I do.
Yeah, I don't think so. So there's a lot of videos and I'm about to wrap up. So, okay. Now you, and I'm not covering everything here, but you'd agree with me that you, after going to the English's house several times, coming back and going back, you ultimately left the scene, right?
Yes.
You provided them written statements to write, correct?
Yes.
You left the written statements at their home to be filled out, correct?
Yes.
When you walked out the door, right?
Yes.
At some point, you'd agree with me, you would have had to go back to their house to pick up their completed written statements, right?
Yes.
Okay. When you did that, do you recall doing that? Excuse me.
Well, I picked up the statement, so I have to, yes.
Well, does that just mean you must have, or do you actually recall that?
No, I did.
Okay, did you have your body cam working when you went and picked up the statements?
I don't know.
Would there be any reason you wouldn't?
I don't know if I had or not.
Okay, so would it surprise you to know that there's no body cam of you picking up the written statements, receiving them completed?
Would it surprise me?
Yes.
No. If, I mean, I don't know if I had it or not.
You don't know if you had, okay.
No.
When do you recall returning, you have their statements in hand and you came back to their house, like at 11 o'clock, right?
I don't recall that.
Do you remember leaving a scene and going to another scene? And then coming back to the English's house at 11:06 a.m.?
I don't recall, sir.
Okay, well, when you come back, did you write down questions for Stacy English that you wanted her to answer
I did.
on her written statement, correct?
Yes.
And do you recall what those questions were?
I don't recall.
May I retrieve?
Sure.
Okay, so what you did is she wrote out her statement, you told her, write whatever happened, and she did that, right?
Mhm.
And then you came back a couple hours later with questions written out to clarify things, right?
Yes.
This was after Mr. Gilligan was arrested, right?
Yes.
Somebody already made a probable cause determination, right?
Yes.
And you're going back to seek clarification, correct?
Did you pick up the statements?
Well, and to have additional questions answered that you hand wrote on the statement form, right?
Yes.
Okay, and that issue that those questions pertain to was whether the alleged gun was supposedly pointed at the house or at Miss English, right?
If that's what it says, I don't recall what I yes.
Well, there's the statements on paper and then there was also the conversation that went along with that, correct?
Okay.
Did you watch the body cam of that?
I did.
Did you talk to the Englishes and recall telling Stacy English that you wanted to paint a picture?
I don't recall that.
Was the okay? What do you recall wanting to have Stacy English somewhere on record saying the gun was pointed at her? Was that important?
I don't recall that.
Do you recall any part of that interaction with Miss English?
I do not.
Okay. At what point, if you know, what point was probable cause achieved? And let me ask it a different way. You do recall stating you weren't sure if a crime had been committed or not, right?
Yes.
That was after the Englishes told you what they claimed happened, or Stacy English, right?
Yes.
Okay, and so Mr. Gilligan is already under arrest, correct?
I know he was the thing. I don't know at what point he was. I wasn't obviously the other officer, so I don't know at what point he was placed under arrest.
At some point, there was a determination that his detention was going to be going from, and I'm about to wrap up, from being detained to being arrested and charged, right?
Yeah.
Who made that determination?
Well, Judge, I'm gonna object to the phrase of that question.
If she knows.
Yes, thank you.
So, if you know.
It was not me, so I don't know who made the decision.
Okay, do you recall somebody coming over the radio as you're leaving the English's house and saying, do you have your phone on you for a TX?
I don't recall that.
Does that sometimes happen?
Yeah.
But a TX would mean a text message, right?
No, I recall.
A telephone call,
Yes.
right? So you step out of the house, you recall somebody called you, right?
Yes.
Who was that?
I'm gonna object, I don't see why that's relevant.
Well, this is where we're getting now, he's under arrest and being charged with something, she's saying there's no crime and maybe no crime.
I still
So I
don't
wanna know-
see, whoever made the decision to arrest the defendant, I still don't see why that's relevant.
What's relevant?
I mean, what fact is that gonna prove more or less?
What's the relevance to who made the decision to arrest?
Potentially not who, I'm more interested in what it was and what effect it had on this officer, the listener to that.
Why don't you just ask her if it had any effect on her?
Do you recall what was said during the telephone call?
I don't know who was on the phone. I know there was a phone call, I just don't know who I spoke to.
Did that phone call change things in your investigation?
How could it if the guy was already arrested?
Well, that's one of my questions that I'm asking, because these are.
But you're not asking it.
Okay, well, I guess one of the things that I'm trying to figure out is at what point it's determined that he's under arrest.
She already said she doesn't even know who made the decision.
Okay.
Do you know at what point that decision was made by someone?
Okay. Did you say, you would agree that it would be wrong for an officer to express a personal opinion about your hope that somebody gets
Judge,
charged?
I'm not object, these are hypotheticals. What does that have to do with anything in this case?
It's a relevance objection?
Yes, it's.
Mr. Crane.
I'll withdraw the question, Judge. Did you say, having said that you weren't sure if a crime was committed or not, and that you weren't sure, do you remember saying as you left the English's house for the last time, you're not sure if Mr. Gilligan's gonna be charged?
Judge, I'm not object, that's compound. Those like 3 different scenarios and one that sounds like.
Actually, I'll be.
Yeah, just rephrase.
Sir, as you're leaving the English's home for the last time on November 17th, do you recall stating that you didn't know if the prosecutor's office was going to charge Mr. Gilligan or not?
Objection. Relevance.
What's relevance?
Well, it's the statement that comes after this. The relevance is the fact that she's uncertain whether charges will ensue, and then the conversation that happened after that.
Do you remember making that comment?
Do you remember stating that you hope that he gets charged,
I know.
but you're not sure? Judge, that's all.
Any redirect, Mr. Muhammad?
Very.
Stop right there then. Give her a chance to catch her breath. Mr. Woodyard. Dismissal? No objection from the defense?
No, we have no.
Mr. Lipke, you owe us $294. Are you in a position to set up some kind of payment arrangements? When do you want to pay it? You can do that by the close of business? By 3 o'clock? I'll give you till Friday at 3. How's that? No problem? Do that. All right. Thank you. Have a great day, guys.
Thank you, Judge.
All right.
Officer, prior to this incident, did you know the victim, Stacey English?
No.
Do you have any relationship with?
No.
How about the defendant, Mr. Adam Gilligan? Did you know him prior to this incident? No. Do you have any relationship with him?
No.
Okay. Oh, no.
Any recross?
Very briefly, if you didn't know, as you just answered Mr. Muhammad's question, position to be saying he shouldn't have the right to have guns, and that you're essentially hoping that he's locked.
Good. I
don't think that was anything to do with the redirect.
Yeah, I think it's outside the scope, and I don't even know if that was a question. It sounded more.
A statement.
Well, I believe this.
Let me ask you this. Do you have a question that is directly related to what came out on the redirect?
Well, yeah, I thought that was because she said, the question was about her knowledge of Mr. Gilligan, whether she knows anything about him. So to that, if that's true, and she doesn't know anything about him, she makes statements that would contradict that, and that's what my question was about.
You remember the question?
Okay, so if you, as you answered Mr. Muhammad's question, if you don't know Mr. Gilligan, I don't want to get his question wrong, but you answered that you really didn't know about Mr. Gilligan, you certainly wouldn't be in a position to say things like, that.
Hold on. Do you recall making statements about the fact that you hope he gets charged? All right. If you said that, why would you say that?
I don't know. Like I said, if I said that, if I spoke with a video, he was telling me these things. If that's true.
Would it be unusual for you to say to the victim, I hope he gets charged based on what the victim's telling you? Thank you. Anything else?
No, not with people.
You can step down, officer. Thank you. Do you have any more questions or witnesses, Mr. Muhammad? Is the defense going to put any witnesses on?
May I get off some short?
Yeah, please.
Thank you.
Oh, hold on, that one I gotta do. Waiver on Carter? Yeah, if we're gonna do a waiver. Officer, come on up, settle in the chair.
You're aware, often not, the waiver was allowed.
Gotta have paperwork on it. Counsel, your appearance for Carter, please.
Yes, Your Honor, Alexander of 96 Neighborhood Defender Service, PA 7. Carter.
Good afternoon, Mr. Carter. Mr. Carter, did you discuss your rights with counsel? You understand those rights and the options those rights give you? You understand what an exam is all about? You understand that by waiving the exam, that means you're going downtown for your next court date at the circuit court level, not at the district court where we're all at right now. Understanding all of that, are you waiving freely and voluntarily? Go ahead, have a seat. Counsel, are you satisfied with the waiver? So am I. AOI date is going to be on the 14th at 9 a.m. Bond will be continued. I will wish you luck downtown and get your signatures before you get out of here. Raise your right hand. Swear, affirm, tell the truth, whole truth, nothing but the truth today?
Yes.
All right. Mr. Mohammed, your witness when you're ready.
Possible to do a waiver on often not.
It is, if you give me a file and paperwork. I got the file. I just need the paperwork. Appearance for Knox.
Good afternoon, Your Honor, Mohammed on the head.
Your Honor, Alexander of 96 Neighborhood Defender Service, PA 7455, Mr. Austin Knox.
Thank you. Waiver.
Yes, Your Honor.
Mr. Knox, did you discuss your rights and options with your counsel? You understood those rights and the options they present to you. You understand the purpose for an exam? You understand by waiving, that means you're going downtown for your next court date at the circuit court level, not at the district court level where we all stand right now. Understanding all of that, are you waiving your exam? Are you doing that freely and voluntarily? Satisfied?
And Your Honor.
So am I. AOI date May 14th, 9 a.m. Bond is continued. Signatures, please. Thanks, Mohammed. Appreciate it. Mr. Mohammed, your witness.
Judge, it's not my witness.
Oh, that's right. Mr. Prain's witness. Mr. Prain, he is sworn in, ready for you.
All right. Good afternoon, sir. Would you introduce yourself and spell your name and record, please?
My name is Sergeant Jordan Short, Jordan. Last name is Short.
All right, sir, how are you employed?
Police Department.
Okay, and were you employed in that capacity on November 7th, 2020?
Yes.
You remember that day? Were you working that day?
Yes.
All right, at some point, did you get a dispatch to Rob Road?
Yes.
And what was that dispatch in regards to?
Male walking around with a gun, pointing at neighbors' residence.
All right, and was this as the result of a 911 call or citizen calling? I don't know if it's not an emergency or emergency, but all over the place, right? Were you on road? Okay, did you receive information? Local location.
Yes.
Where did you go?
I don't recall the exact address, but it was Mr. Gilligan's house with had prior contacts with him, so I was familiar with him.
Okay, I wasn't asking about prior contacts, but you said you've had prior contact with him because you've been in his house before, right?
Correct.
You've never arrested him for a crime, right?
Not that I can recall.
Okay, and you would certainly recall that, right?
Possible.
Well, and then you remember that you've been in his house before, so if you had arrested him for a crime.
Judge, he's answered the question.
He has.
All right. You know, people by the name of Stace and Kevin English.
I don't know them. I just know them from the report.
Okay, had you ever met them before?
No, I wasn't. I did not make contact with them.
All right, and you pulled up, did you go to Mr. Gilligan's residence?
Yes.
And I think you said it was on Rob Road.
Correct.
Can you briefly tell us what you did when you arrived?
We parked two houses to the west. That was unknown where Mr. Gilligan was located at yet, and he was somewhere around his property. We went to the back of we went to the back property over there and began our movement up to Mr. Gillikin's property to try to get an eye on him.
All right, and were there 4 officers on the scene that day?
Yes.
Or actually 5?
Well, yeah, I mean, more showed up, so I mean, it depends on what time you're looking at.
All right, and just so we know who was there, it was yourself and Officer Champagne, correct?
In our position, yes.
And you were with him, correct?
Yes. with
When you said that you were going around, I don't know what you actually said already, but I know you and Officer Champagne kind of worked as a team to cover each other as you went around to the back of the woods, right?
Correct.
Okay, and there was also Officer Gillespie there?
Oh.
And was Officer, Brandon there?
That's the plea.
And also somebody by the name of Sergeant.
Yes, he did.
Okay. And do you go through some yards in order to try to observe the person that was called about?
Yeah.
All right, and so can you tell us what happened when you, I don't know how to say this, but you went through some, a back area. Can you tell us what you did when you arrived on the scene?
We walked through 2 properties, tried to get up to Mr. Gillikin's property because there's a fence area, and then there's also, I guess, like a drop off, big valley type area over by the Metro Parks over there. So we had to work our way up to kind of around this fence to get an eye on the property, try to locate where Mr. Gillikin was on the property.
Fair to say you had to go through some yards to try to get to Mr. Gillikin's, the back of Mr. Gillikin's property.
I'm gonna object, Judge, that's a leading question.
I know, I'm not trying to move on. It's not really that substantial. Like, did you go through some yards?
Yes.
I think I asked, I apologize. Did you have a body worn camera on you that day?
I did.
The same one on your uniform today, is that true?
Yes.
Okay, and did you have that activated?
Yes.
And it was recording both video and audio? Was it recording as you did the approach through the back of the properties that you indicated?
Yes.
Right? And you also wrote a police report later on?
Correct.
Okay. And you had what officer?
Officer Champagne.
And were you attempting to get eyes on Mr. Gillikin?
Yes.
Okay, and what does that mean?
That means one.
All right. Did you at some point observe Mr. Gillikin?
Did.
All right. What was he doing? What did you?
I saw him now with, I didn't see a rifle, I saw a blowtorch, large blowtorch in his hand. He was setting fire to a wood line.
Now, when you say a large blowtorch, what he really had was a little propane torch, right?
I mean, it depends on what you would determine to be large. It's large to me.
It's the type of propane tank that you have on your grill.
Correct.
True. And did it have a apparatus on it that can be used as a torch?
Yeah, it was a blowtorch.
But is it a small torch though?
I determined it to be a large blowtorch.
Okay, well,
Do I care?
I'm sorry.
Do I care?
I guess I don't really know, Judge.
I can answer the question, no.
Was it a weapon?
I determined it to be a weapon.
You thought that the torch was a weapon?
A weapon.
Okay, maybe you might care now, I guess, Judge, but,
I would take judicial notice that anything that shoots flame can be used as a weapon, large, small, or otherwise.
was he using it as a weapon?
Not at the time, he was setting fire to a wood line.
Well, isn't it true he was setting fire to weeds? Because that's what he used it for.
Weeds, possibly in the wood line. It was a wood line. I don't know what he was setting fire to.
Where are there any pictures or videos of a burned wood line from storage?
I don't care. He's not charged with arson.
Did you observe, other than what we call a torch, did you observe any gun or firearm on Mr. Gillikin?
No.
Okay. What I'd like to do at this time is, your body or camera, as you indicated, was working at that time. Would you be able to identify that video if I showed it to you?
Yes.
Okay, I'd like to admit that video, Judge.
Can't wait.
I'm just gonna ask for an offer. What is it gonna show?
Well, it's what it will show, my offer of proof is, it'll show them approaching Mr. Gillikin, that he has no gun on him of any type. That, of course, you heard from the other officer, the pellet gun was in the front of the yard. It will show him being arrested. He complies with their commands. They tell him to get down. He gets down. He's respectful. And as soon as he hears the allegation being made against him, he says, absolutely not. I didn't do that. I was using a pellet gun to shoot squirrels, and offers evidence to the officers in support of that, which they should care about, because intent is an element of the charge that he's facing. It's all.
None of that matters, Mr. Prain.
Okay.
None of that matters because he's been charged by the prosecutor's office. Sought or what the officers wanted, none of that matters.
I just want to show evidence of intent because it's a specific intent charge. And I think that that's something that has to be evaluated.
How's the video going to show intent?
Because he's offering, it shows when he's confronted with the allegation.
It's going to offer his story. That's all it's going to offer. And once again, I'm going to explain to you again. I had a witness who said a weapon was pointed at her. Unless I find her to be totally incredulous, I'm binding over. The fact that you might have an alternative theory of what happened is an issue for the trier of fact.
Judge,
Not an issue for a bind over.
okay, I thought credibility was relevant too, but I understand.
It is relevant. And I'm going to tell you right now, if I take everything you just told me as golden after I watch the video, it's still not enough for me to find that the woman's totally off her rocker and incredulous. It's still going to be an issue for the trier of fact to determine who's more credible, witness A or witness B.
Well, and I assume you'll let me argue the other elements too, right?
Yeah, but I didn't hear anything about the other elements that's going to come out in this video.
Okay, sir, did you recover a pellet gun?
I did not recover. I saw the pellet gun after it was recovered.
All right, could you describe for the court what this pellet gun is like?
Pellet gun looks like a real precision rifle. It's tan in color with a white scope on it.
What's the make?
I don't recall unless I look at my report.
I assume you don't know the model then?
Yeah, I don't. I would have to look at my report.
Do you know the caliber?
Pellet gun, I don't know the. Assuming 22 caliber pellet.
What about .177?
That's a possibility too. I have to look at my report.
All right, you think that would be in there?
Possibly.
All right, whatever fresh recollection you saw, a copy of the report.
Yes.
All right, may I approach?
Sure.
And tell me if I've got the correct report. Right? Yes. Okay.
I didn't see a big problem.
All right, that's nowhere in the report. Is it?
I don't know if any multiple reports that they documented, but not mine.
Yeah. So you wouldn't be able to offer the court any information about what type of pellet gun that was, the caliber, or its capability, correct?
Not, I didn't look at the maker model or caliber of the pellet gun. I just determined that it was a pellet gun.
All right. At some point, did you enter Mr. Gilpin's house?
I don't believe so.
Do you recall entering his basement?
Oh, yes, to attempt to shut off the loudspeaker.
Okay, would you agree that you need a legal right to go in someone's house?
No, it depends on what it's for.
Do you know what gave you the legal right on this data?
Why does it matter? Why does it matter for what I'm hearing today?
I'll withdraw the question.
Thank you.
Did you retrieve any items of evidence from inside Mr. Gilpin's house?
I did not, I was handed evidence or items from his wife. I didn't retrieve any from inside of the residence.
Did you make a comment on, at some point, I got one?
Judge, I'm not sure, that was very good said.
Well, it's a question, and it's his statement, like,
I'll allow it. He's right here.
okay, do you recall saying at some point, I got one?
I don't recall what the context of.
Regardless of the context, do you recall saying that?
I don't know.
Are you lawyer?
I don't know.
That's all.
You step down. Can the sergeant get back to whatever he's supposed to be doing? Yeah. Stay safe.
Thanks.
Anything else, Mr. Prain?
No, Your Honor.
Any rebuttal?
No, good.
All right, arguments.
I'm gonna go Where I believe this when you reflects the question that's matched. And
Thank you. Mr. Brain.
Thank you, Your Honor. Looking at jury instruction 17.9 for the charge that Mr. Gilligan is facing. First element is that they have to show probable cause, which of course is defined as trustworthy facts or knowledge that would lead a person of reasonable caution to believe that the crime has been committed. Looking at element number 1, they have to show the defendant either attempted to commit a battery on the complainant or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching to the person or something closely connected to her. Judge, I know based on the court's previous statements that in light of 2 different positions that you would find a question of fact. So I'm not going to spend a lot of time on this. What I am going to point out though is under the case law, the court still has to make a credibility determination. Now, there were it sounded to me like Miss English acknowledged that she said that this was pointed at the house. And I think the court may have picked up there was maybe a change from pointed at the house to pointed at her that came out at a later time. So we have conflicting information within her own statement.
Here's why that's not going anywhere with me. She was in the house. So if I'm in a house and somebody points something at the house and I say, on one occasion, they pointed at me, and on another occasion, I say they pointed at the house, I don't see a big distinction there.
I'm interested.
So that's not going anywhere. Don't waste another second. Keep moving on.
Because of course our assertion is
And
going to happen at all.
I get that. And I'm not deciding that today, but I didn't find her to be totally unbelievable.
Second, that the defendant intended to either injure or make someone reasonably fear an immediate battery. You know, Mr. Gilligan is out there with a chainsaw. He's clearly working on his property. He's burning weeds. He's doing the intended things for these items, for these items of property. I tried to offer evidence of another purpose because this is the point. If the defendant, she can stand here all day and say what she thinks his intent was, because that's an element that the court has to find. There was evidence, and they didn't present any evidence to the contrary, of what Mr. Gilligan's intent was. He offered that to the officers. You heard no testimony from the prosecution that they cared about that. Probable cause is based on the totality of the circumstances. So if there's evidence that tends to show another intent and purpose, that's relevant for the decision here. In her own testimony, conflicted itself. He had third that the defendant either had the ability to commit a battery, appeared to have the ability, or thought he had the ability. This pellet gun was unloaded. You heard no evidence to the contrary. It's their burden of proof. Most importantly, the fourth element is that it was committed with a dangerous weapon, which the jury instruction defines as any object that is used in a way that is likely, not possible, not maybe, but likely, Your Honor, to cause serious physical injury or death. So we have to look at what was it, how was it used. They had a burden today to produce evidence that this alleged gun, which is not a firearm, because a firearm is something that propels a projectile through an explosive. This is an air gun. You heard nothing to base a decision on that a pellet gun from any particular distance, which they didn't even say, could cause serious, or was likely to cause serious physical injury or death. Their case fails on that grounds. They presented zero evidence that was their burden today. Your Honor, this case has to be dismissed. And the felony firearm charge that goes along with it, it rises and falls with it. I want to say on that regard, I understand that a jury can find somebody guilty of felony firearm, even if they don't convict on the underlying offense, which I definitely take a position against that. However, in order for a finding of probable cause, when you look at elements of felony firearm pneumatic gun, which he is charged with, it says it's not necessary that the defendant be convicted of that crime, but they do have to show that he committed it for this court's probable cause determination. That's in jury instruction 11.34a. Your Honor, this case cannot go any further. It has to be dismissed. They totally failed on an element. Thank you.
Ms. Muhammad.
Judge, I think it's pretty obvious that we're all aware that it was an actual firearm, but it was a pneumatic gun, which is why it's charged count 2 is felony firearm with a pneumatic gun. Additionally, we have the testimony of the victim who indicated that she felt threatened and her actions of going and hiding her son and going down to the basement, all of that is indicative of how she felt, and she clearly felt in fear. She started crying on the stand, recalling the incident. So I believe for purposes of today's hearing, Judge, we've established probably. I'm gonna go.
But Mr. Prain says one of the elements you have to establish today is that there's a likelihood of serious injury. You disagree?
I think it's a question of fact. The firearm, the rifle was pointed in her direction. And we learned that it was a pellet gun. Whether or not it was loaded is a question of fact. We don't know. But had he pulled the trigger, we wouldn't be here for a felonious assault. It could be a GBH or something.
Not with a pellet gun, not a .177 pellet gun through a house.
Bodily harm. It could have struck her in the eye, caused severe. I don't know. That's a different. I still think it's a dangerous weapon.
What's the definition? What's the legal definition in the state of Michigan for a dangerous weapon?
But it could be anything. How the weapon could be used is what would define it. So you could use a phone to be a dangerous weapon.
Right.
This is a pneumatic weapon that shoots out pellets that can cause serious injury.
I watched The Christmas Story too.
Just one word, unloaded, no evidence that it was loaded, end of story, Your Honor. Well,
Again, that's a question.
But there's no evidence that it was unloaded.
Well, they.
So-
But that's their burden and the issue.
Hold on. Let me stop you there. Because what I'm hearing from you is it's their burden today to prove every element of the crime today.
They have to show evidence of probable cause on each element. And what I'm saying is, when they didn't introduce any evidence that it was loaded, you can't say that it's likely to cause injury. If you could take an AR, if it's unloaded, it cannot have any likelihood to cause any injury to anybody unless you're close enough to use it as a club.
Respond to that, Mr. Mohammed. Because that's a pretty good argument.
Judge, a pneumatic weapon is known by the state of Michigan to be a dangerous weapon, and I'd like to just have an opportunity to pull up the jury.
Yeah, go ahead.
That you believe it acknowledges pellet guns.
Why don't you pull up that while I take care of this last case? Is it Laurier? Am I saying it right? We lost the attorney. Counsel, your appearance.
Good afternoon, Your Honor. Alexander, 9th Neighborhood Defender Service, PA 7455, Mr. Alec Herrera.
Mr. Laurier, I understand you're going to take a plea today, correct?
Correct.
You discussed your rights and options with counsel?
Yes.
You understand all those? You understand the possible penalty for the charge of domestic violence? Understanding all of that, are you pleading to that charge? Are you pleading guilty to that charge freely and voluntarily today?
Pleading guilty to the misdemeanor
Domestic violence. All right. Would you voir dire? Incident date is March 6th, 2025, Van Buren Township.
Mr. Leonard, you were in Van Buren Township on March 6th, 2025?
Yes.
And at that time, had been in a relationship with Miss Felicia,
Roberson.
Roberson. Thanks. And at that time, did you threaten physical contact with her in a non-consensual way?
Yes.
Satisfied?
Satisfied with that?
Mr. Legge? I'll accept the plea. I'll dismiss counts 1 and 3 in keeping with the agreement. What are your feelings, gentlemen? Immediate sentence versus pre-sentence investigation?
We are happy to have immediate sentence, Your Honor. I'm understanding what the client qualifies for the agreements.
Okay. Does the complainant have any comments? All right. So if I'm reading this correctly, the sentence recommendation is batter's counseling, not to harm, harass, or confront, 12-month under 769.4A. Is that the sum and substance of the agreement?
Yes, Your Honor. My client's already engaged in cognitive behavioral therapy.
Good. Where at?
He's doing through BetterHelp. It's online.
Okay. Okay. Good. Good. Are you working?
Yeah.
Where at?
Jeff's Pizza, I've been there for about 2 years and I'm a business owner as well.
Okay. What do you do?
Production. Production.
Like video stuff?
Video, music.
Music? Okay. All right. Anything else I should know? All right. I'll go along with the recommendation, 12-month delayed sentence under 769.4A, required batterers counseling and not to harm, harass, or confront. Court costs are assessed in the amount of $750. Can you pay that today?
Yeah.
Now?
Yeah.
Favorite answer. Go downstairs, cashier will smile when she takes your money. Good luck. Thank you, counsel. All right, Mr. Mohammed, you ready to argue?
Yes. Well, Judge, first I would indicate to the court that jury instruction, those are jury instructions. This isn't a jury. This isn't a trial. So I don't even know if it's applicable to that extent. Obviously, we're gonna.
Just humor me. Just humor me.
So in regards to a dangerous weapon, I believe we have to focus on how it can be used. And in this specific case, you have a rifle that's being aimed at a woman and in her child, and we don't know. I don't know how it was gonna. But if that firearm had dispersed pellets and it struck that baby in the eye or struck her in the eye, then of course we're gonna be here for something a little more serious. So I think we have to focus on how it's being used, and in this situation, in this specific situation, it created an assault. And the assault was that she felt in fear of being shot by a gun. At least what she.
I don't have any doubt that she was.
What a reasonable.
I don't have any doubt that she was in fear.
And so that's the people's position, Judge. This is a, we're not here to determine guilt.
I wish we were. This is an absolute bullshit case. It never should have been brought to the level it was brought, but it was. And I think he's right. I think it's all a trier of fact issue. I'm going to give you one more chance to convince me. Because I don't think they ever should have charged this case with assault with a dangerous weapon.
And I would just say this too, they still had to produce evidence of, like, they had a duty, Judge, to say something along the lines of, this is the type of weapon that it is, this is its capabilities, here was the approximate distance, so there's reason to believe that it could go in somewhere, penetrate a window or a building, or do something, and it's likely to cause serious injury or death. They did nothing. I don't see how they could meet that burden, plus it was unloaded. He says the pellet could have gone through it, it could have done this and that. My question is, what pellet? There was no evidence that it was loaded, and if it's unloaded.
Well, let me stop you. Let me stop you, because you just reminded me. What I asked you to respond to before I took the break was his argument that even an AR-15 caliber .223, which is a war weapon, does not meet the definition unless you're close enough to use it as a club if it's unloaded. And you were going to respond to that, and you started looking up.
Well, Judge, I think that's a question of fact. It really is a question of fact. I mean,
How? Why? Why can't I take judicial notice that an unloaded firearm is no more than a club?
We don't know, at least I can't say here in good faith that I know exactly whether or not that gun was loaded or it wasn't.
That's his point.
Yes, and I will agree, I don't know. But what we will say, that's a question of fact.
But they have to produce evidence of it, and that's the difference. They can't just say, maybe. That's not true. They gotta do something.
Do you disagree with that argument, Mr. Mohammed? Because I'm just asking you, do you disagree with that position? That you have to present some evidence today that there's probable cause for that element, the dangerousness?
Not for the felony firearm, because the felony firearm was attached, and in this specific case, we know that it was a pneumatic weapon. It had the appearance of a rifle.
So you hold on. I think you just capitulated that count one shouldn't go downtown.
No, I'm saying in regards to count two.
No, I'm asking about count one. Did you just concede that count one, you didn't meet your burden?
No, I'm not conceding.
All right, well, let's talk about that, because his argument is part of your burden today was that you'd have to present some evidence that that was a possibly or likely dangerous weapon. Is that a fair assessment of your argument, Mr. Prey?
Yes, likely.
Okay.
I think it's inherently known that a pneumatic rifle, a weapon that can disperse pellets, that could potentially penetrate people's eyes and cause serious injury.
But hold on, you're missing my question though. You're missing my question. His argument is you have to present some evidence of the dangerousness of that weapon today. You're asking me without any indication where the window's closed, how far was he from the house? You're asking me without any of that evidence to assume the likelihood of injury. Because, hold on, I'm a gun guy. A pellet gun is much more dangerous to you if I'm this close with it than if I'm 400 yards away. So I heard no evidence about any distances today, any about what obstructions the pellet might have to go through. I heard no evidence of that. His argument is because I heard no evidence, I can't bind over. And I'm still trying to get you to respond to that specific argument from him that I heard no evidence means I can't bind over.
Well, Judge, the testimony was that they did share a border, and she indicated at some point
I share a border with my neighbor too.
I understand, but she indicated that.
It's a long way away.
I understand, but to the point where she could see him physically using her hand gestures and looking directly at her. She also described what the firearm was. She was able to recognize that it was a long rifle. I think the court could take obvious notice of the fact that you have to be able to see them. If you can identify a person and identify what they're holding in their hands, I think it's fair to say that it's within a reasonable distance where that firearm could be used and hit that person. He also indicated that he had crossed into her yard at some point.
But I still heard no testimony about distance. I think, once again, I think it's an absolute, stop. I think it's an absolute shit case, but I do think it's trier fact. It's a trier fact case.
I'm just asking you please to consider the fact that they produced no evidence that it was loaded. The only officer gave said it was unloaded. And that's the evidence.
Who testified that it was unloaded? Because all I heard was nobody checked.
Well, if I make a motion to open up the proofs again, because I have a picture of it being unloaded.
But we're done. We presented our proofs.
That's gonna make the difference. If we reopen the proofs in 30 seconds, I can have Officer Short show that from his body cam, that thing was unloaded. No help.
But it's still not gonna tell me if it was unloaded when it was pointed.
Well, but that's their job to prove that, though. They can't just come here and say, well, maybe. They've got to show some evidence of that, though. They didn't even find a pellet. They didn't even find a can of pellets, not even a little tin.
Then how was he hunting squirrels, which is your theory of the case? How's he hunting squirrels with an unloaded gun with no pellets?
I didn't find that evidence. That was objected to.
But that was your theory that you were trying to present until I told you I wouldn't watch the video.
It's not hunting, but it's unloaded, though.
But you can't have it both ways. You can't have it both ways.
But they found it unloaded, though, and they're asking the court to infer based on nothing that it was loaded. That's where the problem comes. That's where I think the error would be in that decision, is they produced zero evidence of it. They've got to do something on that.
No, Judge, what I'm saying is that.
Hold on, take turns, guys. We've been playing nice.
I just want to reiterate again, an unloaded firearm, and Mr. Muhammad is absolutely right. He even used a cell phone as an example, used in a way that is likely to cause, they did zero on that. And then again, even if it was loaded, you still heard nothing on the distance or anything. This is a point. I mean, well, I guess.
All right, sir. One more little threat. It's not helping. It's actually pissing me off. So sit there like you're a doll on a shelf.
Yes, sir.
Go ahead.
So there's really two issues that they've got to tackle, even if they want to say that it was loaded, Your Honor. You're correct. You didn't hear anything about the distance, just like you wouldn't bind over a retail fraud case unless there was some proof shown of the value of the item. You wouldn't just say, well, just assign an arbitrary value to it. What Mr. Mohammed is saying is that a pellet gun is capable of firing a projectile stipulates that. That's not the issue, but that's all he's proven. That's it. And that can't go downtown on that.
Go ahead, Mohammed.
But that's a question of fact, whether or not it was loaded. So in scenarios where somebody has a real gun and they point a real gun, are we gonna take that position instead of pressing it? If that real gun wasn't loaded with a bullet, when the police officers respond and recover that gun, that it was never ever loaded, that's not how it works. It's how it's at this point, it's just whether or not there's a questionable fact. And I think the officers responded after this incident, whether or not that firearm was loaded in regards to the rightfulness case, it's a question of fact.
You know what? Here's what we're gonna do.
And just one last thing, Judge, if I
Go
may.
ahead.
Thank you. In regards to the distance, I think based on the totality of the circumstances, the observations of the victim, the description of the firearm, being able to recognize that the defendant was pointing his fingers to his eyes and then straight back at her, him crossing into her yard. I think all those circumstances together, I think infers at least to me that it was a reasonable distance to where a reasonable person would feel in fear. So
But hold on. That's a different issue. I already established the fact that I believe this lady was in fear. That's not the argument that's in front of me. That's not in the argument. No, I understand. But the argument that he's making is because you presented no evidence about the dangerousness of it, other than the fact it appeared to be, or that it was a pneumatic weapon, that it fails. That's his argument. So I believe the lady was afraid of it. Because she didn't know what it was. She said it repeatedly. I'm not a gun person. I don't know guns. It looked like a rifle to me and I was freaked out.
I understand. And Judge, I completely disagree with that because whether or not that gun was loaded is a question of fact. If we were to take
No. Hold on. We all agree on that. We all agree on whether or not it was loaded is a question of fact for the trier of fact. His argument is you've got to present some evidence because there's got to be probable cause that it was dangerous. And there's no probable cause that it's dangerous if it's unloaded. Right? That's your argument?
It's exactly this. I'll say this. It's because we have burdens of proof in the law. Scintilla, reasonable suspicion, probable cause, preponderance, right? What burden of proof by which burden of proof did they establish that it was loaded? It was capable of because no.
So I think his argument is that you've got to give some evidence of probable cause that this particular weapon in this particular circumstance was dangerous. Is that a fair summation?
That is a fair summation, and they have to go through either a law, so there's a particular fact they really need to establish.
And Judge, I completely disagree. Whether or not it's loaded is a question of fact for a fact finder, and it should be found over because it's a question of fact. And there is case law on this, and if I get an opportunity, I will find the case law. Whether to say the police were not there at the time of the incident.
Right.
They responded after the fact.
Right.
So to say that a police officer that responded after the crime, and that the way they found the firearm at that specific time is exactly how it was during the commission of the crime does not make sense.
But the difference is we're talking about a real firearm in that case. I can guarantee that case is a real firearm. Center fire, way more powerful than a .177 caliber pellet gun. I'm dismissing it. I'm dismissing it. You know what?
2 seconds.
You're going to find a case that it's pneumatic?
Yes, I will try to.
I'll give you a minute to find it. God knows I'm got nothing else to do.
And while he finds that, I think they should have the answer too. If we were in a jury trial, Your Honor, for an assault battery, and we were requesting a self-defense instruction, we don't just get that instruction because we're here. We have to show some evidence to get that instruction. I mean, that's kind of the nature of the argument here. Like
That analogy is not helping you though.
I guess a better way to say it is they can't rely on.
Now, a better way is just sit down right now. It's going your way. You guys want to take a break?
Yes, please. No.
Well, take a break. Heather told me I can have something to eat. All right. This is fun, by the way. I'm enjoying the hell out of this.
Mr. Gilbert, you say that.
Oh, yeah, you guys, I'm on recess.
What did you endorse?
I didn't have a chance to grab it and I didn't want to hear it click. So I'm sorry, I grabbed your book. I found it.
That's.
Oh, okay, good. I just needed something so it didn't click.
Hey, can you look up people from Hills? Oh, I was. I just don't. I know it's this, we started out. It's fine, I figured. There's people meetings. Yes.
All right, report this court back in session. I will signing.
Have a seat. All right. Anybody got anything to add?
So Judge, and just to confirm, are we taking judicial notice or stipulation that a firearm is a weapon which is designed that can be converted to expel a projectile by an action of an explosive? Are we taking notice that?
I think that's the definition of a firearm in Michigan. It's explosive.
I'll read it, 17.11 definition of firearm. A gun, revolver, is a firearm. A firearm includes any weapon which is designed to or may readily be converted to expel a projectile by action of an explosive. And it also says it does not matter whether the pistol or revolver was capable of firing a projectile, whether it was loaded, which I suspect they're gonna say that's the case here, but this is all about the definition of firearm, it's not a firearm.
So that is, so we're recognizing that a pellet gun is not a firearm. Even though in this case, we have a pneumatic gun is charged under the statute of Michigan of MCL 750.227B-A1, that is considered a weapons felony firearm dash pneumatic gun.
It's my opinion that a air rifle, which is what a pneumatic gun is, does not meet that definition because there's no explosive involved. Matter of fact, I believe there's a specific definition for pneumatic. I don't know if it's gun or weapon.
Okay, so I'm just gonna read the case law that I think for this case. So that's under People v. Peels, 476 Mich. 636-720 N.W.2D 196, which is the 2006 case. And under the statute, there is no requirement of proof that the firearm was operable or reasonably or readily operable. Rather, the statute requires that only that the weapon of a type that is designed or intended to propel a dangerous projectile. And that's People versus Perkins. So I'll start there. And then additionally, there's another People versus Brown, which is 249 Mich. App 32642 N.W.2D, which is a 2002 case. And also citing People versus Peels. A temporarily inoperable firearm is still a firearm covered by the felon in possession of firearm statute.
That's not what we have. A judge under a jury.
We don't have a firearm.
I understand. So, but Judge, literally, it recognizes in the People versus Field, it says, rather, the statute requires only that the weapon, in this case, I believe we can all agree that a pneumatic gun is a weapon, requires that the type of weapon be a type that is designed or intended to propel a dangerous projectile. I think it's very evident that this rifle could project a danger, and the key word that's used in this, dangerous projectile.
I think we can all agree that that's what a pneumatic rifle is designed to do.
Yes, and the definition of pneumatic gun is different. It's under jury instruction 11.3A. It does not use the word firearm. It's called an implement.
And we're not here in a jury trial. This is what it says. It says whether or not it's operable or reasonably or readily operable. Rather, the statute requires only that the weapon be a type that is designed or intended to propel a dangerous projectile. That's under the firearm, unloaded, or inoperable elements.
Firearm.
Yes, this is the MCL, the defendant is charged under for the second count for a pneumatic gun is labeled under a felony firearm.
No, they don't mean it that way. They want the definition of pneumatic.
Okay,
gun
then
under
run-
11.3, unless they're asking, I guess, to bind over a felony firearm without an underlying firearm related felony. They can't do that.
No, I'm requesting that it be bound over as charged with the felony firearm be attached?
They've charged him under a specific statutory subsection for a pneumatic gun on the felony firearm charge. This is not a regular felony firearm.
But it's labeled as a felony firearm.
The case law he's reading is interpreting the definition of a firearm under, I believe, MCL 750.222G.
Right.
This is, excuse me, under 222D. This is a pneumatic gun under 222G, Your Honor. That's just not applicable.
I completely disagree. It literally says, rather the statute requires only that the weapon.
What statute are they referring to?
I believe it's from whatever, this is labeled under 5.573, and then it has the case law. I can pull everything up, Judge, for you to observe and review.
Yeah, what the language you're giving me is qualified by the statute.
Yes.
So I need to know what statute they're referring to.
If I could get a-
Yeah, go ahead. What the hell? Day's all shot anyhow.
Excuse me, appeals.
Yes, equal versus.
Okay, I got it right here. We granted leave to appeal to consider whether the weapon issue in this case constituted a firearm as defined in MCL 750.222D as in dog, Your Honor. This is a G. Pneumatic gun. This case does not have applicability to this, in what they charged him.
I'll give you a chance to look it up, Mr. Marlowe. And here to compound things, that's where I think the state of Michigan, the laws are lacking. Because, you know, there are pneumatic weapons now that are high-powered weapons. I just met a guy this weekend who's killed 2 deer in the last 2 years with a 357 pellet gun. I don't think that's what our current statutes anticipate.
No, I would think they had in mind that you would spend like, for $120, $130 Walmart thing, that's one thing, but I know that they have ones that you could spend $3-4 grand on.
Yeah, and hunt big game.
And that's why it was important that they show what I think fellas got, I can make an offer of approval, but we know what it is.
But I'm not bringing, I don't know if we're on the record.
We are. You want to go off record?
Yeah, I mean, if he's gonna be talking about the case, I don't, my focus.
That's all right. That's fine. Mhm. This is early. Yeah, I didn't want to compound. Yeah. Right, yeah. Go ahead. You just. It might be important for a jury. Right. Mr. Muhammad.
I'm gonna rely on the fact that this felony firearm, dash pneumatic gun, comes in, is being charged from, in the language of the state of Michigan, was that this falls within under weapons felony firearm. So clearly, I believe they intended for this to be considered a firearm. It's literally under the name of the statute. They're labeling it weapons felony firearm dash pneumatic gun. So at this point, I think it's just a question of time. Judge, in response to that, that's why we have two different jury instructions for felony firearm. One for an actual firearm, which is 11.34, it uses the word firearm. And then there's 11.34A, which uses the word pneumatic gun.
But Judge,
So
this
that
isn't a jury. This isn't a jury trial. We're just establishing if there's.
Yeah,
probable cause.
that's still a reasonable argument to make.
It's a legal argument.
But then at this point, the whole case should have been signed off by a judge and brought here. Clearly, there was a probable cause for this warrant to have been signed.
Well, we don't know what argument.
Yeah. This wasn't signed off by a judge, I can guarantee you that.
I think for purposes of this case,
Yep.
there is a question of that, and I think.
So here, all right, stop talking. Section 226, subparagraph 1. A person shall not, with intent to use the same unlawfully against the person of another, go armed with a pistol or other firearm, or pneumatic gun, dagger, dirk, razor, stiletto, or any other dangerous or deadly weapon or instrument. What that tells me is, in their wisdom, the legislature has determined that a pneumatic gun can be a dangerous weapon. And for that reason, I think it's, once again, it's a crap, I made my decision. It's a crap case. I don't think whoever approved it at the prosecutor's office should have approved it at the level they did, but I am going to bind it over.
Judge, I just want to say, they still.
Make your record. Make your record.
Oh, they still, I understand the decision you made, the legal decision. But even if that is approved, they still got to show the evidence. They just didn't show any evidence of it. They're asking you to rely on supposition that something that could be, and here's my comment, Judge, capable under some circumstances does not mean likely under these circumstances with no evidence. It's factual.
I made my ruling. I've given you a chance to build your record. Anything else, fellas?
No, thank you.
All right. AOI date is going to be May 14th, 9 a.m. Bond will be continued.
Judge, Mr. Gilman's tethered on.
He's on a tether?
Yes, he's not tethered and hasn't been allowed to return to his home for 5 months. And that's the thing is that he, you know, well, I don't know if Mr. Conlon.
He's right here.
I just want to address the bond conditions, you know.
Hold on a minute. Let's make sure we're all on the same page with Bond.
All right.
Way back in the fall, it looks like Judge Green set no entry within 5 miles of home. Mental health eval, curfew, 8 a.m. I think that's 8 a.m. to 9 p.m. Is that currently the bond, Mr. Prain?
Your Honor, I believe they removed the curfew. I wasn't here, but Mr. Gill can tell me that was you removed. He says.
I did that. That doesn't surprise me. I don't like curfews. So what's our current bond? Just the GPS tether?
Yeah, the issue we're concerned about, Your Honor, is the GPS tether in the 5 mile radius, because, you know, since November 17th, 20.
Right.
Hasn't been able to return home. And, you know, he did actually return home for a brief period of time, and if there was going to be an incident, it would have happened within that, I don't know if it was a week or so.
No, I didn't return home since 1 month or something.
Was there a mental health eval?
Gave it to you last hearing.
That people.
Oh, hold on a minute. Hold on a minute. All right, go ahead.
He did not return home, but there was no 5 mile radius or condition that would have kept him from his home. So if there was going to be an incident, he would have had an opportunity to do that. He has no intention of harming anybody. These people think, these people, I say a lot of people, you know, nobody really knows Mr. Gillikin. They can think what they want. He can walk around with a tinfoil hat on. It's America. The man owns a home. He works hard. He's earned a good living. He works in the technology field. He does not have any violent convictions. He had a pellet gun that was unloaded, and we maintain he did not point it at anybody, Your Honor. He's been kept out of his home while his little daughter passed away. And
I am so sorry, Mr. Gillick.
And this has turned his life upside down and destroyed his life over a bullshit case, excuse my language. But I would like for Mr. Gillikin to be able to go home where he lives. I mean, he bought that house
He's worked hard all his life. There's no reason away from his home. It is disgusting what's happened to him in this case, Judge. Thank you.
Any response from the people, Mr. Mohammed?
Judge, the reason that the conditions were put in place were due to the potential danger to the victims in this case. I was informed at some point during the last that he's been exhibiting extremely odd behavior, and it's suggested in the facts of the case that police learned. Additionally, there was an emergency order that was conducted at his home.
When was that?
It was an ERPO. They petitioned for it under the statute. Detective Harrison got it with no notice in the hearing to Mr. Gilligan. So he doesn't even have firearms if that's any concern because they got taken away too.
By voluntary. Yes, sir.
Judge, the officer in charge is just looking for him.
That's fine.
Because I believe it happened after, the case. If I recall.
It was the Monday before Thanksgiving that it was ordered. And it was fine. Day after this, so the 18th.
Yeah, so nothing since he's been on bond. There's been no allegations or anything.
Bond violations.
Okay, I don't need the date then, Ms. Dale. All right, anything else, gentlemen?
Just, we'd like the court to address his condition to be able to return home.
Yeah, I'm, anything else before I make a decision on the bond?
And it's that, those are the conditions. There's no likelihood, there's no reason for them under MCR 6.106. They're not reasonably met.
Judge, I believe you ordered the defendant to go through the pretrial services and the mental health evaluation. Or not you, but you reminded him at one of the.
I've got a mental health eval. It's in the file. There's a report in the file.
Case was, and I don't know if I've read that. Was there any treatment?
I don't think so. I'm looking for that right now. No. Suicidal ideation, no. Homicidal ideation, no. Violence risk level, low. At this time, there's no indication of a need for immediate psychiatric intervention beyond this ongoing outpatient treatment. You're doing that still? Yeah. All right. I'm dropping the bond conditions, GPS tether and or order to stay away from the house. Anything else?
Thank you.
Good luck downtown.
See the tires again.
9 a.m. on the 14th. I want both the attorneys here though.
How do I get it?
You get it, we'll get your paperwork. You got to go down where they put it on.
I get to go on it.
Yeah.
That's good.
Mr. Mohammed, don't go away. I want you and Mr. Prain up here.
Yeah, shut up.
I shut all this. Shut the TV off. I can start. Sounds good. Did a great job. He didn't back out this way. Keep showing off. Now I'm doing stuff. Stand up with Jesus.
I mean, shut up.
Awesome. But seriously.